Original side only.
Original side. One assigned matter.
Yes. Appellate set come back when we take up appellate set matters. Yes.
May I mention the last matter in my lord the list?
Yes.
One is extremely urgent matter. It was taken up by Justice Manthan on account of urgency, but in the midst of hearing, since he knew one of the parties, he's released the matter. It's been assigned to my lord. My lord, if it could come up as an application next week, but rather than coming up as a specially fixed matter.
Well, put it in the list next week as an application before the special.
The last matter, my lord.
Yes.
I'm
Follow.
This is my application for clarification.
But I'm taking a preliminary objection to the maintainability. Your Lordship will see the appeal has been disposed of. This is not a review. This is not a typographical error or clerical mistake. The prayers amount to a substantive change in the order.
I'll explain, my lord, what the
Whatever is the change, my lord.
We'll take into consideration that. Yes.
My lord, here your lordship will recall there was a award by which, my lord, there was family disputes were settled. It was not a partition of an HUF. The award goes by 4 schedules. There is schedule 1, which had all the properties, schedule 2 and 3, which goes to 2 respective sons, and 4th schedule, which remains with the HUF. Schedule 1 minus schedule 2 and 3 is schedule 4. The award goes only with regard to the allocation of schedule 2 and 3 to the 2 sons. On that basis, there's a family arrangement which was also made subsequently, my lord, after the award. The award is of 9 September 2010. The deed of family settlement was of 22nd September 2010. Award is of 9 September 2010, and the deed of family settlement is of 22nd September 2010.
Yes.
There are some conflicting clauses in the deed of family settlement, which has been observed by your lordship in another matter, which I'll come to later, my lord. Now, my lord, what happens is, my lord, the HUF, which remains, and schedule 4 property remains with HUF. This is one part of the matter. Now, my lord, in the award, for the award, there's an execution which is filed. At the execution stage, my lord, your lordship has finally passed this order where execution of a deed of family arrangement is done on the basis of the award. That only is on the basis of schedule 2 and 3 property. Schedule 4 is left out of it altogether. Schedule 4 does not come into play at all. When this deed of family arrangement was being discussed between the advocates, my lord, it was being exchanged. At that point of time, my lord, that's where the confusion comes. On 11th of February 2025, for the first time, my lord, the special officer who had been appointed to get the deed of family arrangement registered, he had circulated a format, a deed for a format. In that format, my lord, the HUF was referred to as since dissolved. The HUF. We immediately wrote back saying that since dissolved, there are 3 or 4 more corrections. So far as since dissolved, we deleted those since dissolved and wrote back to the special officer. That was objected to also by the respondent here. In the meantime, my lord, the special officer...
What was objected to? The since dissolved was objected.
Since dissolved was objected. Deletion of since dissolved was objected.
Deletion was objected.
Deletion was objected. Then, my lord, what happens is, my lord, on the basis of the deed which was circulated, that was also sent to the stamp collector for valuation. What would be the valuation? So, on the basis of that, since dissolved is only in relation to the HUF, which is the 4th schedule, so it really doesn't make any difference to the valuation. So, my lord, when it was circulated, it was given to the collector gave a valuation also. That valuation, we were acceptable. We had no problem with the valuation because the valuation only goes on the basis of the schedule 2 and schedule 3 property, which is the allocation to the 2 sons. My learned friend had an objection there saying that the schedule 4 should also be valued. With that regard, there was some dispute which was going on. Finally, it came to your lordship, and before your lordship, my lord, what has happened is, my lord, when your lordship will recall, at that a suit had been filed by my learned friend in the meantime, which encompassed all the properties and not just schedule 4 properties for partition. That suit has since been sought to be withdrawn, and there's a counterclaim also which is counterclaim whether it should be accepted, that is also pending in that suit. That's in Calcutta High Court. So in that, my lord, that was pending. So there was an order of injunction which had been passed at the instance of one of the defendants in that partition suit, because of which there was a delay before your lordship whether the execution should be allowed or not. That is when, my lord, after the order of injunction was lifted at our instance only, your lordship passed the instant order. If your lordship comes to the order now, page 191, 17th December 2025. Yes. We recorded in our order dated 19th November 2025 that the parties are ad idem the registration of the deed of family arrangement and assured the court that they would take steps for vacating modification of the impugned order. We had adjourned on such basis awaiting any order which may be passed by the learned single judge. The learned senior counsel appearing for the appellants hands over a server copy of the order of 15th December 2025 passed by the learned single judge in connection with the suit, wherein it is recorded that the interim order dated 21st August 2025 was modified to the extent that the order shall not stand in the way of implementing any order passed by the division bench in APOT 7 2024, on which this bench is now in season. Accordingly, learned senior counsel for the appellants also submits that a query was raised before the Registrar Assurances Kolkata, a copy of which is handed over to the court today. Hence, there cannot be any further impediment in registration of the deed of family arrangement. Accordingly, APOT 7 of 2024 along with GA 1 of 2024 are disposed of by directing the special officer appointed to take steps for registration of the deed of family arrangement in question, which has been circulated under cover of the letter of 29th April 2025. The parties shall equally share the registration charges, fees, stamp duties, so and so. Now, Mala, this is where the confusion has happened. 29th April 2025, what was circulated was the valuation on the basis of the deed which was not changed. So now, my lord, it is being insisted that since dissolved must remain, and they are taking advantage of this since dissolved in the deed which was circulated in February, even in the second suit which has been filed. Now, what has happened is a second suit was filed. Your lordship will remember in Alipur court by my learned client, where my client, where, my lord, he is claiming only partition of the Schedule 4 properties on the basis that the HUF is still in existence. Using the word that the since dissolved, an advantage is being taken that HUF is no longer there, so the rights have become definite. Well, in this connection, let me just place your lordship's order once, my lord, which has been passed in another partition suit, my lord. If your lordship just takes, my lord, that order, it's for your lordships only. At a copy, my lord, if your lordship comes straight to paragraph 43. Upon careful consideration of the arguments of parties and perusal of materials on record, it transpires that it is an undisputed position that the subject matter of the present partition suit instituted by the appellant, comprised of the fourth schedule of the arbitral award, is a joint property. The bone of contention is to the right of the respondent number one of the owners, to sell a portion of the property to the outsiders. The second friction point is the actual share of the respondent number one, at least at the prima facie level, in the suit property. Well, the plaintiff is me, the respondent is my learned friends. To consider the second aspect first, we are to look at the arbitral award as well as the family arrangement in conjunction. In clause 6C of the arbitral award, which was subsequently implemented through family arrangement, it was categorically mentioned that Ramdas Mahadev Prasad HUF shall continue to subsist with Bijoy Kumar Swaika as Karta and co-partner and Kusum Swaika as member thereof, save the property scheduled in save the properties stated in second schedule and third schedule thereunder written. All remaining properties of the HUF and control companies, concerns, and other assets fully described in the fourth schedule were to continue to be properties of the said HUF as before, with heritable and transferable estate absolutely forever. Rajiv and Sunil, as per the said clause, would not have any right, claim, or interest in the remaining properties described in the fourth schedule thereunder written. There is an apparent conflict between the recital of the subsequent family arrangement which followed and one of the clauses therein. Whereas in one of the paragraphs in the recital, it was recorded that each of Bijoy Kumar Swaika, Rajiv Swaika, Sunil Swaika, and Srimati Kusum Swaika, being the party of the first part and second part, third part, fourth part, were entitled to an undivided 1/4 share in the HUF, apparently signifying that on the demise of Bijay Kumar Swaika and Kusum Swaika, subsequently, Rajiv and Sunil would become entitled to 50% each in such property. In a subsequent clause F, it was reiterated that the award is not a partition and that the parties thereto have simply made an award to resolve the disputes and save the amity and dignity of the family. Simultaneously, it was stipulated that the properties mentioned in the fourth schedule thereunder written would be continued to be held by Ramdas Prasad HUF with Bijay Kumar Swaika as Karta and Koparsanar and Srimati Kusum Swaika as members thereof to the exclusion of any claim, right or interest of Rajiv and Sunil. Thus, at least an arguable question remains as to which of the clauses would prevail. In the first clause mentioned herein above, is to prevail, the properties upon the demise of Vijay and Kusum would devolve in moiety shares on Rajiv and Sunil, whereas if clause F is to prevail, the property would continue to remain as property of Ramdas Mahadev Prasad HUF, and upon the demise of the Karta and his wife, all coparceners would have undivided interest in the corpus thereof. If the second view is accepted, the daughters of Rajiv and Sunil respectively, who were coparceners as well, would also have shares in the property, thereby defeating the case made out by the respondent number 1 to the effect that the respondent number 1 is the exclusive owner of 50% share in the fourth schedule property. It is well settled that at the stage of consideration of an ex parte ad interim injunction press, the court is only to look at the case made out in the plaint and injunction. As such, proceedings from such perspective, it is the plaint case which is to be taken into consideration. Since the plaintiffs places reliance on clause F of the family arrangement, in effect by arguing that all properties to the present suit have become co-sharers to the property by dint of being coparceners in the HUF originally, at least an arguable and triable issue has been made out as to whether Sunil and Rajiv have got by devolution 50% share in each of the suit properties and whether their daughters and coparceners also have shares in the property. Thus, a prima facie case has been made out to the extent that the triable issues are to be decided in the suit. Well, next is goes on to the issue of law. So, so far as whether the HUF remains or not is an issue which is there, which is pending to be decided. Now this is something whether it is our contention HUF remains and the daughters are part of the HUF. It is their contention that upon the death of Vijay Kumar Swaika, the HUF has come to an end and it has dissolved. So, my lord, this issue is still which is at large, it has not yet been decided. Now, my lord, it has always been our contention, even in this deed, which is actually not subject matter of the deed also, my lord, because the deed is only restricted to Schedule 2 and 3 and the valuation thereof, which has been accepted by us. Schedule 4, which is the HUF, taking advantage of that since dissolved. Now, my lord, a contention is being raised. In fact, my lord, in this application, a written objection has been filed subsequently by the respondents where they are taking a contention that the HUF has dissolved. So there is no question of it going any further. So that all the clarification that I'm seeking, my lord, is that on that, if you're in the lordship's order, the 29th April, that should be only restricted, my lord, to Schedule 2 and 3. And so far as Schedule 4 HUF is concerned, that since dissolved should not be there. Or no rights should accrue because that since dissolved has been mentioned.
In the deed of family arrangement, which was circulated under cover of that letter, 29th April,
since dissolved is mentioned. That is the problem that has. Well, what has happened, as I was saying, well, if your lordship sees the sequence,
but this order was
February
virtually on consent.
My lord, your lordship, I was also not there, my lord, my learned friend. On that day, my lord, Mr. Chaudhary came right at the end, if your lordship remembers. And that day, my lord, the juniors were present at that time, my lord.
But even then, your juniors.
My lord, that letter was handed over in court at that point of time. Had it been, my lord, the deed of family arrangement, my lord, we would have shown, my lord, that since dissolved was not agreed upon.
Cannot reopen an order which has been passed on consent.
No, my lord, that's on the basis of that since
remember that it was
right
passed on consent.
They are seeking
no contention was raised at that point of
I agree, my lord. That is why we have come before in clarification. The problem is only with regard to that since dissolved. Rights, they are claiming that we have consented and now, my lord, there is no HUF at all, which we had objected to previously. My lord, if your lordship, that's why I was showing, my lord, the sequence of events. 11th of February, well, the learned special officer circulated this deed of settlement, deed of family arrangement between the lawyers. Immediately on 12th of February, we wrote back saying that the since dissolved should be removed. What happens
There can be
after that?
two scenarios. One is that an appeal. Appeal does not lie against a consent order. So you did the right thing in moving this court, but this court's the charter jurisdiction is limited to consider Mr. Mukherjee whether whatever has been recorded here actually transpired on that day. So whatever transpired on that day did happen, as reflected here.
I cannot
Because
deny
this
that,
was
but yes,
in your presence and there was no contention raised on this.
yes, my lord. My lord,
Unfortunately, your name was also given in
I
this.
was there. I was online that day. I remember, my lord. My Mr. G. Chaudhary came right at the end, my lord. He wanted, but the letter of 29th April was circulated earlier. In fact, my lord, when it was being discussed before the special officer
But
for
you cannot
finalization,
reopen a consent order. Cannot reopen a consent order because you say you have a dispute because your case is
my
not.
lord, the rights are they are claiming rights on the basis of that one word. I'll show your lordship. If your lordship just takes 1 minute, my lord, since I know, my lord, it's a task. If your lordship just takes, my lord, the deed of family settlement, which is an issue right now.
Yes.
My lord, if your lordship takes, my lord, page 82 once of the application.
You cannot interpret the document now. Since
Not an
it's all be
interpretation.
there or not there.
It is not an interpretation whatsoever. That letter which was, well, that letter was also handed over, and only the letter was handed over, which said that the
Yes.
valuation is correct. The valuation is correct. If your lordship
But we
sees,
did not. This court did not enter into that question at all regarding the deed
My lord,
because it was a consent order.
in case, my lord, if your lordship also makes an observations that, my lord, the family deed of arrangement is only in relation to schedule 2 and 3, the problem will be resolved. Now,
The
what
difficulty
is
is we
being
could have done that till that date, until and unless that order was recorded that it has been handed over and both of you were present and previously also talks of settlement were going on the basis of that we took that and directed, and that was also passed in open court, that deed of registration circulated with the April 20.
My lord,
Could have raised the point. You could have raised the
My lord,
point that
yes.
no, that deed was not actually given to us. It is being handed over now.
My lord,
If you said that, we wouldn't have. We had.
no, my
at
lord,
least
at that point it did not occur. Honestly, it did not occur. Now, my lord, if your lordship sees our conduct also,
But
that
Mr.
is why.
Mukherjee, conduct also we can't go too much because you knew that there was a dispute on that date. At least your client knew, both of you knew that there was a dispute regarding whether it's since dissolved will be there or not. But if that was pointed out and there was no consensus on that, you should have pointed out, at least give me a copy of the deed of arrangement before I agree to this. Because otherwise we would have adjudicated, we would not have recorded this order. But after recording post facto, it's a post facto recalling of an order saying that I did not give consent on that date, which we cannot do. You had given consent.
May I only show your lordship what we had circulated once? Your lordship will see that and see how our stance at every point of time. If your lordship just takes, my lord, that letter
Your
once,
stand even after this is that
it has
since
always been
dissolve
our
was
stand.
not there.
It was always been our
True,
stand.
but this order
is
is
on
not
the basis-
conclusive, obviously, and this records merely this has a value in as much as your submission was recorded and your stand was recorded, which is your stand even today, and even in the suit from which this arose.
If I may just take one moment,
That
I
is
know,
the
my lord,
consistent stand.
and I also different objection.
If I can, my lord, just show two earlier orders of.
So we'll come to you.
Great.
My lord, I told them copy. Already copy can down at one.
এটা কোন order?
No, no, it is. Well, this is the written objection which has since been filed in the subsequent suit after your lordship's order.
That is post facto. That is what we're saying, Mr. Mukherjee.
They are taking advantage of this. That is all.
They obviously take advantage of this.
Well,
Since
but
it's
then your lordship will see my prior conduct once, only for my satisfaction. After that, your lordship. Well, if your lordship takes, my lord, my letter, my lord, page 82, page 83 first, my lord, page 83, page 83. Lord, your lordship will find at the bottom of page 83 there is an email. At the bottom of page 83, there's an email of 11th February, which is being written by the special officer, Mr. D.N. Mitra, to us, my lord.
Yes.
Attached, please find the deed of family arrangement as settled by me. I am sharing the draft schedule from Mr. Rai and Company, which is attached, which is my lord there. I would request Ms. So-and-so to kindly check the same and let me know your views by 2 p.m. tomorrow. Thereafter, I propose to send the document to the Registrar of Assurance, Calcutta, for assessment of stamp duty and registration charges. I immediately write back on page 82 if your lordship takes. This refers to your email of 11th February enclosing the revised deed of family settlement. We have made minor changes in the draft deed of family arrangement which are in track mode. I have also once again added Aadhaar numbers of so and so. You are once again sending the schedule to the family arrangement which was sent to you. The revised deed and schedule are sent herewith may kindly be considered and forwarded to the registrar for ascertaining the market valuation and stamp duty as payable on the said deed as per one. Now, my lord, I have annexed the deed of family settlement, page 84 onwards. If your lordship comes straight to page 99, your lordship will find, my lord, the first clause which is set out there. So I just read on the fourth
Since
line.
result has been
Since
scored.
result has struck off. Again, my lord, if your lordship takes page 101, 101, clause E, recital E. Recital E.
Yes.
So struck off. Now, my lord, the family arrangement as it was without the since dissolved had been sent to the registrar of assurances for valuation. Valuation was only in respect of schedule 2 and 3 properties. Whether this remains or not is absolutely immaterial, because well, this concerns the schedule 4 property, the HUF. It absolutely is immaterial for the purpose of valuation. The valuation was done on, and that was sent on 29th April. Now, your lordship will see the 29th April. They had objected to it also.
Should have been a bit
I understand, my
more
lord.
cautious when the order was being
I
passed.
absolutely understand, my lord.
We
That is why
just
we
mentioned that we have some doubt as to what deed was.
We honestly, it is unfortunate we did not realize that.
That's why we also did not comment on that deed at all. And we said that which was circulated under cover of the letter, that letter. So if this was, and we had an inkling that there was some dispute on that. So we had at least recorded that and said that
it has
something
been,
we have said.
It has been our mistake. At that point of time, we did not realize.
But it's a very costly mistake.
I understand. That is why we before lordship.
It has merged into an order of the court. I mean, not merged into, but it has culminated in an order of the court.
And that is why
recording your consent. We cannot now. You have. We can't say you have grown wiser because you were wiser previously also because you had deleted. You can appreciate that.
Yes, my lord.
But ultimately, it boiled down to our recording that that the deed which was circulated under the cover of the letter.
On 29th April,
because we passed an order, this order was passed in open court. That much we remember.
Yes, my lord. No doubt about
we are saying that the under cover of the letter, you at least if you had a doubt that under cover of the letter what copy was circulated, and now you say that you knew that under cover of that letter with since dissolved was circulated.
We knew
that on that date.
We knew about that.
So you could have pointed out that that is not the deed of registration which you were agreeing to.
Well, we had. So what we had actually, well, it is unfortunate. What we had always
there was a communication gap.
Yes,
maybe we can appreciate your part. You are embarrassed. We can also appreciate that. But Mr. Mukherjee, we can't help it because now it will be recalling a consent order, which we can't do. My lord, subsequently, if something happens and we cannot. If consent orders are started being recalled on these grounds on post facto clarification applications, Mr. Okay, this is not a clarification. You were seeking a recall of that order, and then we had to say they have to say that you did not give consent on that day, which you clearly remember. There was, it was maybe might have been tacit. You did not say I do give consent, or I do thrice. Maybe you did not.
What I recall, they wanted to come back at that point of time, but it was. But I'm not getting into that.
As I told you, Mr. Mukherjee, we are very well appreciating the embarrassment. We can fully appreciate. We had practiced. I can fully appreciate that, but we can't help this scenario.
May your lordship will record a submission and
we have to. We have to. That vehemently we'll add vehemently. Vociferously sounds bad.
It is only.
Definitely do that so that if you can use that anywhere.
There's another issue. Another thing, even by consent, a legal position can't change.
This was not a legal position. This was not a legal position. You can agree to a HUF being dissolved.
No, my lord. That is the other thing, my lord. Section 171 of the Income Tax Act, my lord, provides that an HUF will continue to remain.
See, Mr. Mukherjee, we only said that deed, whatever is there, will be registered. That was the limited consent given by you.
Yes, my lord.
So whether it's registered or not, your legal argument on whether that registered document, insofar as that part is concerned, is debatable because it's contrary to law. That argument remains open to you. But if you want that to be recorded and that is the purpose, we have some doubt whether we should do that.
What has fallen from your lordship if that is recorded? that whether the
It has fallen unofficially, not
My lord,
solemnly.
if it has fallen from your lordship, it is official.
No, 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 Mr. Mukherjee, because
My lord, if that
very
point,
well,
only that.
let us hear Mr. Shen on that.
My lord, I'm not.
That is the most
Well,
we can
So
think
far as
about
the
doing.
29th April, it has gone as our mistake. There's no doubt about it. It's as your lordship, I could not have placed it better. It's an embarrassment. from
It's
us.
undoubtedly,
Yes,
it's
it's an
undoubtedly is.
embarrassment.
Let us hear Mr. Shen. Mr. Shen, tell us this.
Yes.
We'll look into whatever you're saying. We're not shutting you out. I mean, one thing that even if a registered deed is there, if that is a clause is contrary to law, that
But
argument
they
will
will
be made
argue.
by
They will argue that no one can stop.
The recording doesn't.
Effect of a registered deed.
while today, while recording Mr. Mukherjee's arguments, we can turn down that argument on the ground that first of all, consent order cannot be recalled. On that ground, we are refusing. Secondly, if he wants to make this argument, it is open to him to make the
But
argument.
that liberty need not be
No,
given.
we are not giving a liberty.
That is fine.
That is a ground of refusal.
Very
That we are refusing because that
Because-
cannot be taken at this stage.
Yes.
That can in any event be taken.
So suppose there is a registered deed.
Yes.
I interpret a particular clause of a registered deed in the way the law wants it to be interpreted.
They are
I
entitled
will
to interpret their canvas their interpretation before any court.
Yes, but I just want to
But
again
we
but-
won't couch it in a liberty language.
liberty language.
No, we won't say liberty.
But
In
very
any
well.
event, they can. We can say.
Everybody, even if that word, Lordship's word of liberty is not there, it is their right. They can argue whatever they want.
No, we
But
say that only. Say that.
I would just only want to say, my lord, one academic thing. My lord, they have filed a partition suit.
Yes.
Now, my lord, once the partition suit is filed, there is a disruption. They say that because the family HUF does not exist, shares have to be apportioned and appropriated towards the parties
Oh,
in
the
this.
premise of the family settlement is also that, but we had recorded in this order, which was cited by Mr. Mukherjee, that was one of the points, but the daughters also get. Yes.
Let the,
That was on the
no,
so
no.
that is also one of the
So, my lord, if the daughters
premises
get,
of the partition.
my lord, even if the daughters get, if according to them, daughters are part of that HUF.
That was specifically argued by
Yes,
them in
yes,
connection
yes.
with that suit only.
So once a partition suit they have filed, they themselves admit the severance of the status already.
May not be regarding fourth schedule. May not be regarding fourth schedule.
No, no, fourth schedule property is the subject matter only. Only subject matter is fourth
No, but
schedule.
partition suit is filed only when they say it's joint.
It is joined, but they want a division.
We won't interpret the language of the plaintiff at this
Very well,
stage.
let us
Cannot.
not, but I just want to say only one thing, my lord.
Know what is the exact, I mean, what are the nuances of that pleadings there, or the underlying refrain of that.
Very well, but one cannot content together in a deed which I am executing post partition suit that HUF is existing. Deed is going to be registered post the partition suit which I have filed. I cannot contend in the deed
Yes.
after I have filed a partition suit
Yes.
that HUF exists. That will be contrary to their stand in the partition suit.
We won't go into that.
Very well. But there are two earlier orders.
Then we have to go into other things also. We have to
No,
interpret
no,
the
no.
plaintiff.
I will not invite your
Invite us to
lordship
do
to
that. That would be contrary to your whatever said.
Yes,
And we
but
should not go into this at all.
19th November and 12th November. These also records consent.
It was consistent. I mean, it was
Yes,
going
it
on for
was
some time.
consistent. And one
We are on the verge of getting fed up when you say agree to it.
fine,
We are going to adjudicate. If you did not agree on that date, we
in
don't-
fact, my client
did not
was
put
the
pressure on
person
you, but yes.
who was raising the dispute as to stamp duty. That is why, my lord, before the earlier division bench, I take it on myself, my client, that appeal could not be disposed of. Your lordship will find so many times Justice Tandon's bench had to adjourn the matter, even after special officer was appointed, just because there was a dispute only.
That was happening before us also. So that's why we
Ultimately, I
were
came and
bent upon
submitted.
adjudicating it when at that point of time this consent came.
Yes, well, and paragraph 13, your lordship will see they have communicated on December 2025 of the petition. On 26 December 2025, Lord Special Officer again communicated a draft deed of family arrangement, intimated the family advocates for both. There were some blanks which required to be filled up. Then on 30th December, advocate for the applicant communicated copies of the first 5 pages of the draft deed with blanks filled in. So there also was again, they
Since Dec-
accepted.
So 26 December is since dissolved.
26 December had that since dissolved.
After this.
After 26 December, paragraph 14 on 30th December, they have filled up the first 5 pages.
Mr. Shin, one difficulty only because in principle both of you agreed, but neither the 12th November nor the 19th November order records ties up the deed with the covering letter.
But that was.
That does not. That does not.
So, if even in one of these orders it was recorded that they have given consent to the deed of family settlement, which was accompanying the covering letter dated such and such April 29th, then we could say that there was a clear-cut consent. They could not resign. But that is not recorded. They were agreeable, but that although that I mean,
That was already in
was not pointed out.
circulation. That
We thought
26.
that was sorted out. Everything was sorted out. We did not even know
Exactly.
if
Even I did not also point out 26 because 26th April, after that, all these orders are being passed. Then, Malad, kindly see para 14, 30th December,
yes,
they are responding to the draft of 26 December sent by the special officer.
At page
At
269.
page 8, kindly see page 8 of the petition.
At page 269 since dissolved.
After April, whatever has happened, then in paragraph 13, on 26 December, special officer again communicated draft deed of family arrangement, intimated family advocates that there were some blanks which were required to be filled in by the parties.
So 29 April.
Then on
let us see that in that letter they did not point out about this.
No.
then on 30th December,
Then when was this
15th of January, we pointed out for the first time. 15th of January.
26?
Yes, my lord. 15th of January 2026. After. No, we've mentioned everything in our application.
The 29th. So 19 December.
That was after even our order.
Yes, my lord.
Then
that is the problem.
Well, this was
this
absolutely,
scored through deed was sent after our order.
yes, my lord. That it was absolutely missed out at that point of time.
You have made many mistakes. Your client has made mistakes, and not we are not putting it on you.
Well, lord, but immediately after the 15th of January,
Yes.
your lordship
After
sees
30
page,
days,
that is page 384. There we have said, 15th of January we mentioned for the first time.
That was also after our order.
After your lordship's order.
Whatever happened was after that order. So you agree and then go and dispute, score through and all this.
Well, if your lordship just take me.
No. 17 December. Prior to 17 December, did you send any draft deed
My lord,
with
if
the that word scored through?
copy that date.
After the order, but we have referred that why we have made that change of since dissolved.
My lord, if your lordship takes page 484, this is 21st January.
26. This is.
21st January 2026. My lord, if your lordship just sees
484.
Yes, 480.
484. Fourth volume, my lord.
Put for him to down. Oh, sorry.
484.
Yes.
21st January 2026. This refers to our email of 16 January received from Ryan Company by our email of 12th February 2025. That's the first where we had, since dissolved, we had removed. We had enclosed the draft family arrangement with our suggested edits, and a copy of the email along with the said draft is enclosed here for reference. We had in pages number 16 and 18 deleted the word
7th
since dissolved. Our client has all along disputed this claim of Sunil Spiker. By your letter of 29th April, you had forwarded us a query sheet along with the draft deed of arrangement. In reply to the same, we had stated that we had no objection to the value mentioned in the query sheet. It appears that you overlooked the edits in the draft deed under the cover of 12th February, since dissolved has crept into the draft deed of family and circulated by you. This was inadvertent and the error was not from our side.
After 12th February, so many things happened.
My lord,
after 12th February, there was so
yes,
many
my lord, those things have
communications
happened. My lord. There's no doubt, my lord, that after that we had missed it. There is no
also.
doubt.
Forgotten about that.
We had, well, because we had circulated, we had mentioned it. After that, and we were only the dispute after that became only with regard to the valuation. I was saying that the valuation is right because schedule 2 and 3 was valued. My learned friend was saying schedule 4 also ought to have been valued. And the valuation stamp duty ought to have been assessed on the valuation of schedule 1, 2 and 3, schedule 2, 3 and 4, all properties. That was the dispute which was there after that. Dispute as to since dissolved was not there at all. It is only when the registration was actually going to happen, my lord, when the after your lordship's order that this issue has again crept up, my lord. It wasn't there before. The issue was only with regard to the valuation. I was saying Schedule 2.3 is fine, which had been done. And my learned friend was saying that Schedule 4 should also have been included. The dispute, if your lordship recall before your lordship, was my learned friend continued to say Schedule 4 also ought to have been part of the valuation for stamp duty assessment, which your lordship did not agree to right at the end, my lord. And the consent was with regard to Schedule 2 and 3 valuation. And this was something, my lord, it was a long deed. It was missed out. As your lordship said, it was an embarrassment only at the time of the formal registration after your lordship's order that this was again noticed that the
Schedule
change
4 was
which we had
never dealt
suggested,
with in that family deed of family arrangement. Schedule 4 was not dealt with even.
it was never dealt
That's
with.
why
That's why
it was not. It was immaterial for the
it was
purpose of-
immaterial. Even now it is immaterial because Schedule 4 is not part of the valuation. It is just that those words are there. It's a I would say it's an honest mistake and embarrassing. It's embarrassing on our part. It has always been our stand that the HUF has continued to remain. And legally also, my lord, till such time there is a full partition of the properties of the HUF. The HUF continues to remain. That is Section 171 of the Income Tax Act. It continues, and your lordship knows HUF is primarily for the purpose of taxation. It's a Hindu law concept, but it is primarily for the concept of taxation. Section 20F, various provisions of the income tax, culminating into Section 171, which says only upon full partition. There is also concepts of partial partition in.
We will not go into
I'm
that.
not going into that. That's to
We'll
do
say that
something
you have
different.
argued that, but that will
Yes, my lord. I leave it to your
we'll
lordship.
do
my
whatever we said actually. Please take it. The present application is for clarification of an order dated December 17, 2025, passed in connection with GA1, GA/1 of 2024, arising out of APOT 7 of 2024 in EC 494 of 2019. Pushed up by the said order, comma, in presence of learned counsel for both parties, comma, the court had proceeded on the premise that there was a consensus between the parties and recorded that the APOT and the GA were disposed of by directing the special officer SO capital within bracket who had already been appointed to take immediate steps for registration তারপর double inverted মধ্যে করে of the deed of family arrangement in question, comma, which has been circulated under cover of the letter dated April 29, 2025, double inverted close, full stop. The parties were to share equally the registration charges, comma, fees and stamp duties for the purpose of such registration. For sub next para, learned counsel for the petitioner submits, comma, by placing reliance on communications between the parties, comma, primarily through email, comma, that there was a minor dispute still subsisting as to whether the expression since dissolved, double inverted close, comma, qualifying the qualifying the HUF to which the parties belonged, comma, as suggested in the draft of the present respondents within bracket appellants therein, comma, would remain in the draft deed for the purpose of registration or not. For sub next para, learned counsel for the petitioner submits that a specific objection was taken by the present petitioners to the said expression, double inverted, since dissolved, double inverted, remaining in the draft deed. Full stop. Next para, learned counsel places before the court an order dated February 17, 2026, passed by this bench in connection with FMAT 55 of 2026, comma, an appeal arising out of injunction order passed in a partition suit pending at the behest of the petitioners, comma, that this court had categorically recorded therein the stand of the present petitioners to the effect that the HUF had not been dissolved as yet. Full stop. Next para. Learned counsel also relies on certain emails between the parties, comma, in particular, an email dated February 11, 2025, sent at the behest of the present petitioners to the special officer.
12th February. 11th February is sent by the special officer. Page
sorry,
81.
sorry.
Page 82 is my lord.
Yes, you're right. Thank
83 and
you.
82.
Right. Uh, 20 say at the behest of Secretary, sent by the special officer to both parties, wherewith a draft schedule was shared by the learned special officer, comma, requesting the law firm representing the present respondents to check the same and to let the special officer know their views by 2 p.m. the next day. Full stop. As per the said email, comma, thereafter, comma, the learned special officer proposed to send the document to the Registrar of Assurances, Calcutta, for assessment of stamp duty and registration charges. Full stop. Next para. On December 2.
No, no, that should be February 12th. It's the other way, American way.
Oh, this is
I
so
don't
the
know
other
why
one
they've done
also
it.
should, yes, fair. Right.
But December 2 will actually help me because it's
On February 12, 2025, comma, in reply to the uh, special officer's email dated February 11, 2025, comma, the present petitioners wrote to the special officer that they had made minor changes in the said draft deed of family arrangement, which are in track mode. Full stop. Next para. Learned counsel also places reliance on a subsequent email dated January 21, 2026, where the present petitioners, comma, in an email of event date, comma, referred to the email dated February 12, 2025, where the draft family arrangement had allegedly been enclosed, comma, with the suggested edits, with the edits suggested by the present petitioners. Full stop. Next para. Thus, comma, learned counsel submits that it was the consistent stand of the present petitioners that the words double inverted since dissolved double inverted close, comma, qualifying the HUF, comma, should be deleted from the deed of family arrangement which was to be presented for registration. So next para. However, comma, unfortunately, comma, on December 17, 2025, comma, when the order under uh, clarification was passed, comma, the present petitioners could not the point out to the court that the deed of family arrangement which accompanied the covering letter dated April 29, 2025, comma, sent to the registrar for the purpose of assessment of stamp duty and registration charges, comma, was the unedited copy of the deed of family arrangement, comma, to which the present petitioners did not agree in principle insofar as the words since dissolved were concerned. Full stop. Next para. Even otherwise, comma, learned counsel for the petitioners submits that Any agreement contrary to law cannot stand the scrutiny of judicial review, comma, in particular, since the clause whereby the HUF was indicated to have been deleted is contrary to section 171 of the Income Tax Act, comma, which envisages that unless there is a partition by metes and bounds, comma, an HUF does not stand dissolved. Full stop, next para. Learned senior counsel appearing for the uh, respondents hearing within bracket appellants in APOT 7 of 2024, comma, submits that the order of which clarification is sought was passed on consent of both parties and in presence of counsel for the parties. Full stop, as such, comma, the application for clarification is not maintainable at all in law. Full stop, moreover, comma, it is pointed out that the matter had been disposed of on the basis of such consent, and the same cannot be reopened afresh post facto. Full stop, next para. Learned senior
It is not a clarification, it is a substantive modification.
Very well. Learned senior counsel further submits that in the garb of a clarification application, comma, the present application seeks a substantive modification going to the roots of the order dated December 17, 2025. Whose of next para, learned senior counsel also places before the court server copies of two orders, comma, respectively dated November 12 and November 19, 2025, passed in APOT 7 of 2024, wherein it was clearly recorded by the court that the learned senior counsel appearing for the appellants had submitted that the parties had agreed in principle to the terms of settlement, and the matter hinged only on the prayer for a direction to be passed by the court for registration of the terms of settlement agreed to between the parties through the special officer. Full stop. It was further recorded in the earlier order dated November 12, 2025, that the court had granted an adjournment in order to enable learned senior counsel appearing for the respondents to take instructions on such submission of the appellants therein. Full stop. Next para. In the order dated November 19, 2025, comma, the court clearly recorded that learned senior counsel appearing for the appellants had submitted that since the parties were ad idem as to the registration and stamping of the document in question, comma, the appeal itself may be disposed of by directing such registration to be made by the special officer appointed for such purpose. Full stop. To the above submission, comma, learned counsel appearing for the respondent within bracket present petitioners, bracket closed, submitted that there was no difficulty on the part of the respondent in acceding to the above proposal. Full stop. However, comma, since the partition suit was pending, comma, where an injunction order was subsisting then, comma, the order was required to be modified for the purpose of going ahead with the registration. Full stop. Next para. Accordingly, the matter was further adjourned. Full stop. Next para. Thus, comma, it is submitted that all along, comma, there was agreement between the parties as to the deed in question being registered. Full stop. Next para. Learned senior counsel further submits that at this subsequent juncture, comma, the order recording consent cannot be recalled merely for the asking. So furthermore, comma, it is contended that the legal submissions on the validity and legality of the deed sought to be advanced by the respondents can are available to them and can be canvassed by them if otherwise available in law, and this is not the forum where such contentions can be decided. Full stop. Next para. Upon a careful consideration of the submissions of the parties, comma, we find that there cannot be any doubt as to the order dated December 17, 2025 having been passed on consent of the parties. Full stop. Next para. From the consistent stand of the parties, comma, in particular as reflected in the order dated November 19, 2025, comma, both sides submitted that there was no difficulty uh, that they agreed to the deed deed of family arrangement being registered. Full stop. Next para. Hence, comma, there is no scope of recall of the said order merely since there was some uh, erroneous perception on the part of the respondents allegedly as to the contents of the said deed of family arrangement which was directed to be registered. Push up. Next para. We fully appreciate that there might have been some embarrassment on the part of the uh, of of the respondent and or their uh, present petitioners and or their counsel, inasmuch as they that inasmuch as, comma, in their perception, comma, the deed of family arrangement which they agreed to be registered was not the one which was circulated under cover of the letter dated April 29, 2025. Whose of next para, however, comma, such post facto wisdom of the present petitioners cannot be a ground for recalling an order which was passed specifically on consent of both parties. Full stop. Next para. In the event the respondents had even an inkling of doubt as to the contents of the deed of family settlement which had been circulated under cover of the letter dated April 29, 2025 and was directed to be registered, comma, it was open for the present petitioners to point out before this court even on December 17, 2025 when the order in question was being passed. Full stop. We distinctly remember that the said order was passed in open court and in presence of counsel for the parties. Full stop. Next para. Thus, comma, this court is of the opinion that whatever might be the stand of the present petitioners in any other litigation, comma, including the partition suit indicated above, comma, the same cannot be a justification for recalling the order dated December 17, 2025. Full stop. Next para. As rightly pointed out by learned senior counsel for the uh, respondents hearing within bracket appellants in APOT 7 of 2024, comma, the legal argument sought to be made on the purported validity of the deed of family settlement, comma, which was directed to be registered by the order dated December 17, 2025, comma, can very well be canvassed by the present petitioners before any competent forum stroke court if they are otherwise entitled to in law. Full stop. Next para. In view of the above observations, comma, uh, we are not inclined to uh, modify and or make any further observation on the order dated December 17, 2025. Accordingly, GA2 of 2026 is dismissed on contest without any orders to costs, comma, in the light of the above observations.
The only thing your lordship has said recalled, and sir, I have not asked for recalling, only modification. Or
But did we said that you have asked for recall?
No, my lord. Prayer is for modification.
So we
or
have said
clarification.
for recall.
Yes, my lord. Your lordship is recalling. You not asked for recall of this order.
কোথাও যদি রিকল থাকে তাহলে সেটা একটু
That's all.
same cannot be a justification for recalling the order dated December 17.
Clarification. Clarifying.
recalling the order dated in the garb of clarification. In the garb of clarification.
Only one submission. Last part of your lordship's order, let that be your lordship's order, not my sub.
Recorded.
No, that is in response to your lordship's query. Yes, that is always open. No, that is in observation of a court. I
Made
cannot,
that argument, Mr. Shen.
that is not an argument.
No, we have said that if they are otherwise entitled to,
Of course, well, that is there, but that not be a part of the submission.
that would be proper.
But I cannot, that will amount to some sort of a concession.
No,
That is on a point of
No.
law.
and we exactly recorded what happened in court. you had, and not only that, you have added that, and this is not the, you have argued that
Yes.
if they want to canvass that point, then they may argue if otherwise entered in law before the appropriate forum, and this is not the proper forum to make such arguments. That is your
But
submission.
that is in response to your lordship's query, my lord. This is not necessary for this application.
What query?
That this
They have argued that.
this
If you
law-
left that untouched, then we would not say that. They have argued that.
clause in the deed, my lord, they will argue, my lord. That is
No.
no one can
Whatever you have
question that.
recorded is there. Yes.
May it please.
Yes,
tell-
Mr. Bose.
What is point number 1?
My lord, I was on the question of passing off. If you remember, because I finished infringement and this gold flake and that gold stag. Yes. Just I'll get my note out.
Please. Yes.
Oh, that thing. এই খাতা নিয়ে চলছি। আর লাগবে না। Yes. Now, my lord, I had pointed out a case, two cases, my lord, on clause 14. It says, I said, I mean, the very fact that learned judge gave a show cause said that the learned judge also knew that for passing off is an independent cause of action. There are certain ingredients. I do not have jurisdiction. And I pointed out judgment of single judge, Hindustan HUL, my lord, versus 3 leaves, Justice Tandon's judgment, saying, my lord, leave, only after leave is granted, only after leave
Yes.
is granted,
Yes.
my lord, the court assumes jurisdiction. There is a passage you and it went up on appeal before Justice Indira bench, Justice presided by Justice Indira Banerjee, and the whole suit was withdrawn. My lord, I have made these submissions. I will not, just reminding your lordship. Now I am on the second. I was on the second aspect of the matter, my lord, that I took, my lord, section 62 and 134, the bull by the horn, and said, my lord, that when a party, I mean, these are like, for example, my lord, and very well brought out in Sanjay Dalia's case, my lord, like section 62, really it became, if you see the preamble to section 62, how it was introduced, my lord, you see, a poor artist has a copy, his author. This is really to protect the poor my lord, author of copyright, that my lord, he and someone infringes, my lord, somewhere in, my lord, I mean, and he's based here. A poor person cannot be allowed to run, my lord, all the way to that place where he does not create, my lord, have a place of business. My lord, this aspect is not available to these multinational big companies. So if you are carrying on business also at that place, and that person is reciting, that follows from section 20, and my lord, it's been, and Justice Badar Ahmed's division bench judgment, which is quoting Sanjay Dalia. So then you don't have an option. Then you must file it there, that you have a place of business and that the defendant is only there, you have to do it there. My lord, that is the submission which I had made. My lord, one aspect of the matter, I'll place Sanjay Dalia's case. I did not. I said it's already quoted. So just allow me. I'll just take 5 minutes to place the judgment. My lord, yes, I'll. My lord, in the compilation, oh, my lord, it's in the second volume. It's at running page 258. In fact, the previous one is Justice Badr Ahmed's judgment, division bench, of course, and Justice, I think, yes, Justice Sazdev, division bench. Now, my lord, 258, running page, if you are there, my lord.
Yes.
Now, my lord, now you see what has happened here, my lord. This was on interpretation of section 62 first and section 134(2). My lord, but the discussion, if you find, is on 62 basically. My lord, it says the plaintiff has to prevent infringement without obtaining a license. The defendant owns cinema halls in Maharashtra and Mumbai where infringement is alleged. An entire cause of action has arisen in Mumbai, Maharashtra. Now, my lord,
Which paragraph?
my lord, paragraph 2, page 268 of the judgment. My lord, just because I will place it, my lord, in our, what has happened in our case.
Yes.
My lord, I am now attacking the infringement bit. My lord, also not passing off generally. Sorry, I should have pointed it first, but since it's related to the passing off, I'm pointing out. Now, my lord, now, so infringement has arisen in Bombay. So why should Delhi High Court, my lord, have jurisdiction? My lord, that is the point in issue. Now, my lord, paragraph 3, if you see, civil suit was filed in the High Court at Delhi by virtue of fact that branch office of plaintiff is situated in Delhi and plaintiff is carrying on business in Delhi. My lord, it's possible because the 134 and 60 says so. However, it is not disputed that plaintiff's head office is situated in Mumbai. I'm stopping here for a moment, my lord. It's nobody's case. You just click the internet, my lord, that ITC does not have. You just, I mean, it's in the public domain. You just click, and one of the best selling offices is in Punjab. In Punjab. So, so this point I'm arguing, and I should tell you, lordship, frankly, did you argue all this? Not there, but whatever it is, it's not there. But it's a question, my lord, of fundamental of law. And I'm taking this point, and if your lordship says, my lord, frankly speaking, I have checked the vacating application closely. I've said the reply. Now, what I don't know, whether there was an opposition to the injunction application, which I couldn't find in the paper book. And desperately, I was asking my advocate record, at least give me the papers. It's not in the paper book, so it doesn't lie whether the vacating was treated as opposition. That also I don't know. My lord, whatever papers, it's not there. But I must tell you, my lord, just in case you said you argued this, but it's not there. So I'm making with you whatever, my lord. But let me complete this argument, my lord. So it is not disputed that the plaintiff's head office is situated in Mumbai. The objection, but what is there in the pleading? I showed you that the plaintiff through its agent in Punjab, my lord, that paragraph opposition, my lord, I wanted that. So I don't know. So my lord, of course, the fault is my clients because papers are not with me. Yeah, I mean, well, so I just wanted to tell your lordship this. So the objection was raised by the defendant with regard to the territorial. So here, this point is, it is not disputed. The single judge has upheld the objection and held that suit should have been filed in the court at Mumbai, my lord, because it is not disputed. Now, my lord, please have a look, my lord. It's just a brief discussion, exactly what I was telling you, the object of section 62. Please come to para 5. My lord, it was submitted by learned senior counsel for the appellant. Special right has been conferred under section 62 and 134. My lord, and in the middle of that paragraph, convenience of defendant is not a relevant consideration. Have you found that in the middle of that very paragraph? Convenience of defendant is not a relevant consideration. This was the argument. Now, my lord, on behalf of the, my lord, interpreting section 62, intention of parliament. My lord, this is what I am on. Intention of parliament is to be gathered from plain and natural meaning. Now, my lord, kindly see on the other hand, on behalf of respondents, it is submitted that abuse of provisions of section 62 and 134 cannot be permitted at the hands of multinational to harass the defendants. At the hands, my lord, only multinational, because the object of section 62 is to protect a poor author. My lord, the side. When you come to multinational, the concept is totally different. Now, my lord, with respect to the suit filed, section is not carrying on business, cannot be defined subjectively. Object of parliament behind enacting and section 34 has to be taken into account while interpreting the mischief rule of Hayden has been pressed into service so as to prevent harassment, my lord, of the defendants and abuse of the said provisions. This is what, my lord, I want to say. Court is duty bound to avoid disproportionate counter mischief while interpreting the provision. Public policy and convenience has to be taken. Interpretation must be made so as to hardship and absurdity. Purposive interpretation, my lord. Now, my lord, para 9, my lord. Well, I can go on, but it's the same thing, my lord, if you want, my lord, I can. So I can, if you see para, I can only indicate the paragraphs, and as long as I have conveyed to your lordship what I said, I'm sure your lordship would. I mean, so, my lord, para 9 you can look at, my lord. Now, then the entire parliamentary debate on copyright, my lord, para 13. My lord, the debate, my lord, I still have the parliamentary debates. My father lived. I don't know nowadays, no one, all these constitution, my lord, framing of this side debates, everything is there. I've never looked at it. But previously, when this was rich and everyone interpreting constitution, because this is where it all began. In this court, people used to refer to all these. Now there's no challenge to ultravirus, nothing. So these are probably white ants have started eating also. White ants also have started eating. I don't know. Now, my lord, so one of the points, my lord, it is desirable also because it may act as deterrent on the infringer when he knows that he may have to go few hundreds of miles to where the author lives, where the book got published first. These were debates going on inside. Now, para 14, my lord, you can have a look. I'll not waste your lordship time. Now you can look, my lord, at para 17, 18, 20, and main is 24. I'm just reading 24. If interpretation suggested by the appellants is accepted, several mischiefs may result. Intention is that plaintiff would not go to far-flung places than that of the residence where he carries on business works in order to deprive defendant a remedy and harass him by dragging him to a distant place. It is settled proposition law that the interpretation of provisions has to be such as which prevents mischief. The said principle was explained in Hayden's case. According to the mischief rule, 4 points are required to be taken into consideration. While interpreting a statute, the problem of mischief, that statute was designed to remedy should first be identified, and then a construction that suppresses the problem and advance should be adopted. It's when a purposive interpretation is all. Sorry. Yes, I indicated. Para 18. My lord,
18 we have
yes.
noted. Yes.
Don't finish. Now, my lord, I'm just yes, and my lord, of course, my favorite book, Para 34, is there. G.P. Singh. Now, my lord, it goes on, my lord, Lordship. So now, my lord, now I come.
So what was the ultimate interpretation of
No, of course, that
that
does
paragraph
not
that
have
we know?
sustained.
Yes.
The order was sustained.
Yes.
And, my lord, last paragraph, the Delhi High Court lawyers,
646.
my lord, they came, my lord, everyone said, since your lordship
Yes.
is there, I mean,
Para 50 is that Delhi High Court lawyer, and para
Yes,
46 is the
yes, that we are the best, our judges are the best, and we are the best. Yes, para 50. That they only have expertise, my lord. No, my lord,
Okay.
no, my lord, now, my lord, yes. Now, my lord, we come to back to passing off. I went to, my lord, it's actually not passing off. It deals with both infringement and passing off. My lord, the Pernod case. Pernod case was, my lord, Seagram, as you know, my lord, whiskey, Blender's Pride, and this no, Blender's Pride and the other whiskey, the blue. No, my lord, there were two brands. Though they took the infringement mark was London Pride. Now, my lord, the two bottles, Blender's Pride, they took the Blender's Pride and took another drink, my lord, of Seagram. It's called blue, my lord, the color was blue.
My learned friend knows nothing about cheap whiskies. He's never had it.
I haven't not had any whiskey. He knows I don't have whiskey.
Even if you had it, you wouldn't know that it was whiskey. If you hadn't have it.
No. That I know. Well, they all say this is good, this is high. So little bit, just this little, I taste. Some are sweet, and I find this is good.
Sweet
Because-
whiskey.
Yes, quite, because I have a sweet tooth. I mean, unless it's sweet. No, sweet wine. Dry on all these things I cannot take. Manad, what can I do, Manad? How can people have it also, I don't know. Imperial Blue. The two Seagram whiskies was Imperial Blue and Blender's Pride. And London Pride took the pride from
From the blenders.
blenders and made it blue from the the other, what's the name you said? Imperial Blue. Yes. So now I can, so the questions were twofold. Now, my lord, you can't have a trademark over pride, just pride. You did not have any separate registration over pride. You can, I mean, if some people have over pride. Suppose you had, you can't dissect. You have registration over Blender's Pride. That is the interpretation of section 17.1 and 17.2, which I will not refer to right now because in the section, the judgment, it's that section is quoted. So the first point is on the infringement bit. Clearly held here, my lord, remember disclaimer on gold, my lord. So, my lord, you don't have a separate registration for gold. You have to take gold stag and gold flake. Like, for example, same thing happened. Blender Pride and London Pride. You can't dissect. There is no separate registration. Therefore, you can't, you have to read it as a whole. You can't dissect. Anti-dissection dissection rule. That's called 17.1 and 17.2 of the Trademark Act. My lord, you can do. This is with regard to the other fundamental question is relating to passing off. Why, my lord? Who is the average customer? My lord, please remember, cigarettes cannot be advertised. I will show you I've shown you, I think, it cannot be advertised. Now, my lord, then there is the interesting things happen. When do you judge? When does the average customer judge that it is being passed off, if at all, my lord? Is it at the time of sale or is it post sale? Then you go back and say, hey, what did I have? Whiskey, my lord said, this is not a blender, so whether that will have an effect. My lord, so these points, my lord, I think are quite germane in our case also, whereas more or less here also whiskey you can't, my lord, sort of advertise. Yes. So, my lord, may I, with your lordship's leave, just show the judgment in the. So, my lord, 138.
You are citing Bernard,
Yes, my lord.
401.
No, my lord. Please mark it from 138 because that I marked. This is the SCC one. 138. I find, my lord, twice it has been given.
Acha. Very good. We scored this through them.
Unless your lordship has already marked, because I have marked SCC one.
No, definitely that will be more convenient.
Yes.
Very good.
My lord, I have marked some portions. It may be helpful. It's a big judgment. And all this history and how I trademark, my lord, all these things are obviously given, my lord. And, my lord, if you straight away come to 142, running page, that is the running page of the judgment.
142 is fine.
Is, no, I have to tell them, my lord.
Acha.
Yes.
Page 5 of only.
Yes, it is, my lord, para 7, continuation of para 7, last portion. Next page.
Para 8 has started there. In the
Oh, sorry.
Yes.
Yes.
So para
Mala, I'm sorry.
Para
It's para 8. Now, my lord, sorry, I'm excused.
This is correct.
According to the appellants, they are engaged in the manufacture and distribution of wines, liquors, and spirits. They sell whiskey under the brand names Blender's Pride and Imperial Blue, both of which are registered trademarks. The appellants also hold the registered trademark for Seagram's. So, my lord, as I told your lordship, it's Blender's Pride and Imperial Blue. Now, my lord, in 9, para 9, last, the trademark Blender's Pride was coined and adopted by the appellant's predecessor and has been in extensive worldwide use since 1970 whiskey. Then 10, in 1995, Blender's Pride whiskey was launched in India, and para 11 will tell you in May 2019, the appellants became aware that the respondent has been marketing whiskey under Mark London Pride using packaging, which is now trademark, which was deceptively similar to that of the appellants. The mark adapted was not only phonetically and visually similar to Blender, but also copied the color combination get up trade dress of Imperial Blue label. So, my lord, it is a combination, my lord, of both. Imperial Blue label, they have copied the blue part, and then, my lord, the Blender's Pride, as I was. Now, my lord, so para 12, aggrieved by the appellants instituted seeking a decree for permanent injunction from trademark infringement, passing off, and copyright violation. Now, by order dated such and such, 20, commercial dismissed the interim injunction challenging the same. Appellants approached the High Court, filing, which was also dismissed in the appeal. So two rounds, my lord, dismissed. 14.3, my lord. The imitation of two established brands, Blenders Pride and Imperial Blythe, is neither coincidental. My lord, this is part of the submission of the appellant. My lord. And it is deliberate, dishonest attempt to misappropriate the appellant's goodwill and reputation. And my lord, in 14.4, the last portion, it is written, appellant erroneously dissected the mark Blender Pride and compared Blenders and London, ignoring the distinct and dominant component Pride. My lord, this is absolutely in our case, my lord. So you have to take into account gold. My lord. Ignoring the distinctive dominant component Pride. Now, my lord, in the present case, my lord, para 14.6, first line. In the present case, composite London Pride is deceptively similar to registered wordmark Blenders Pride. They are used for identical goods. My lord, 14.8. Appellate court, my lord, these are submissions on behalf of the appellants, placed undue emphasis on dissimilarity with the words Imperial Blue and London Pride, while overlooking visual similarities in color combination, layout, etc., of the registered. My lord, this would possibly be the argument of their argument, and I am just therefore, my lord, noting the paragraphs. My lord. Then 14.9, appellate court erred in applying 15.1, 17.2 of trademark, despite not claiming exclusive right per se, but only of composite mark Blenders Pride. My lord, directly what I was telling, my lord, section 17.2. Now, my lord, straight away, please come to para 15. The submissions, para 15. My lord, in the middle, accordingly, respondent claims exclusive right over the mark London Pride, including its distinctive elements and goodwill attached thereto. It was further contended that the respondent is entirely dissimilar in name for any appellant's registered mark. Then 15.1, learned senior further contended label by the appellants for their products under Imperial Blue and the label of the respondent sold under are entirely distinct. Now, my lord, 15.2 in the middle, the goods in both cases are sold in sealed boxes. My lord, this is important. In sealed boxes, not loose, and the boxes themselves are visually distinct. The color scheme, typography, logos are markedly
different.
Markedly different. Yes. I never heard markedly.
Markedly, wickedly, variously.
Markedly. Anyway, my lord, different. Now, these were the submissions. In my case, remember, my lord, 85% is that ghastly image of these thing, and which is mandatory. Yes. Even color combination is mandatory, that part, and then this little bit is there. So, issues for consideration. My lord, para 16 onwards is important. I'll only read the relevant because his whole history is being given. Para 17. Question that arises in the present appeal is whether appellants are entitled to grant interim injunction from using impugned trademark get-up trade dress, including packaging of London, on the ground that such amounts infringement and imitation of registered blenders is such and such. My lord, then all sections are there. I will only draw your lordship's attention to running page 151 to section where the section 117 is mentioned. Only I will draw your lordship's attention to that portion. I have placed many of the sections while I was.
This is section para
Mala, it's not a para, it's not, if you, in the compile, it's Mala, the whole sections are
Yes,
set
it's
out.
quoted.
I am, the
So you are
section
placing 17.
17,
Right.
Mala, yes. Because instead of, just.
Going to the
Yes.
151.
Yes. Effect of registration of parts of a mark. And it says, when a trademark consists of several matters, its registration shall confer on the proprietor exclusive to the use of the trademark taken as a whole. So it must be considered as a, no, this section is not possible. Now, my lord, notwithstanding anything contained, when a trademark contains any part which is not the subject matter of separate application by the proprietor, my lord, then I am skipping B. The registration thereof shall not confer any exclusive forming only part of the whole of the trademark so registered. Absolutely, my lord, clear. If you disclaim, then, my lord, you have to do it. My lord, this is the section how I now tell you how it has been interpreted. My lord. I argued this when I was, my lord, part of it, my lord, when I cited some judgments like, what was, I think Sulachana Bai.
But there is a qualitative assessment also involved, Mr. Bose. Why you are saying this? Suppose blender's pride. Now, I don't use the entire thing.
Hmm.
I just say, I intentionally make a spelling mistake and make it blender's pride without the E.
My lord,
That's a part. But you
blenders.
have to
Now you're talking about print.
Part means linguistically part.
Linguistically, my lord, because gold, pride, you don't have a separate registration. That is what, my lord, that is, may I?
Here it's very clear.
My lord,
Gold.
that's, I think, neither here. Let me.
Right.
So let's, my lord, see what how it has been interpreted.
Yes.
This, because I found this is more or less similar. My lord, the pride aspect and the gold aspect. Pride is not gold, although people may think, gold, owning gold is pride. My lord,
The magicians also have, there's a very good movie on that.
make it go. Oh,
Right.
wow.
Yes. Yes.
Lovely, lovely. My lord, 18.4. My lord, para 18.4. Section 17. Section
15.
Section 17 clarifies that exclusive rights are granted over the mark as
This is para 18.
oh,
Which para 18?
18.4 minute.
18.4 is something else.
Yes, I am reading from the third line after your lordship's
Oh, I see.
return.
We'll start from there. We'll just come back. Yes, please.
Yes. Now, my lord, we were on 18.4.
Section 17.
Yes. Section 17 clarifies exclusive rights are granted over the mark as a whole, while subsection ensures that generic or non-distinctive elements within a composite mark are not monopolized individually. Now, my lord, straight away, please come to 18.8 basically provides comprehensive statutory for protecting registered trademark while also preserving right of prior users through passing off. So, my lord, straight away, now we are discussing, I think, all these judgments, same judgments going on and on. My lord, I will come, my lord.
The judgments.
Oh, yes, my lord, all the same judgments going on and on. And para 22.
Yes.
Analysis. Now, after quoting, my lord, all these things.
Nowadays, most judgments are dismissed. It's very irritating.
No,
Very
no,
irritating.
my-
Why should you quote the entire thing? I mean,
The-
and next one,
basically wants
we
to
shall
know
quote
what
these
you have to
judgments,
what you have
including the quotations. and
what
it will
very
become bigger, large,
yes.
very.
My lord, may I digress for a minute because this reminds me of what your lordship.
Few
I mean, when I was abroad, my director of studies he once told me, what happens to your Supreme Court judgments? Previous your Privy Council was 2-page, 3-page. Now it goes on and on, and I didn't know a thing because I did not study any law. So I said, what he's talking about, I don't know. I never knew also Privy Council. So he says, it's just going on. Then when I came back, then I realized, I mean, this. We talk about landmark judgments and landmark. This is landmark, everything. Justice Ajaynath Rai. Once I used it, what did you say? He knew me. So he said, what do you say? Landmark. Don't use that word.
Mr. Sudhish Pai, he writes books.
Oh,
He used a very fine expression. There are landmark judgments and landslide judgments. So it's so well appreciated. And there are landslide. And he mentioned one or two landslide judgments also. So
no, he's very knowledgeable. Very knowledgeable. Very knowledgeable.
and he has very high regards of Calcutta High Court. Not
My lord,
not
everyone has
representing-
Justice Rohington Nariman. I mean, when it was a very a Bombay High Court judgment and a Delhi High Court, I will not follow Bombay. I will follow Calcutta. Probably. No.
Yes.
Always.
Was certain.
What's Calcutta? Oh, Calcutta. Calcutta. I know. My lord, not everyone in Bombay. The others, my lord, there was this.
Yes.
Are you aware of the tussle which used to happen, my lord, the Bombay High Court passing when law was developing in our after, my lord, it was always a tussle between Bombay and Calcutta. Went up to Supreme Court, Supreme Court invariably would follow Bombay. They told to me by late Mr. Pratap Chatterjee, always. But Mr. Rohington Nariman had very high regard. Para 22.
Yes.
Upon a comparison of the rival marks, the commercial court found that the only common element was the word pride, and that no other similarity was discernible. The packaging, style, bottle shape, and logos of the two brands were found to be entirely different. The court also examined whether a consumer of the appellant's product Blender's Pride would likely be deceived by the respondent's product London Pride, and concluded that pride is a commonly used word in ordinary parlance, over which no exclusivity could be claimed. The bottles of the respective products were found to be clearly distinguishable, since the appellants had not claimed a shape trademark, and the bottles were generally adhered to standard forms, no similarity could be drawn in that regard. And 2 lines down, no imitation capable of misleading consumers was found in the respondent's product. Now, when at para 23, where the average person is being, High Court, upon consideration of the material on record, concurred with the finding of Commercial Court and held that the respondent's use of the word pride was unlikely to mislead or confuse a consumer of average intelligence. Products such as those in question are generally identified and purchased by their complete names. You go and you ask for a gold flake, complete names, or more commonly by their first words. In the appellant's trademark, the first word is blenders. Here, of course, it's gold. So you to now do with flake and stag, if there is any comparison between flake and stag.
Flake in our student days used to mean Will's Flake. There was a Will's
Yes,
Flake brand.
yes,
also.
yes.
So,
I know. Well,
Flake meant Will's Flake,
yes.
not gold flake.
Yes, white and blue are.
Thank you, Mr. Vasu. We are not inclined to hear
No, no,
your comments on these things.
Oh,
you very
sorry,
much.
that was capstan.
Yes, yes, we know.
Yeah.
There must be some
No,
faux pas and
No, no,
please let us.
no.
Not your opinion on the product.
Will flake ta konta
On the law, yes, you are a master, but
konta guli? No, no one knows better than me. My father used to smoke 75 cigarettes a day. And that caused.
so that much.
I used to see all this. I used to go with him, besides Flurries, all these, they used to sell these smuggled cigarettes, Rothmans, Benson Hedges 555, and all these things. I used to go, and all money which used to earn used to go, and my mother used to shout. I remember.
Right. Yes. So, yes.
Now, my lord, now in the middle, in the appellant's trademark, the first word is blenders, where the respondent's mark, it is London. There is absolutely no similarity between the two. The court further held, pride is a generic, commonly used and laudatory expression. It concluded that the dominant part of the appellant's mark is blenders. A comparison between Imperial Blue and London Pride was found to be wholly irrelevant, as the marks are entirely different. Accordingly, there could be no likelihood of confusion, no deception in the mind of a reasonable consumer. Court also noted what pride is publicly juris common to the trade cited existence of 48 other trademark containing pride in class 32, 33. My lord, we have there is also some we have disclosed.
Gold.
There's gold, my lord, many golds are there. They are noted by learned.
Yes, we noticed that.
Yes. 24. The High Court further observed that competing trademarks related to premium, very important. Premium, one is page 95 rupees, another is 50 rupees. Premium or ultra premium whiskey, and the consumers of SAR can reasonably be presumed to be literate and possess sufficient intelligence to distinguish Bender's Imperial Blue and London Pride. My lord, class of consumer, important.
That may not apply in your case.
My lord, 95 when you are buying 95 and 50 rupees, that's the price difference noted in the plaint itself, noted.
So then you have to tie up class with money.
Class with money, that average, the person who's a regular cigarette.
Money people.
No. A regular cigarette smoker, that's the class I'm talking. Now, regular cigarette smoker will go and ask for a gold flake. No, I can't. You can't defame my client. He's saying bidis are 20 and mine is 50. So a little above. I mean, he wants me to say that.
Bidis are 20 rupees.
He's saying.
No. Cannot.
Intermediate customers between BDs and
Anyway, whatever.
বলছে কি আমি কি করে জানি স্যার বিড়ি খাবো
I mean, cigarette smoking is not, I mean, anyway, very well, yes.
now blenders pride even consumers of average intelligence with imperfect recollection would be able to differentiate between the rival brands. The High Court affirmed the commercial finding there is no deceptive similarity in the respondent and that could constitute imitation of the appellant's trademark. The High Court found no infirmity in the conclusions. Then 25.1. It is further contended comparison should have been conducted from the standpoint view of an average consumer with imperfect recollection. My lord, please remember, these cigarettes are sold in packets, not sold loose. It can't be. Whether you do it illegally, that's another thing. I have no idea. A holistic comparison of the products reveals essential features such as bottle shape, label structure, distinctive color of dark blue, light blue, and gold are deceptively similar and likely to cause confusion. However, commercial erroneously presumed that the purchasers of premium are discerning and likely to be misled. It is also submitted. Well, this is the submission, of course, not the finding.
Yes, yes.
It is also that are dishonestly attempted essential features of the trademark. Then, my lord, the two bottles, like in our case, my lord, comparison is made. One significant, you must remember, that is a roundel device.
Yes, yes.
It is mentioned there. There is no roundel device in ours. That is why, please remember that. And so here also in the plaint, as also in the order, this chart is there. Not that, and roundel device is specifically mentioned in theirs. It's absent in our case. Now, in para 28, it says the appellant in there have highlighted the overall similarities of the marks. Milord, I is the color combination used in the label and packaging consists dark blue, light blue, golden, and white. The names of the brands are Imperial versus London Pride. In both cases are written in white against a blue background, which are identically shaped dome. My lord, it's mentioned here. So in 28.1, in particular with respect to label and logo, made the following deceptive similarities. My lord, color combination of dark blue, light blue, and gold is used in both labels and packaging. Textual content in both logos is rendered in white. Outer packaging, thick borders, etc., with background. Then, my lord, the test of passing off.
Who would confuse between Imperial Blue and London Pride?
Obviously, my lord, Sigram taking it to
Such a
Supreme
long
Court.
judgment was necessary.
Supreme Court, my lord, it was all the way to Supreme Court with so many judgments. Now the
Yes, you have
my lord,
chosen the right judge.
my lord, now my lord 29.2. Now my lord 29.2, para 29.2.
29-2.
While an intent to deceive is not a necessary element, passing off requires proof of a likelihood or confusion of deception. Passing off. This is the difference.
Yes.
Now, no need of proof is required in this infringement. But passing off, you must give proof that this is some misled. Where would you give the proof? In Milord, where they are being misled in Punjab, that is, my lord, one of the reasons why I say it should always have jurisdiction where the defendant is there. Now, my lord, kindly see straight away to 31.7.
Purposive interpretation of a territorial jurisdiction clause is very risky sometimes, sir.
Of course, it is.
Depends entirely on the
My lord, if it hadn't been for the judgment, I probably would have faced some
very
difficulty.
risky, very risky.
No, I'm saying
consequences.
Consequences.
In your perception,
Of course,
it will be.
my lord, and therefore you have to go to statutory.
I may love multinationals, so
Yeah.
I'll say that.
Yes.
Why
yes.
should
My lord,
you distinguish
the
between them? and
man, I can only
poor
put a judgment, my lord, which which I've got. then rest is your lordship's. One day, who
No, we
knows?
cannot.
eh,
We have to. We are
No, no,
bound by
that
the.
is why, one day it may be set aside. So,
No, but there is a
but,
point.
but of
The
course, there is
logic
a
is very
point.
strong.
Of course, there is a point. And I'm saying this. And why should I not, my lord, when I
Logic is
have
very
this-
strong, Mr.
Uh,
Bose,
yeah.
but
My lord,
the
as a
consequences,
matter,
the
your lordship,
ramifications
my
might
lord,
be.
your lordships are free to intervene any judgment. If you don't like a judgment, there are ways and means
Yes, there
with little intelligence how to
Yes, yes,
get rid of such judgments.
We are
Now-
becoming experts in both sides.
No, everyone, my lord. Sir, 31.7.
Yes,
Sir,
31.7.
My lord, what I say necessary is not always correct. After all, we are subject to what your lordship decides. Yeah,
That is also not.
no, misleading is bad, definitely.
Will.
My lord, but your lordship
It's a
ultimately.
part of the our job also to find out whether it is.
That famous story of Mr. Pratap Chatterjee used to say about justice.
Which famous?
Shombik Das. Justice Shombik Das. Yes.
Even if Mr. Banerjee knows, he'll not say.
No, he doesn't know. He told me 1950s, in 1950s, a judge of High Court. So someone was, going to saying a lot of things about him with the Look Council. My English may be dull bhat English, but what I say is the law.
Yes.
1950.
Unless set aside or until set aside.
Of course.
Why
we used to-
because there are so many curative and 5 judgments last year, inclusive judgments.
Previously, we used
Justice
to only
now be-
study AI manual and know what the law is and this case is there. Now you press anything. Is murder a crime? Is not a crime? You'll get a judgment.
Definitely you'll get under Hindu Succession Act. Murder may be, not a crime.
So, my lord,
But preponderance of probability will apply.
some case, someone
Irrespective of
argues.
conviction.
Some
In case of section 21 or 19, I forgot, Hindu Succession Act. You are disqualified if you are.
So that judgment
Preponderance of probability
that
for that.
is some court it is
Murder may not be a crime.
press and you will now to AI has come. SCC, they are selling 15,000 rupees AI. Now all the previously when you used to press AI, all wrong judgments and things used to come. Now SCC is giving with AI all the relevant judgments. 15,000 for upgradation. No,
Very
with SCC AI, the judgments are coming now.
AI can't be trusted.
Very risky till now.
SCC,
AI people are saying that.
my lord, I know that is so normal. SCC AI has come out.
সেটা তো শোনেন
SCC is not so sacrosanct.
Yes,
SCC,
AI to AI.
The
SCC
judgment
is SCC. AI is AI.
Judgment. Color
Yes.
combinations are a specific combination color may be, my lord, 31.7 may be prima facie registrable depending on its manner of presentation. For example, colors used with a defined geometric shape may qualify for registration. Where colors are applied to packaging or labels, the burden of proving acquired distinct is higher. In such cases, the proprietor must show that the color scheme functions as a badge of origin. Now, Mirad, you have seen, now you apply this principle. In our case, even the color doesn't match. 13 minute when I talk about artistic in copyright, I'll make further submissions. Now, Millard, 31.9 in the middle, by contrast, the respondents mark London Pride uses the term pride in a distinctive commercial context overall presentation. The term pride using common laudatory cannot be claimed exclusive in isolation. Although both parties trade dress, color, feature elements of blue, gold, such similarities are insufficient to establish deceptive similarity. Placement of elements, design of labels, font style, in material respect, not a roundel device. Color, not same. Then This is the rule of anti-dissection, which I mean, not, again, we are going back not to, although it is related to passing off also, I just not, a foundational principle of trademark is must be compared as a whole and not by dissecting them into individual components. This is known as the anti-dissection rule, which reflects the real world manner in which consumers perceive trademarks based on their overall impression encompassing appearance, sound structure, and commercial impression. Then, my lord, little down, last few lines of that paragraph, court expressly cautioned against isolating individual parts of composite marks. Such an approach disregard how consumers actually experience and recall trademarks, while Section 17 restricts exclusive to the trademark as a whole and does not confer protection over individual distinctive marks per se. Courts may still identify dominant or essential feature within a composite mark to assess likelihood of confusion. I am also saying this. Now, my lord, however, this does not permit treating such features in isolation. Rather, they must be evaluated in the context of overall commercial impression created by the mark. 32.3. Consequently, in disputes involving composite marks, the mere presence of a shared or generic in both marks does not by itself justify a finding of deceptive similarity. Deceptive similarity. Courts must undertake holistic comparison examining visual, phonetic, structural, and conceptual elements to assess whether the overall impression created by the rival marks is likely to mislead an average consumer of ordinary intelligence and imperfect memory. If the marks viewed in totality convey distinct identities, the use of common elements, particularly if it is descriptive or laudatory. Then, Miller, next paragraph, 32.4 in the middle. When viewed in its entirety, Appellant's mark, Blender's Pride, Imperial Seagram are structurally, phonetically, and visually distinct from respondent's mark, London Pride. Mere presence of word pride, which is generic lauded, does not render competing word in the absence of resemblance. In no case of infringement or passing is made of. You dissect gold. So now it becomes a comparison, stag or flake. That's not the case, my lord, here. It's gold flake or gold stag. Now, dominant feature test. In determining whether a mark is deceptively similar to another, courts often consider the dominant feature, that is, element which is most distinct, memorable, and likely to influence consumer perception. While the anti-dissection rule requires marks to be compared in their entirety, courts may still place emphasis on certain prominent or distinguishing features, especially where such features significantly contribute to the overall commercial impression of the mark. My lord, 33.2. An analogy that aptly illustrates the significance of a dominant element in a mark is that mixing of milk and water. Mixing milk and water. If small quantity of milk is added to half glass of water, the mixture becomes cloudy. The change is perceptible, but the dominant character remains watery. Conversely, if the same amount of water is added to half glass of milk, the result still appears to be milk. The dilution is imperceptible. Though the components are the same, perceptual impact differs depending on which element dominates. Similarly, in trademark analysis, presence of common elements across the mark does not automatically lead to likelihood of confusion. What matters is the relative prominence and distinctive of element, just as the milk in the second example visually and quality overwhelms the water, a dominant feature in the mark can subsume other components, the shape, consumer perception. Therefore, while assessing deceptivity, due weight must be given to the dominant element without disregarding the composite nature. My dominant element is gold. Now, Miller 33.3. In the middle, the dominant element functions as the hook that captures the consumer's attention and facilitates brand recall. For instance, in composites such as Blender's Pride or Imperial Blue, the term Blender's Imperial may be regarded as dominant owing to their distinctive frequently. In contrast, elements such as price are relatively generic, commonplace in the liquor industry. Now, Millard, in Gold Flake, you have their entire case runs that I have acquired my right over gold. That's how their case is built. You can see the paragraphs, Millard, you will find out, which has been negated. And for good reasons. Now, Millard, kindly. So once that is gone, what do you have to compare? Now, Millard, however, Millard, just Millard, next page before 34. However, from a holistic comparison, the overall commercial impression in London is substantially different from the color scheme, etc., convinced. Millard, then the next heading is important. No exclusive right over common or distinctive terms. Millard, may I just read this? This is important. 34. It is well established principle of trademark that generic, particularly those commonly used in given, cannot be monopolized by any proprietor, even where such terms even if such terms form part of a registered trademark, protection does not exist to those elements per se, unless it is affirmatively shown they have acquired secondary meaning, that the term has be exclusive and distinctly associated with plaintiff's product. This is what they have pleaded in the case. The big case, Millard, which happened and the wrong judgment came about, red ever ready. I monopolized red. You can't. And a wrong case has been decided, which is still going around, Millard, of this by this court, with great respect, Millard, if I may cite, if you have had the occasion to see that judgment, red ever ready. Millard, monopolize the red, you monopolize. Later on, courts wanted to dilute, but because it's a division bench, presided over Justice Nijjar. I mean, red. Now, so I have monopoly. Now, everyone, the other case, I was there. Now I have been shunted out in from the appeal court. This Exide. Someone wanted another red. So says I have a monopoly of red. So you can, no one can do another red. Whatever. So I don't want to, because it's sub judice before now Supreme Court, big things. Another bench, appeal. So that's anyway, I lost. So the injunction was granted.
No, red ever is in appeal.
No, this is Exide and Amaron.
Amaron.
তুই ছিলি হ্যাঁ না অনিন্দা মিত্র অনিন্দা মিত্র আর মৌসুমী হ্যাঁ ও yes হ্যাঁ yes now Millard yes anyway Millard 34 point Millard, did I read yes 34 is well established trademark monopolize one power wherever forms part of registered protection does not extend to these elements effectively shown they have acquired secondary meaning. Millard, yes, 34.1. In Godfrey Phillips, this court univocally held that descriptive or denoting character are not capable of exclusive appropriation, they have acquired distinctive, prolonged, continuous, and exclusive use. 34 point ওটা cross appeal একটা বলেছে না এটা? Yes, now they have filed a cross appeal challenging that finding. Therefore, I am reading it. So I won't again address cross appeal. So I'm reading this just in to say the word pride is a laudatory and commonly used English term typically employed to suggest notions of excellence, heritage, and national identity. Within the alcoholic beverages industry, it is extensively used as part of various trademarks. Judicial notice may be multiple registrations under class 33, such as McDowell Pride, High Pride, Royal Pride, Pride, all incorporating pride. May not we have given examples also, many goals. There is widespread usage illustrates the word publicity juris not inherently distinctly, therefore incapable appropriation in the absence of compelling evidence, secondary meaning. The appellant's blender is a composite trademark composing of suggestive blenders. Now, may not please come to 34.4, where Cadila, in Cadila Healthcare, this care reaffirmed the deceptive must be assessed holistically, taking into account such as nature of marks, class of purchasers, mode of purchase, and overall circumstances surrounding the trade. Now, my lord, then we come to the heading average consumer test and imperfect recollection. This heading. My lord, please come straight away to 35.5. The foundational test of assessing distinctly similar remains in pianist test laid down in Pianist Company Limited application by Justice Parker. Indian courts continue to apply this holistic standard, which requires consideration of the visual and phonetic similarity of the marks, the nature of the marks, the class of consumer, all surrounding circumstances. Justice Parker framed the test as follows. May I read it, Milord? You must take the two words. You must judge them both by their look and by their sound. Gold flake, gold stag. You must consider the goods in which they are applied. Cigarettes, which cannot be advertised. The nature and kind of consumer who would likely to buy the goods, rupees 50, rupees 95. And the smoker, an addict, smoker of a particular brand. And all surrounding circumstances. No advertisements. You must first consider what is likely to happen if each of these trademarks is used in a normal way for the respective goods. If considering all these circumstances, you come to the conclusion there will be confusion, not necessarily that one trader will be passed off as another. Then, Milord, please come to 35.7. Applying these principles, it is evident that rival are not deceptive. Similar appellant's trademark, such and such, convey distinct commercial impressions. When compared to respondent London, the overall visual, phonetic, trade dress, though sharing some generic elements, such as use blue and gold, are sufficiently different, the structural, conceptual dissimilarities, etc., etc. তোর জন্য রেখে দিয়েছি কিছু। My lord, paragraph 37.
Yes, 37.
My lord, earlier this is of course the history that they were unsuccessful in regarding use of word against United Spirits in the Delhi High Court. And my lord, what happened? It was held that the Punjab by Appellate Commercial dismissed the appeal. Then, my lord, there's big thing about estoppel, which I will, because disclaimer, remember, my lord, I had said, my lord, what is the effect of such? I will give you a series of judgments as the paragraphs I will indicate. Now, কি জানো কথাটার নাম?
Prosecution history estoppel.
Prosecution history estoppel. Basically, cannot approbate in a trademark if you have not come with clean hands you are not entitled to any order.
So in previous litigation, if you take a particular stand, you
Yes.
cannot deviate from
In
that.
any forum, not
Any forum.
litigation, any forum you are taking a different stand, duty to say this. Cannot claim exclusive in a gold established by virtue of a suit.
All right.
Claimed gold only.
সে তো বলেছি তো,
Right,
disclaim.
বলেছি, gold is an essential feature.
Well, they had disclaimed gold. Now entire plaint proceeds on the basis is an essential feature.
এখানেও pride was highly commended.
সেটাই তো বলছি, এটাই তো তাই। I will give the cases, just read
Don't give
portals.
too many cases, one or two landmark or landslide, whatever you choose.
My lord, I will leave it. Now, my lord, the following, no landmark. It's all more or less
Slide.
division bench, Delhi High Court and all this. No, not landmark. My lord, landmark is only appropriate, reprobate. Supreme Court, 1,000 cases, appropriate, reprobate.
Issue went up to Supreme.
He's saying went up to Supreme Court dismissed it. That's what he wants to say. I'll give you one line order of Supreme Court also. তুই ছাড় না বাপু। Now, my lord, para 24, estoppel. The admissions made by the appellant plaintiff before the registry, especially when the appellant is claiming the right at the time of registration, my lord, is important and will debar the appellant plaintiff from any relief if not disclosed in the plaint, amounts to material concealment. The reply of the plaintiff at the time of registration, etc., or rather claimed right over blenders is an important factor. The relevant portion of the plaintiff's reply in their admission is reproduced below. We submit that the subject matter is an unique combination. Blender, which is a combination in isolation, has no relevance whatsoever with the goods. This is, we submit, it is a well-known principle, have to be compared in entirety. This is their quoting. And then right at the end, when compared as a whole, McDowell price phonetically, visually, structurally dissimilar. You disclose all this if you have disclaimed something in any forum. And you are claiming gold. And learned judge has accepted portion of it. It may be relying on some judgment which has been overruled. I just indicate.
Gold is usually one side is flake and one side is.
Yes, yes. If you remove gold, I've told that. Then you find stag and flake. Now, my lord, in a little below, the bone of content, last line, bone of content revolves primarily between two marks, Blenders Pride on one hand, owned by Appellant, and Royal Challengers American Pride, a trademark duly registered by the respondents on the RN loggerheads. In the light of express provisions whereby trademark of part has been infringed, it is requirement as per law that part of the trademark has to be registered separately. Admittedly, in the present case, I was holder of registered trademark Blenders Pride collectively. Therefore, entire thrust of the argument and the case built upon there is infringement is only the basis of common word pride. And this is, they know about this. And therefore, in the plaint, it proceeds gold. My lord, you can see I've referred one day, you saying why you're reading the paragraphs. Therefore, my lord,
Consistently done.
yes, at the
Section 17 also.
বলে দিচ্ছি, তুই তো আসিস নি, সব দেখিয়ে দিচ্ছি 70। At the outset, in the absence of any registration of the word pride, independently and separately, this entitles appellant to any stay qua the same. Further, the act and conduct also demonstrate they themselves have forgotten and have never objected to the use word separately. Then para 39, it is too far stretch at the behest of the appellant that use of the word there could be any misconception or dilution in the mind of common man on the street who is the ultimate consumer, which would lead to any confusion. The said parameter having not been made, appellant has failed to demonstrate Now he is facing any irreparable loss which would be compensated in terms of money. That is different, my lord. Then you straight away please come to my lord, para 40, just above para 40, post-sale confusion doctrine. My lord, an important aspect, new aspect. Post, when, my lord, recent evolution of trademark jurisprudence in the UK post-sale confusion doctrine, which I told your lordship. This is something new, maybe, than the ordinary one.
The word doctrine, it becomes a new concept.
Doctrine, no, post-sale. Post-sale. When? At the what time?
After sales
After
doctrine.
you go by, then you say, "Ee, what am I smoking?" Then you realize.
Don't be so graphic on that.
Okay, what am I drinking? This is not the same, because a good whiskey drinker will immediately know what he is drinking. Like when I were at parties, I used to get bootlegger from, and Mr. Ranjan Bacha will say, "No, go to this bootlegger. This is not tasting this Lafroy or whatever that is." Then I don't know. So well, I know. Well, I don't know the trusted bootleggers. That I know. No.
You're making bootleggers sound like drug peddler.
No, nowadays,
Different classes.
no. Previously,
to
now
understand
you get in Spencer and all these things. When I'm talking of when junior days, there were all these things were not available. You had to trust a bootlegger, and they used to all smugglers. They used to come. Post-sale confusion, developing doctrine. The notion of post-sale confusion, though well recognized in jurisdiction like United States and now the UK, is still relatively novel with Indian trademark law. তুই ওটা কি বললি এখন নতুন ইন্ট্রোডিউস কি করেছে ওই
Prosecution history estoppel.
না
Something else has also come.
লেবেল কি লেবেল মার্ক ওই যেটা আর্গুই করছিস ওইটাই হ্যাঁ there is some
Sound mark.
And sound mark. Now they have
Sound
introduced
mark is
sound marks and
interesting.
tape tray, like bottle design. So these concepts. Suppose
On fragrance also, it was being submitted on the last.
Trademark was there.
99.
Tape was there.
Shape of the good. It was not there in the 58 Act. It has been introduced for the first time.
Yes.
we usually so next post-sale confusion, developing doctrine. The notion of post-sale confusion, though well recognized in jurisdiction like the United States and now the UK, is relatively new novel within the Indian trademark law. It refers to the confusion that occurs not at the time of purchase, but rather after the product has been bought and is seen in use by others. The form of confusion can arise, for example, when a consumer knowingly purchases counterfeit goods such as imitation Rolex watches or knockoff Adidas. May not often happening, right? Knockoff may not. Then 40.3. The underlying harm in post-sale confusion lies in deceptive appearance of legitimacy, which can impair the distinctiveness and perceived exclusivity of the genuine product. This is especially relevant in sectors like fashion, perfumes, luxury goods. না আরেকটা আছে genuine luxury automobiles, food products, etc. Then 40.4. However, in the present case, goods in question are not intended or for public display.
Rolex is for public display.
No, my lord, it's no ban on advertisement.
No, that is a separate paragraph. 49.
That is for, it is more clarified in later paragraph. My lord, then 40.5, even though doctrine of post is inapplicable to the facts of the present, certain paragraph judgment of UK Supreme Court, which I will not point out, if it is inapplicable. It is
Yes, exactly.
Yeah.
It's inapplicable. Why?
Yes.
Court
My lord, straight
10
to-
pages. And
to 41, summary of findings.
thank
This
you
is
very
more
much.
important.
Yes.
my lord, we have come almost to the end. Uh, what to do, my lord? So many things, doctrines are there. I have to read them.
Only doctrines, yes,
And
right.
quite new Supreme Court. Now, my lord, and we'll stay at least for 3, 4, or 5 years. Now, my lord,
We are getting circulations every other day.
no, okay, I'll keep.
No, circulations. The judgments are circulated. Those are not reported. Circulated to every judge of every high court. Some of the judgments which are passed in court are being circulated to judges for their knowledge of law. Direction is the registries to circulate among all the judges. of the
Oh,
high
that
court.
I've seen, yes. Oh,
You know that.
In the High Court as well as from the
no, no, from the
From
direction
the
it is
Supreme Court.
given.
From the Supreme Court, a particular bench, all judgments, every other day we are getting circulation judgments. All the
Like-
High Court judges are being circulated,
Like, for
judgments which are
example,
not reported otherwise, but
So, sir, certain judgments have it written at the.
no, no, they have, you're right. They have it written at the bottom that for circulation.
No, it comes to.
no, no,
Malad is
not
saying
that
it comes to-
circulation. Specific direction on the
Malad is-
registry
Oh,
for these judgments to be
registry
circulated among all the judges.
oh. I-
Sir, whatever that High Court
So entire forests are being destroyed for those circulations. The paper.
Oh, acha.
You'll find very little, I mean,
Mhm.
no judgment is required, no environment
now-
judgment will remain.
Very difficult to
In
catch.
any event, those
Well,
will go.
catch whatever your lordship. At times I get it. I get at times
No,
I
no,
do not.
because you are thinking of something else. That's why.
No.
Because like we were thinking of
No, no,
saying when Mr.
your
Banerjee
lordship was also understood what I
Yes,
was
yes,
saying.
that is how it-
Yes.
Mr. Banerjee was referring to shape this. It crossed across our mind. This must have been after the advent of Ed Sheeran. So that will not. You will not catch that. No, you have not even heard about him. Please continue with whatever you're doing.
Yes. Summary of findings.
Yes, yes.
It is correct. It is settled principle of trademark that deceptive similar does not necessitate exact imitation. What is material is
The
right.
same thing is probably. I mean,
Yes, that's for a 42.
yes.
While comparing rival, court must assess marks in entirety rather than dissecting.
How many times have you read this?
etc. Well, kindly say the dominant feature of the mark may assist in crossing preliminary threshold of analysis, but ultimate inquiry must focus on the overall impression created by the mark, especially in the context of the relevant goods, trade channels, target consumers. The proper test is not to place the two marks side by side to identify dissimilarities, but to determine whether impugn when viewed independently is likely to create an impression of association of the common origin in the mind of the average consumer. Then 43 says section 71 of the Trademark Act grants exclusive right only in respect registered to protect for common distinctive unless such has a secondary meaning. 43. Yes, 43. Yeah. Section 27 to 20 preserve the right to institute passing off, determine notably 29(3) presumably consumer, not the same section 17 and 72 which I read previously is being again mentioned. In the present case in 45, the marks are clearly not identified. Well, I've said that. 46. আরো দেবো? 46 তো?
No, that has found place in at least 4 other paragraphs which have been placed by himself.
46.
Publicity
I'm
judice, yes.
reading
We
46.
know the. By now we also know the spelling of publicity
How much?
apart from the concept.
The courts below also correctly observe that the product are premium, ultra-premium, targeted at a discerning consumer base, such are likely to a greater case in their purchase power. My
This
lord,
is
a smoker.
another risky parameter. What is premium to you may not be premium to Mr. Banerjee.
Yes, but a smoker. I'm talking about a smoker.
There are smokers of several categories.
Correct.
Some people smoke in lounges. Some people smoke on the streets.
Mhm.
Some people smoke both places. So that's different. But therefore, the premiumness of the consumer
Yes.
is very, I mean,
My lord, you have to purchase it, right? You are purchasing it. Or you are asking, wherever you go, you have to purchase. You have to purchase,
yes.
right? So, my lord,
Suppose I am a businessman. I occasionally smoke whatever I get.
my lord,
I mean, whatever is offered to me in my category. So I may go to a shop and ask for
My lord,
cigarette.
with great respect, my lord, exception, my
There are many people like that who are casual smokers. Many people like that.
my lord,
They
maybe
come out of a restaurant and they just ask for a cigarette.
my lord, in the case of blenders and all these things,
This price is not so premium, is it?
no, it-
May not be so premium from the perception of many people.
yes. So he says, give me a whiskey. He will say,
Not give me a whiskey, but regarding blender and the class
London
who
Pride.
is drinking blender premium, blender's pride
There may not
may
be.
not be considered premium by other
Right.
classes of people.
I mean, in our case, with respect, may not-
Suppose your gold flake,
Yes.
your gold flake. I mean, it depends on the. I mean, you cannot determine class by only the money. That is what we are.
not only may not
Because you are tying up the 50
95 and 95 and
that
55.
may not be a good test in many cases.
My lord, well, the difference, may not the other test is
And
the smoker
50 is-
category.
Yes, and 50 and 95 may not be too different for several classes of people, of several income groups even.
No,
50
that is
similar to
also a fact.
95.
I've also mentioned, I said it's also the price, but yes, the category, Lakshmi may be right, but it's a category
person who
smokers.
earns, say rupees 10,000 per month, to him 50 and 95 will make a huge difference.
Yes,
But a person who wants, say 10 lakhs per month,
Huh.
to him it may not make a difference.
right. So, my lord,
The price factor may
my
not
lord,
be-
so he's buying in bulk. So when you talk about 10 lakhs, price factor is one packet, right? He's buying. So this is one aspect. The other aspect is the category that a smoker, like a person like will not go and say, give me a cigarette. And he
Ideally,
doesn't
we should
smoke.
also I mean, smoke both the cigarettes to understand whether, because regarding the post
I won't find any difference.
what is the term, post consumption or no, not post consumption, post sale, whatever.
Yes.
Yes. That confusion we have to also clarify.
My lord, frankly speaking, I won't, but as general
the best person.
average customer is a brand specific. He will ask for, give me a gold flake or give me a, that's all. I said the category of average intelligence, don't compare it with me or someone.
Question of intelligence, the question of taste. I mean, people may have a particular taste for gold flake.
So it's brand.
They will not
That's-
take gold stack.
That's a brand. You
You have a point there.
yes.
That is the discerning customer.
So, my lord, the 46 says, as correctly, yes, 47, although appellants heavily rely on anti-dissection, they themselves seek to dissect the composite mark, such as pride, claim in essence appears to be based brand association with Seagram rather than legally cognizable infringement. Brand. My lord, then 49, in the liquor industry,
Same applies to our industry.
liquor industry, while advertising, where advertising is highly restricted, my lord, brand recognition rests predominantly on packaging and, my lord, very important, this consumer loyalty. Unless the imitation is deliberate intent to mislead, chance of confusion is minimal. Allegation of counterfeiting in the present case appears to be speculative, unsupported by credible evidence. There is no evidence here. That's different. The para 50 attempt to combine, etc. Then in the middle, each mark must be assessed independently. Cherry picking generic or unregistered features from multiple marks to fabricate a composite is not legally sustainable. It is not in dispute, is not registered as a standalone mark, nor can appellants claim exclusivity such and such. Then Miller para 54, the comparison between reveals greater divergence, the mark arrangement, etc., etc. Then 55, the entire 55, although the appellant's whole registration for the composite marks, no evidence was reduced to demonstrate that any particular element such as bottle shape, color scheme, or the word pride has acquired distinct secondary meaning. They have tried to. A trademark protection extends only distinct identification files, distinctive or commonplace fall outside the ambit of protection unless proved. Significant appellants earlier, pride was unsuccessful. Punjab High Court head appellant did not proceed independent review, but only for composite, etc., etc. Now, my lord, আবার কি করবো?
Suppose they're calling the brands ultra premium, and the milk example shows that there is no direct knowledge.
57 he wants me to read my 56 টা পুরোটা পড়বো
You have read that.
court
Punjab-
further observe having failed the objected registration the appellants were stopped from subsequently my lord contrary to the principle settled principles this decision was upheld by this কোনটা
accordingly পরের থেকে লাইনটা স্যার এই লাইনটাই
ওরে কতবার তো, হ্যাঁ accordingly they could not claim any exclusive or enforceable rights over standalone word pride. In the middle it is written.
that you have been saying since the beginning of the judgment.
But they want me to say again. Then, my lord, say that it is contrary to equity. Now I will show you why I'm focusing on this. Are these series of judgments? It's gross suppression, to say the least. My lord, I think one judgment I pointed out. I will straight away quickly go through the paragraphs of these judgments.
So clean hand theory.
Yes,
Clean hand principle.
yes, more or less. And my lord, that's clean hands. Now, my lord, may I, you please take the chart. I have indicated the points. I thought I'll finish the copyright aspect also today. এখানে ওই bunchটা দিবি না দেয় না so first is, my lord, if you see the bunch, the first is 2022 volume 6 SCC 585, that is pages 1 to 4.
compilation of
Yes.
Have you got?
Yes, this compilation. Yes. So we thought another bunch was coming. So rather appreciate. Yes, you're giving the points of the judge.
Yes, my lord.
Please, please.
My lord, so on the proposition, this is for the proposition cannot take contradictory stand before two forums. My lord, you just look at page paragraphs, Justice Shah's judgment emphasis. My lord, my lord, paragraph, relevant paragraphs are paragraph 5, 6, and 7. Oh, sorry, I'm sorry. 2022 volume 6 SCC 585. ওই বাঞ্চের মধ্যে ফার্স্ট para 5, 6 and
Sir, both you can give them a copy of the index.
I've given.
Oh, yeah.
Great.
I've given. My lord.
That would suffice. Yes.
My lord, paragraph 5. My lord, in the middle, original defendants just took a contrary stand, then was taken by them before revenue authority, before civil court, and respondents took the objection the civil court would have no jurisdiction to entertain the suit. Then para 6, respondents original cannot be permitted to take two contradictory before two different authorities courts. They cannot be permitted to approbate, reprobate once objection raised on behalf of the original that they would have no jurisdiction. Then Miller para 7, straight away, please come in the High Court, the second line, has not at all appreciated the fact that when appellant original plaintiff approach revenue authority, Tehsildar, he was not suited on the, and that they had no jurisdiction. Therefore, when the suit was filed, respondents took a contrary stand, even the civil court suit would be barred. Now, my lord, please come to the second judgment, which is a Calcutta High Court judgment. My lord, it is 2017 SCC online, Calcutta 16310. My lord, my lord, I believe করিস না এরকম ভালো লাগে না para 2, there is, my lord, kindly see the plaintiff is what appears to be a passing contemplated by refusal of trial court to grant interlocutory restraint use of unregistered mark Swarno Ganga in respect of paddy seeds. There is no dispute that both the respondent sell paddy seeds. The respondent has a registered mark Tiger brand. Appellant also sells paddy under Swarno Ganga in conjunction. Now, my lord, para 3 in the middle, that the plaintiff states that in order to the plaintiff has duly applied for registration Tiger brand in such and obtained registration on such and such. para 4, thus the case before was that it was registered proprietor of Tiger brand Swarno Ganga, and it was entitled to injunction against the respondent for such registered mark. It has now been candidly admitted that the registration that appellant enjoys is only in respect of label Tiger mark. It is also evident deed of assignment concern in favor of appellant also possesses legal grant. Then when a para 6, though elsewhere in the body allegation is seeking to pass off goods, the principal case is one of infringement on the basis of alleged registration of Tiger, alleged registration of mark Tiger brand Swarno Ganga. Such assertion in the plaint is now accepted to be inaccurate in view of false statement. Never make a false statement in this sort of case. I mean, you are going ex parte, whatever it is. I mean, after then this can't be sustained. Yes, no. Mellor, please straight away come to Mellor. One is Mellor, yes. Mellor, this I have given. 2023 SCC Online Delhi, page 38, item 8. 2023 SCC Online Delhi, 38, para 43 and 47.
Yes.
Contrary stand before the register. Have I given it to you already?
Yes.
Huh?
Yes. Not the point, but we place this judgment.
Yes.
43, 46, and
Mellor,
47.
73.
So we'll just take down the point.
Yes, 73. I just read it. Just
Need not. You have placed it already.
I placed it, na? I mean,
Yes.
yes.
43, 46, 47. You have marked.
Yes. Now this went up on appeal. Item 20. Sorry, special leave petition. Mellor, item 23, page, which is running page 519. Mellor, running page 519. And Mellor, there was a review also filed, which is item for 25, running page 521.
Yes. Right.
No, I am not. Just mark the para 43 and 47. Contrary, this is why I have given, because this is contrary stand before registrar. Now, Mellor, then আমি আর এগুলো দেবো না, এগুলো কি সব দিয়েছে? Yes. Oh, বড় মাটা না? Mellor, এটা 2. Mellor, have I given your lordship already 2018 volume 16 SCC?
Para 6, you said.
Mellor, item 10.
Yes, para 6.
Yes. Then I have given already. I'm sorry.
This is on what point? Just give us a.
Mellor, this is registration with a disclaimer. What is the effect? Malabar. Yes.
Yes. Now we do.
Now, Mellor, rest I have given. Mellor, yes. Now, Mellor, one point I must tell your lordship is about, Mellor, item 22, Vaidya Rishi,
Yes.
India Health Private Limited, and Suresh Dutt Parashar. Mellor, paragraph 18 of that judgment is relevant. Mellor, I finished this aspect. Just copyright is left. I will quickly finish. Why I am telling? I'm telling you because there a judgment was deferred. Mellor, you see, wrong view was expressed in of a particular judgment. আমাকে দে আমার ওই second volume-টা পাচ্ছি না, এ নিয়ে নিয়েছে। Mellor, why have we taken it here? Mellor, 498. Just see, Mellor, why I am saying this. 498. Mellor, yes. This Rajkumar Prasad. Mellor, 498, para 19. আমারটা একটু দিয়ে দেন, মার্ক করা আছে।
Para 19 or 18?
Mellor, para 19. The
Yes.
decision of Rajkumar Prasad is contrary to Said Mohiuddin. This is the Supreme Court judgment. Mellor, Rajkumar Prasad has been relied upon by learned single judge.
Said Mohideen was subsequent without considering the previous one.
No, this is prior. Supreme Court.
Supreme Court was prior.
This is Rajkumar Prasad is not Supreme Court. This is contrary to Supreme Court judgment. It has been so held. Manan basically is saying that it is possible that even if gold is I'll show that
That the
paragraph.
one registered owner
Yes,
can sue another registered proprietor or not.
yes,
That was decided in Said Moinuddin in 2016.
which I pointed out.
That it could not be, but still there was a subsequent Delhi High Court judgment which has been relied on in the impugned judgment, which says otherwise, which has been relied on.
Ultimately held that one cannot sue.
Yeah.
Well, I can give you the paragraph number of the impugned judgment. My lord, even Sulochana Bai, which I
Para 9 discusses it.
yes, and Sulochana
19,
Sulochana Bai, I've already given. Moinuddin may not expressly. They have held that it's contrary.
Mohideen,
Now-
you gave the paragraphs you elaborately read also.
Yes, yes, everything I've read. My lord, which paragraph of the impugned order? Just give me the impugned order.
Impugned order. This case impugned.
Just give me. I finish. Well, I'll go straight to copyright next day and take about 15 minutes.
15 minutes next day.
15 and a half an hour, minute. I just want to about the artistic, whether it is at all artistic or not. I've got a judgment.
One request for
Yes.
after Mr. Bose finishes the next next week.
You have difficulty next week.
Can you give us the week after that, Manoj? That's
Mr. Mukherjee was asking
me
me
or-
this.
Very well, no difficulty.
Very
Yes. We're keeping it next week for.
yes. No, that's 25th first. Unfortunately,
Let,
that
let
day-
us let us
First
finish.
April had to be-
Let us finish, then you can do it.
for Wednesday.
So,
Pechish, কোন paragraph?
heard in part for list the matter for further hearing on March 25, 2026.
Well, I'll point out the paragraph of the judgment next day. huh?
Yes, yes. We'll start with that. So there will be a continuity. also.
Yes.
Yes.
May I please your lordship, my lord, on 24th September 2025, pursuant to the lordship's order, the matter was sent to the mediation committee.
Yes.
Result was nothing. That's why I have,
It's an appeal hearing matter we are not adding now.
my lord, very short matter, my lord.
Understood, but there are so many short matters also.
But I have
Let's
tried
dispose of
so
some
many
more appeals.
times. So your lordship can you consider
We'll take up, but after some matters are over, some
Because
hearing
the
matters.
Lordship,
Yes.
praying leave for filing a memorandum of appeal for hearing at your earliest convenience time.
Memorandum of appeal, you need not.
Memorandum of appeal arising out of a judgment from the lower court. It was a
It's a first appeal.
it is a FAT for tender.
First appeal.
First appeal.
Is it ready for hearing?
It is actually I'm praying leave for filing it at an early date for hearing.
But let it be ready for hearing.
Yes,
then
it is
only.
ready. It is ready.
Paper books have not been filed. How can it be ready?
No, it is
File
only
it in the department.
it is for tendering this.
File it in the department. Why are you asking for leave?
The memorandum of appeal I have to file.
You have to file in the department. Why are you asking?
I am asking for leave for filing the early date, fixing a
No
date.
question of early hearing. First, let it be filed. Paper books will be prepared. There's a long way to go.
Oh.
Sorry, no. From that.
Lordship, assigned matter, my business has been stalled. I cannot.
It's appearing in the list.
Lordship.
No upgradation.
Lordship, I cannot sell my vehicle until and unless an
Understood,
appropriate
but
order.
no upgradation right now. Later on we'll fix a date for assigned matters again. We did it some time back, but not. Right
Lordship, kindly fix one
not
day
right
for,
now, not
for assigned matters.
We'll do it after some time. Yes.
Inclusion in the list under application, restoration application.
Yes.
I seek your lordship's leave to file an appeal without the certified copy of the order.
Yes.
My lord, praying for inclusion in the list intra-court hearing, my lord. It's about compensation.
Wait for some time.
Inclusion. Order 41 only left.
Order 41, yes.
Lordship, this is inclusion under heading application, Lordship.
Yes.
The civil application included.
Lordship, praying for your leave to mention for an application. Lordship, I'm praying.
Application, yes. Follow them. Yes.
My lord, I am the appellant in
Yes,
part.
yes.
My lord, your lordships were pleased to pass and admit the appeal last
Is
week.
the correction you are asking for?
My lord, in the order, there is no description of the impugned remand order. And there was a stay for that remand order.
Stay of operation of the impugned remand order is sufficient.
Yeah, my lord, there is no description of the
For that, an order need not be corrected. The petitioner, the appellant appearing in person submits that in the order dated March 11, 2026, no description of the remand order was given. So, however, we do not file any specific need to do so, since the order pertains to a particular appeal, the memorandum of which in any event will disclose the order under challenge. Next.
I am appearing on behalf of the appellant applicant, my lord.
Yes.
Affidavit of service application for restoration, my lord. Dismissed for default on 19th February, my lord.
What is the reason you have given, Ms. Gupta?
My lord, we are keeping watch over the matter, but at the time of call could not reach the court, my lord.
We find from the order dated February 19, 2026 that none of the parties appeared on the said date. So accordingly, applying the principle incorporated under Order 9, Rule 4, read with Section 107 of the Code of Civil Procedure, we do not deem it necessary to direct prior service of copy of the application. Since sufficient reasons for the absence of the petition on appellant on the relevant date have been mentioned, has been furnished, Can 3 of 2026 is allowed, thereby recalling the order dated February 19, 2026 and restoring FAT 336 of 2022 along with Can 1 of 2022 to their original file and number. Was an interim order subsisting?
No.
The application.
Can 1 has already been disposed of, my lord. Only Can 3 is this is Can 3.
ও আচ্ছা, can one had been disposed of,
Yes, my lord.
আচ্ছা, thereby restoring, তাহলে and can-টা হবে না, restoring ওই affidavit,
Can 3.
this is can 3, we have allowed that,
Yes, my lord.
তার আগে affidavit, oh you have already served.
Paper book, yes, my lord, served, but that has been refused, my lord. Kindly recall, my lord, by order dated 11th December, my lord, these matters has been fixed ex
আচ্ছা,
parte.
যেটা আমি প্রথম সেন্টেন্সে বলেছি তার আগে লেগে affidavit of service filed to be kept on record, বুঝছাপ, তারপরের সেন্টেন্স যেটা প্রথম সেন্টেন্স ছিল, অ্যাপ্লাইং দ্য প্রিন্সিপাল অফ, যেটা বললাম, no further service is, it is not necessary to direct any further service code.
This matter is being heard ex parte, my lord, as the wife is not representing, my lord. Although legally the service has been
Paper book
given.
directions were given.
Yes, paper book has been filed, my lord. Your matter, this matter has been heard by your lordship, and your lordship was pleased to direct the petitioner to file short list of dates, my lord. My lord, can it be taken up?
No, you have to suffer somewhat for not being vigilant. Wait for
Great.
some time. Yes.
Item number 3 with quotes.
For the husband respondent, my lord, this is my application for modification of the last order, my lord.
Yes.
On the two application proceeding on initiated, one divorce by the wife and one restitution of conjugal rights by the
কোন
husband.
ক্যানটা উপরে দেবেন তো, যেটা ক্যান নম্বরটা যেটা বলছেন উনি move
Can
করছেন সেটা
3,
উপরে।
my lord.
Can
3.
which
The
appeal?
FA3 in can 3 in connection with FA3.
Yes.
My lord, divorce was filed by the two proceeding. Divorce was filed by the wife and restitution of conjugal rights was filed by the husband. I am the husband. Divorce application rejected and restitution of conjugal rights application was allowed. My learned friend has preferred two appeals. During pendency, appeal admitted. During pendency of the appeal, the matter has come before the Honorable Justice Soumensen and the Honorable Justice Apurva Sinha Roy, when the matter was sent to the mediation. And before sending the matter to the mediation, another proceeding of defamation suit, which is no way connected with this proceeding, we have assured before this honorable court that during pendency of the mediation proceeding, we will not participate in that proceeding. That under
You are the plaintiff in that suit.
in the plaintiff in that suit. My lord, kindly come to page 35 of my application, my lord. Paragraph number 6, my lord.
Yes.
In the meantime, mediation failed. Both the parties appeared and it failed. Now, subsequent to filing this application, my lord, this development took place. This order was passed by the learned court below.
No, why did you file this application in the
For
first place?
modification to proceed with that defamation suit. Only to with that extent or nothing.
So no modification was required in the first
My
place.
lord, there is an order, so I have filed this application.
Until further.
Until further order.
All right.
This was the last paragraph, my lord. Thus, plaintiff is directed to produce either the mediation report or subsequent order of the Honorable High Court. So,
But this is on a different footing. Mediation, have you got the mediation report?
it was, I have not,
Achha, it should be sent to the court.
it was sent to the court.
Mediation report টা কোথায়? Mediation committee তে report থাকবে, judicial করে থাকে। Yes, so we are allowing this application. We are clarifying that they will be able to proceed with the defamation suit, and
My lord,
mediation has
may I
failed.
come in? My lord, there's some reason they are stating that that is totally altogether from that suits, my lord. I will show my lord, your lordship, that is annexed to page 24, 23, 24. That is suit itself. That is also part of that. The appeal is considering that previous suit, that is the restitution of conjugal rights, the divorce suit of the dissolution of the marriage. And that has been pleaded there, and that is also under the consideration. And the appeal is pending right now. The appeal has been, execution order has been stated by your lordship.
And kindly come to page
So no,
24.
but you have not asked for any stay of that suit, and that was continuing. This was only due to the mediation.
My
It's
lord,
very
kindly
clear from
comes
the
to-
order.
Kindly comes to.
No, they had assured that they will not participate until further order in view of the previous sentence that parties will render cooperation during the mediation. Mediation has failed, they are entitled to proceed. We'll say that subject to any order of stay independently being passed. If that is passed, you can pray for that before that court also. The present application, the two present appeals, দুটো action order. The present two appeals arise respectively out of a decree, out of a judgment decreeing the divorce suit of the, a judgment dismissing the divorce suit of the appellant wife and one ONE allowing the counterclaim of the respondent husband seeking restitution of conjugal rights.
That was not counterclaim, that is separate suit, total separate suit.
Not a counterclaim.
No.
Two separate.
Counterclaim to suit kore
In a common judgment passed.
decreeing and decree allowing the counterclaim with it and decreeing the separate suit filed by the respondent husband for restitution of conjugal rights. For sub next para, the matter was sent to mediation. Full stop. However, comma, from the report of the learned mediator dated November 7, from the order of the mediator dated November 7, 2025, comma, it transpires that the mediation between the parties has failed. Full stop. Next para, accordingly, learned counsel for the respondent husband submits that the present application was filed for recording appropriate orders in that regard. Full stop. It is pointed out that in paragraph number 6 of the order dated August 6, 2025 by a coordinate bench, comma, whereby the appeals were sent for mediation, comma, and assurance of the counsel, an assurance of counsel for the respondent husband was recorded to the effect that the respondent would not participate in the defamation suit within bracket instituted by the respondent husband bracket closed until further order. Full stop. It is submitted that such assurance was given in the light of the matter being sent to mediation. Full stop. However, comma, since the mediation has failed, comma, such portion of the order may be modified and it may be clarified that the husband would be entitled to proceed with the defamation suit. For sub next para, learned counsel also hands over a copy of an order dated December 17, 2025, passed in the defamation suit, whereby the learned trial judge insisted on the respondent to produce either the mediation report or a subsequent order of this court clarifying the status of the mediation and stroke or granting liberty to proceed with the suit. For sub next para, learned counsel appearing for the appellant wife submits.
One more submission. I have already filed the application for order 6 rule 17 and order 41 rule 27.
Let us complete this order.
No, this is in this appeal, my lord. I have already filed. Your lordship consider that would be taken at the time of the hearing of the appeal.
Let us complete this order on this application first. Learned counsel appearing for the appellant wife submits that since the allegations made in the defamation suit are in the context of the dismissal of the divorce suit and the decreeing of the restitution of conjugal rights suit of the respondent husband, comma, the same cannot be permitted to continue, comma, since those very judgments have been challenged in the present appeals. For sub next para, however, comma, we find that there is no order of any court staying the proceedings of the defamation suit. Full stop. It is also evident from the order dated August 6, 2025, comma, that the assurance given by the respondent that he will not participate in the defamation suit was specifically in the context of the matter being sent to mediation, comma, which has subsequently failed. Full stop. Accordingly, comma, we do not find any bar to the respondent husband proceeding with his defamation suit. Full stop. Next para. Accordingly, can 3 of 2025 is disposed of by recording that the mediation between the parties has failed and that there will be no impediment for the respondent husband herein to proceed with his defamation suit before the court where it is pending. Full stop. Next para, however, comma, we make it clear that the above observation will be subject to any order of stay, comma, if passed by any competent court at any point of time. Next para. Yes, your what applications are pending?
Order 40 Rule 27 and Order 6 Rule 17. My lord, your lordship already passed the judgment that order that would be taken with the appeal.
So why are you
with the
mentioning
appeal.
that?
That is our my appearance. I have to bring that fact before your lordship.
Service may be kept.
That is that.
Prothome affidavit service filed today be kept. Thank you.
Yes.
That order is already there, so yes. Next.
My lord, the second one, the can is 4.
Can 4 is what?
The second item number 4.
That is
Can
also
number,
same order.
same thing.
Acha, can 3 of যেটা বললাম, can 3 is in FA3.
FA3.
Can 3 of such and such in FA3 of 2024 and can 4 of the same
FA5.
year in FA5 of 2024 are
Get.
applications ওটা কোথাও ওটা করে দেবেন।
Item number 5.
This is my affidavit of service. Yesterday the matter was taken up. It has
Door locked, the door locked and
yes,
intimation.
and unclaimed.
Unclaimed. Oh, affidavit service was not there. Yes, Mr. Mahathir, please.
But I filed the counter claim in a suit for divorce filed by the husband. My lord, suit was filed on May 2001. No. Marriage was 2001. One male child 2006. My lord, suit for divorce 2019. My lord, written statement has been filed 2022. And my counter claim has been filed 2025. My lord, counter claim for restitution of conjugal rights. My lord, they filed an application that counter claim is not maintainable because of the delay. I filed much after filing of the written statement, therefore it cannot be taken up. That application, my lord, at it starts at page 7 of the application. Relevant paragraphs are, my lord, paragraph 4 and 5. Paragraph 4, my lord, the entire order 8 rule 6A has been quoted, and then my lord says that it is counter claim should be filed at the time of delivery of the defense. It should not be, therefore it should not be considered. It should be dismissed. This was their prayer. We filed our written objection. Court has, my lord, accepted their plea, and my lord said that since it has been filed, my lord, much after, therefore, my lord, it cannot be taken into consideration.
But the cause of action has to arise before.
Yes.
That is sufficient.
Yes.
Just check up whether we are making any mistake.
Okay. Cause of action
has to arise
prior
before or
to
after.
filing of written statement.
Yes, only that. There is no time frame for filing. Otherwise, if it is barred by
The
limitation,
concept of amendment has been applied.
yes.
Since the issue has been framed, therefore, my lord, it should not be taken into consideration. Considering a Supreme Court
You have,
decision,
this application is for stay of that. What? This application is for stay of the judgment.
stay of the operation.
Learned counsel for the appellate wife submits that the counterclaim of the appellate wife, comma, seeking restitution of conjugal rights, comma, filed in a suit for divorce filed by the respondent husband, comma, was turned down apparently on the ground that the counterclaim could not be filed after filing of the written statement, comma, on a misinterpretation of Order 8 Rule 6 capital A of the Code of Civil Procedure. Full stop. We are prima facie satisfied with the case sought to be made out by the appellant, inasmuch as Order 8 Rule 6 capital A merely mandates that the cause of action has to arise before or after filing of the suit, but before filing of the counterclaim. Full stop. There is per se no bar in the said provision as to the counterclaim being filed after filing of the written statement. Full stop. Accordingly, accordingly, a strong prima facie case for grant of stay has been.
No, my lord has already last occasion granted stay, but my lord was of the view, my lord directed me hard copy along with the memo of
Not appearing. What can
Yes.
be done? There should be stay of all further. We have stayed all further proceedings.
till the disposal of the application.
There should be stay of all further proceedings. We also find from our previous order that ad interim stay in that regard has already been granted. Full stop. Since from the affidavit of service filed today, it transpires that due service has been effected on the respondent, but the respondent chooses not to appear, the application is being disposed of ex parte. Accordingly, Can 1 of 2025 is disposed of by granting stay of all further proceedings.
Two names suit number 362 of 2019.
All right. All further proceedings of matrimonial suit number 362 of 2019 pending before the learned additional district judge, special court bracket EC Act bracket close district Paschim Medinipur till disposal of the appeal. Full stop. The appellant this is only on a small point, so you can prepare informal paper books. The appellant shall put in requisites, postal costs, and written up notice form within a week from date for service of notice of the appeal on the respondent. Full stop. Should you dispense? No. Trial court record.
Trial court is not necessary.
No. In view of the ambit of the appeal being short, calling for the trial court records is dispensed with for the present. Full stop. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks or 6 weeks. 4 weeks. Within 4 weeks from date. Full stop. Liberty to the parties to mention the appeal for inclusion in the list as and when the same is ready for it.
Item number 6.
For the plaintiff respondent.
But I'm for the appellant. My lord, yesterday, my lord, your lordship, my lord, took up 2 applications, my lord. For section 5, my lord, that was disposed of, allowing, my lord, the application, and my lord, 1 for addition of party, my lord. But only, my lord, Can 1, my lord, that is for stay of, my lord, final decree proceedings, my lord, that is pending.
Why did you ask for adjournment in that?
My lord, your lordship was, my lord, I was, my lord, to answer on, my lord, the merits of my appeal.
Oh, yeah. Yeah.
My lord, kindly, my lord, takes up, my lord.
What was the merits of the judge? Remind us, Mr. Banerjee.
Yes, my lord.
You also remind us what
Yes.
fell against you.
Yes. My lord, so far, my lord, the merits have not been gone into, my lord. Nothing, my lord.
What is the merit?
My lord, there are, my lord, 2 prayers, my lord, primarily in the plaint.
Your suit.
Their suit.
Degree.
Yes. 1, my lord, for this, my lord, partition. That is the first prayer, my lord. So far, my lord, the share of the parties go, my lord, in the partition, in the prayer for partition, my lord. There is nothing on record, my lord, to dispute much. The second.
But that was taken by Mr. Mukherjee.
Yes.
You're not disputing the shares.
Yes. The second, my lord, the second prayer is, my lord, for a easementary right over one part of the property in the suit property. One part of, my lord, they claim that it's a road which is being used by them for a long period of time. We say that there's an alternative road, and that portion of the plot is was never being used as a road itself. That is what, my lord.
The local investigation was held.
Yes, my lord. My lord, may I, my lord, take your lordship, my lord, to the order once. My lord, so far, my lord, the order, my lord.
No, you don't admit that there is an easementary right over any portion. They claim exclusive easementary right over that portion.
No, they claim ejmali easementary right.
So what are you disputing then? You say that it belongs
There is no easementary right. It's a joint property.
My lord, I say that, my lord, that portion of, my lord, kindly.
You say that you also don't have an easementary right.
No, my lord, kindly sees, my lord, the nature of the order once, my lord.
Yes. First, Mr. Banerjee shows that declaration in the prayer in the.
Yes. Kindly, my lord, takes up the plaint once. My lord, page 17 of the injunction application, my lord.
No, come to the prayer of the plaint.
Yes, my lord, page 17 of the injunction application.
Come to the plaint. Why injunction application?
Injunction application can one.
Oh, acha, acha. Yes, yes.
My lord, I'm reading, my lord, the prayer number ক is, my lord, আর্জির বর্ণনা নালিশি ক তপশিল বর্ণিত দাগে সম্পত্তিতে বাদী 13 শতক সম্পত্তি বাবদ
show us that portion. That really.
সেকেন্ড
ক1
ক1 আর্জির বর্ণনা মতে নালিশি ক তপশিল বর্ণিত সম্পত্তির তপশিল নকশায় দর্শিত এবিসিডি চিহ্নিত ভূমি নালিশি দাগের অংশীদারগণের যাতায়াতের জন্য এজমাল রাস্তা থাকা প্রচারে ডিক্রি দিবার আদেশ হয়। This is, my lord, their prayer.
How are you affected? You say that you have rights over that, ownership rights?
Yes, exclusive ownership right. That is
exclusive.
Exclusive. That is what my case is, my lord.
You have exclusive.
I have exclusive ownership right.
Not a joint property then.
No, over that part of that, my lord. Kindly, my lord, takes up, my lord.
Your written statement.
My lord, kindly, my lord, takes my lord the order once.
The judgment, impugned judgment.
The impugned judgment, my lord.
That has also been annexed here.
No, my lord. It's in the memo.
From the memo, yes.
Page 8, my lord, of the internal page 8.
Yes.
May I read, my lord? The suit be and the same is decreed on contest in preliminary form in respect of co-scheduled property against defendant number 1, 2, 3 and ex parte against rest defendants. It is hereby declared that the plaintiff has 13 shatak of lane in co-scheduled property as mentioned in the plan, and it is also declared that the defendant number 1, 2, 3 have 30.5 shatak share in co-scheduled property. The rest defendants have remaining share in the suit property as
this lane should be share, we suppose.
Share, my lord.
Very well, yes.
The rest defendants have remaining share in the suit property as described in co-schedule of plain.
The last paragraph.
It is also declared that all co-sharers of co-schedule property has a joint right of pathway as mentioned and marked as ABCD in the plain.
You are claiming by inheritance, all of you, from your father?
No, purchased.
You jointly purchased?
The vendor is same.
No, not this this easement portion, not this pathway. The rest of the property, how are you claiming?
I'm claiming, my lord, by my deed. By my deed, my lord, there
are regarding the easement property.
My lord, there are, my lord, two deeds. My lord, what has happened, my lord? I'll just, my lord, indicate. There are, my lord, two deeds. My lord, I purchased the property, my lord, in favor of my two minor sons from, my lord, the 5 daughters of the original vendor. The five daughters of the original owner.
They were the absolute owners between themselves.
Yes. They were absolute owners.
All the owners sold that?
No, not all the owners. The five daughters, they had some portion of the property, and the others also had some portion of. They are also other co-sharers.
The other co-sharers, they have not sold their shares to you.
No. Well,
so they sold to you.
Well, kindly, well, takes up, well, page 2 of the impugned judgment once. Well, this part will be clear, my lord.
You are defendant number 8.
I am defendant number 1. Defendant number 1, my lord, purchased, my lord, some portion of the property, my lord, in favor of his two minor sons, my lord, to separate this from, my lord, some of the co-owners who had, my lord, a larger share of the property.
Demarcated portion?
Undemarcated.
Could not have purchased.
Could not have purchased demarcated.
So then,
and my lord, my learned.
Can you become another co-owner?
I become another co-owner, and my learned senior friend's client also, my lord, purchased some portion of it.
Yes.
Now, my lord, in between us, there is a, my lord. In between us, my lord, they claim, my lord, exclusive ownership of 13 decimals of the plot, and my lord, I claim, my lord.
They claim exclusive ownership. No.
They claim ownership of 13
shatak share.
13 shatak share. And my lord, my claim is, my lord, 30.5 shatak of share, my lord, in co-scheduled property.
Which has been granted.
Which has been, my lord. The difficulty is, my lord, the pathway never exists on any of the property, any of the, my lord, portion. The difficulty is, my lord, I'll just indicate, my lord, what they are showing as pathway. My lord, what they are showing as pathway today, my lord, that portion of the land is already being my lord, occupied by me. My lord, that is, my lord, a contention, my lord, to be taken, my lord, at the final decree stage. But my lord, the existence of the pathway, my lord, that is in doubt. My lord, may I, my lord, show, my lord, why?
Whether it is a pathway or a joint property, in any event, present possession is honored by the partition commissioner, even if you are in possession of it. So how does it affect you in any manner, in fact? Whether pathway or not, it's a joint property. So pathway or not, that will be ascertained by the commissioner.
There is, my lord, already an inspection had taken place.
Suppose it's a pathway, then it has to remain as a pathway. That may be your problem.
Yes.
But how do you claim right? What is the source of your title to that pathway, exclusive title?
Exclusive title, my lord, I'm not claiming, my lord. But, my lord, the existence of the pathway itself, my lord, that I'm disputing. The existence of the pathway, my lord, that takes away a chunk of the share of, my lord, the suit property. My lord, kindly takes up, my lord, the contention of the plaintiff, my lord, once, my lord, in my lord, in the 7 হবে না, এটা 3 হবে, my lord, internal page 3, my lord, of the plaint, of, my lord, the judgment.
Yes.
Right of pathway. The claim of the plaintiff in respect of
Right of pathway.
My lord, the heading is, my lord, right of pathway.
That is not page 3.
Well, it has been
Wrongly paginated.
wrongly paginated, but should have,
Your learned junior was right actually.
well, it should have been, my lord,
7.
my lord, 7, my lord, but should have been
Internal pagination is 7.
7. Should have been, my lord, 3, my lord, after 2, directly 7.
Why?
Can you, my lord, see the previous page, my lord?
Previous page is 6.
আমাদেরটা কি
You don't have all the pages.
কি করেছো?
You don't have all the pages, Mr.
My lord, kindly, my lord, takes up, my lord, takes up.
So at least you will not argue on pages 1 to 5.
My lord,
But you are assured.
but
You want to
I'm only on this part only, my lord.
Yes.
The claim of the
You are
plaintiff.
appealing for whom?
They are with us.
Why is he with such a sad face? Yes. Yes, Mr.
Right of pathway. The claim of the plaintiff in respect of pathway over ABCD portion as mentioned in the sketch map of the plaint has been agitated in this suit. It appears that at page 7 of the document of Exhibit 3, by which 13 shatak of land was transferred in favor of plaintiff, it is clearly mentioned that there is existence of a joint pathway on northern side of the suit property. Again, at page number 5 of Exhibit 4 and Exhibit C, placed on behalf of the defendants, similar recital regarding enjoyment of pathway has been mentioned. Similarly, from the recital at page number 6 of Exhibit D, Exhibit D on 6 on behalf of the plaintiff has mentioned existence of right of pathway on the northern side of the suit property. On scrutiny of the evidence of PW3, Learned Advocate Commissioner, it is transferred that his report, Exhibit 12, has mentioned at point 2 of page number 4 the existence of a Kacha road marked as ABCD, which is about 120 feet long and 9.4 feet broad in co-scheduled property. At the time of cross-examination, the defendant number 1 deposed as Result 1 that he has filed no objection in respect of such local inspection report. It is argued on behalf of the defendants that original owner of the suit property did not demarcate any portion of the land as pathway, and for which prayer of common passage made by the plaintiff does not arise. On perusal of the evidence of DW1, it appears that he admitted that there was a Moram road running east to west, situated to the north of the Suddak. He admitted the sketch map depicting the position of the co-sharers was prepared in his presence along with others. He also identified his signature on Exhibit 10, which is marked as Exhibit 10/1. The said document of hand sketch map also establishes the fact that existence of a pathway on the northern side of the suit plot. It is argued that a purchaser cannot have better title than what vendor had. A decision reported in AIS such and such was placed on behalf of the defendant. In this regard, madam, I'm coming on skipping, madam. It is settled principle of law that an easement of necessity only arises. Easement of necessity arises only at
The time of severance.
only at the time of severance of joint tenements, when an easement is necessary for enjoyment of transferred or partition property. In the instant case, the joint right of pathway, without which co-scheduled property cannot be used at all by all the co-sharers, is revealed from the documents of title of both the plaintiff as well as the defendants, and also from the partition plan prepared in presence of both the parties. The executors of sale deeds have created right of pathway in favor of both the plaintiff and defendant. The above decision produced on behalf of the defendant seems not to be applicable. In view of the above discussion, it is invariably determined that the co-scheduled property is a joint property of the plaintiff and the defendant having respective shares therein. It is also determined that all co-sharers have legal right to use common pathway as mentioned in their respective deeds of sale. Since the co-scheduled property in question is a joint property and parties to the suit are co-sharers of the suit property, any co-sharer is entitled to demand partition of the joint property for severance of their right Considering the facts and above of the case and having regard to the evidence on record, I have no hesitation to hold that such defendants have joint right over procedural property.
Now, this pathway what is on the other side of the pathway? That pathway was a part of the original vendor's property also.
They have filed a sketch map. We have also filed a same vendors.
Both the pathway also belong to the vendors.
Yes.
Then
it is the entire large chunk of land
in between in the middle of that or
the entire undivided portion is being sold in both the deeds of the parties
within the two parts.
Yes, existing.
Kindly takes up page 19 once 19.
No, it that pathway is not within the property, within the larger property of the vendor.
Within the property.
Then obviously because separate portions were sold to different parties.
Kindly takes up page 19 once, page 19, my lord. It's their map, my lord. Page 9.
Card map.
It's a plenty fair map.
19.
It is, my lord, 19 my lord, of Can 1, my lord.
Yes, yes.
It is, my lord, the map annexed to, my lord, annexed with the plaint, my lord.
Yes.
In the middle, my lord, kindly sees, my lord, in the middle, my lord, Ejmali Rasta.
Where is that?
At the top hand side, my lord, beside plot number 90.
Modam Rasta we find.
No, my lord, beneath that, my lord, it's 90-degree angle too. My lord, the...
Oh, yes, yes. Ejmali Rasta. So it's pat within the middle of the property. So that was necessary at the time of severance. Court is right. At the time of severance, because one share was given to them, the other share to you.
Now, my lord, kindly consider, my lord, the plot number 94 Doba from the image, my lord. Plot number 94 Doba. This belongs to my lord Chandu Ali Khan, my lord, the appellant, my lord, before your lordship. And my lord, just my lord, beside my lord, that road, that my lord, that disputed Rasta.
See, everything is a joint property because there cannot be, it's joint till there was no partition previously.
Existence of this pathway, my lord, makes my property divided into parts. Kindly sees, my lord, from at the bottom, my lord, the plot
Apart from the Doba, what other proportion of the property is given to you? Which other plot?
Yes, my lord, kindly sees, my lord.
Suit plot is only 93. Doba and all these things are not the suit property. Suit property is only plot number 93.
Where is 93 in this picture?
Milord, 93 is Milord, that portion, Milord, which my learned friend has shown. Milord, in the middle, plot number 93.
93.
Yes. So this is the suit property. So my learned friend's contention before the trial court was that
even if you cannot reach the Doba without that pathway.
No, my lord, that is what, my lord, there is a, my lord, there, my lord, my contention is there is, my lord, road throughout the suit property, my lord, all around. All around the suit property, my lord, there is a road. Well, this is their map. Now, my lord, kindly takes up my map once. I have also annexed a map, my lord, with my written statement. My lord, page 37.
But there are several, in all the deeds the vendors have created. You cited judgments to show that the vendor cannot create a better title. But this is not a better title. Within their property, they have demarcated a particular portion
My lord, kindly
for
considers,
convenience
my
of
lord,
the user.
kindly considers the vendors were, my lord, 5 sisters.
Maybe.
5 sisters. There are other co-sharers who did not.
They are also parties to the partition suit.
Yes.
They are not parties. Then it's bad for non-gender.
Only the vendors, the total property is a large chunk of land. These 5 daughters, they have sold out their undemarcated portion.
How can
to
they?
both of us.
How can
undemarcated. That's why.
Undemarcated, their share can be sold. Because
yes.
Then the suit is bad for non-gender.
No. I am not saying regarding those others.
No, vis-a-vis the other original co-owners, the property remains undivided also.
Yes. Those are the parties. I am
that
not
is
saying
what we are asking.
Those are parties. Now, these 5 common vendors of both of us, they have executed 3 sale deeds. 1 in my favor, 2 in their favor. These 3 sale deeds simultaneously recognize that this 13.13 is sold to me and 30.5 is sold to them. And both these 3 deeds, simultaneously, there was an arrangement that this portion will be used by all these parties as a common passage. The court found that yes, both of your deeds,
their sale deed and your sale deed both
by the common vendors.
You are also bound by that.
Yes, and thereafter local investigation.
So, claim through the deed Mr. Banerjee,
But I'm claiming my share so far as 30.5 shatak of land is
through
concerned.
your deed,
Through my deed, my lord.
through your deed,
Through
but if
two
you,
deeds,
if
through
you
two deeds, my
rely on that deed, you have to rely on it as a whole.
My lord, there is no, my lord,
You
my
cannot
lord, my lord,
reject a part of it.
my lord, may I, my lord, only, my lord, indicate one thing. There is, my lord, no indication in the impugned order itself, impugned judgment itself, that my deed says so. They
Yes.
say, my lord.
You just now read it out for us.
No, no, my lord, kindly consider.
Page 8, top.
Yes.
All the questions is revealed from the document of title of both the plaintiff as well as the defendant, and also from the partition plan prepared in presence of both the
You are
parties.
facing where? Which
Not the page 8 from the top in the instant case. Not page 8 of the judgment, top. In the instant, has your lordship, in the instant case, the joint right of pathway without which co-schedule property cannot be used at all by the co-owners is revealed from the documents of title of both the plaintiff as well as the defendants.
Not only that,
And
page
also
5 of exhibit, previous page 5 of exhibit 4 and exhibit C, placed on behalf of the defendants. Similar recital regarding enjoyment of pathway has been made.
I'll just indicate, my lord,
Those
what
are
I
your
feel.
deeds.
My lord, no, my lord, I'll just indicate.
And there's a commissioner's report, advocate commissioner's report. You have not filed written objection.
My lord,
he said, I will not.
And you have admitted that there was a, that is a moram road.
My lord, page 5, my lord, kindly comes. My lord, page 5 of the judgment, my lord. My lord, page number 5, my lord, item number 5 from the top and item number 6 from the top. My lord, exhibit E and exhibit F. These are, my lord, my two deeds. Well, nowhere from the judgment it transpires that in my these two deeds, well, there is, my lord, an indication of pathway.
But from a composite reading of all the other deeds, it has been arrived.
My lord, the rest of the deeds were, my lord, my exhibits, my lord, I had exhibited them. That, my lord, I cannot. That, my lord, I cannot bear.
They had a right to do this. Your own vendors had that property. You admit the ownership of the vendors. By relying on your deed, you are at least admitting the ownership of the vendors.
Certainly, my lord.
So if you are admitting that, they had a right to carve out this passage, and your only contention controversy was
kindly considers, my lord,
this better title part.
Some of the co-sharers of a large plot, chunk of plot, my lord, carved out a, my lord, a portion of, my lord, of the path, my lord, as a pathway.
Any even that portion,
that also not in my deed.
If that has not been given to you, that portion, that pathway has not been given to you, you do not have a right otherwise also to controvert. I mean, you are not affected in any manner. What is your locus standi? You don't have a right to challenge that also. You are unlawfully occupying. Even that, unfortunately, as per law, the commission has to take note of your position also if you are in actual position. But it's a pathway corroborated by several deeds executed by your vendors in respect of the others.
Apart from my deeds.
Maybe. Majority wins.
Kindly, my lord, let the deeds at least, my lord, come, my lord, kindly have a look at those deeds, my lord. After that, my lord, my lord,
No, we proceed on the premise that your deed does not reflect and their deeds reflect. All the other is one of the plausible views, Mr. Banerjee. We need not interfere in this matter. You are rejecting our order of Rule 11.
My lord, whatever.
No, we cannot. First, we are deciding it on merits.
Well,
in view of the short point involved, the appeal itself is taken up for hearing on the basis of the papers on record, along with the connected application. Who's up next para? The present challenge has been preferred by your defendant number?
1.
No,
1, 2, 3.
1, 2, 3.
No, 1, 2, and 3, my lord.
Very good. Defendant numbers 1, 2, and 3.
2 and 3 were minors, my lord, represented by 1. 2 and 3 are minors, represented by.
But they were defendants in this.
Yes. 1, 2, and 3.
1, 2. Please take your seats, both. If we commit a factual error, just point. Defendant numbers 1, 2, and 3 in a partition suit, against the preliminary degree passed therein. Who sub next para? Although the shares of the parties as declared by the learned trial judge have not been objected to in principle, the appellants assail the declaration in the impugned preliminary decree to the effect that a passage marked as ABCD in the sketch map annexed to the plaint is a joint pathway between the parties, that is the co-sharers of co-scheduled property. Who's up next para? Learned counsel appearing for the appellants argues that the said
purported pathway is not reflected from the title deed of the present appellants. Full stop. Next para. Moreover, comma, since only some of the co-owners of a larger chunk of property sold different portions of the said property respectively to the plaintiffs and the defendants, comma, the said vendors could not carve out additional rights or change the character of the property from its original uh, nature by themselves. Full stop. Next para. It is argued that a vendor cannot convey a better title than he/she has. Full stop. Next para. It is further argued that should we record that you are in possession of that property?
Admittedly, madam, that part is not
It is further argued that the so-called pathway.
Regarding the pathway, their admission is not admitted, but their possession.
No, they are
Pathway,
claiming.
They are claiming that they are in possession. My conspectus of suit, filing of suit, is that they are trying to encroach upon pathway.
So-called pathway is a property which is in occupation of the present appellants. First of next para, learned counsel appearing for the you are for which of the respondents?
Plaintiff. One. Yes, only one plaintiff. I stepped into
for the plaintiff stroke respondent number 1 contends that the learned trial judge categorically found in the impugned judgment that it is corroborated by most of the title deeds of the respective parties, comma, from common vendors, comma, that the pathway in question is a joint pathway of all the co-owners of the cost schedule property, comma, which comprises of the entire block of joint property. Full stop. Next para. Further, comma, it is pointed out that an advocate commissioner held a local inspection and filed his report, comma, to which no objection was sought to be filed by the defendants, stroke appellants. Full stop. Furthermore, comma, it is seen from the furthermore, comma, learned counsel relies on the portion of the judgment where the learned trial judge categorically observed learned counsel for the কি বললাম এখন last moreover observed that the joint right of pathway without which cost schedule property cannot be used at all by all the co-sharers is revealed from the documents of title of both the plaintiff as well as the defendants and also from the partition plan prepared in presence of both parties. Full stop. Next para. Upon a perusal of the impugned judgment, comma, we find that the learned trial judge proceeded on one of the plausible views which is possible to be taken on the basis of the materials on record. Full stop. Next para. The learned trial judge went on to record in the impugned judgment that an advocate commissioner's report was filed and marked as Exhibit 2, comma, from which the existence of Kacha Road marked as ABCD, comma, which is about 120 feet long and 9.4 feet broad within the cost schedule property was established. Full stop. It was further recorded that at the time of cross-examination, the defendant stroke appellant number 1, comma, deposing as DW1, comma, had categorically stated that he had filed no objection in respect of such local inspection report. Full stop. Next para. Although it was argued on behalf of the defendants that the original owners of the suit property did not demarcate any portion of land as pathway, comma, the learned trial judge placed reliance on Exhibits 4 and Exhibit C
as well as Exhibit 3, comma, the respective deeds of the plaintiff and some of the defendants, comma, to come to the conclusion that in all the said deeds, comma, there was corroborative reference to such joint pathway. Full stop. Although the specific deeds, purchase deeds of the present appellants might not have reflected such pathway, comma, in view of the vendor's intention being clear with regard to the creation of such pathway for the convenience of the purchasers, comma, since otherwise it would be inconvenient for the parties to have access to their respective portions, comma, which they had full right to do. Full stop. Next para. Since the defendant numbers 1 to 3 appellants claim through the self-same vendors, comma, they cannot dispute the title of the vendors, full stop, associated with the bundle of rights pertaining to the ownership of the said vendors, comma, albeit ALBA, in respect of a share in the original chunk of property, comma, also included the right to carve out a pathway in between the property sold by them, comma, for the convenience of the purchasers. Full stop. The necessity to create such pathway, comma, although might not have existed previously, comma, was coextensive and originated simultaneously with the execution of the deeds and vesting of portions of the property in respect of different purchasers, comma, since otherwise it would be difficult for the said purchasers, within bracket, the parties to the present litigation, bracket close, to enjoy their respective portions by having access thereto through the property of the others. Full stop. Next para. The learned in the court below, comma, in the trial court, comma, the learned the appellants relied on certain decisions of the Honorable Supreme Court as well as the Madhya Pradesh High Court in support of the proposition that a co-sharer can only sell to the extent of his share, but not any specific portion of the land. Full stop. Next para. Even going by such principle, comma, the parties have chosen the route RUT of partition to have their specific portions in the property demarcated. Full stop. Next para. Furthermore, comma, even if it is held that no specific portion could be allotted to either party, comma, the nature and character of a portion of the transferred property could very well be identified by the vendors in the sale deeds executed by them. Full stop. Next para. Moreover, comma, in view of the specific admissions of the defendant number 1 as DW1, comma, as recorded in the impugned judgment, comma, it cannot be said that there was no existence of pathway. Full stop. The DW1 further admitted that there was a Muram road running east to west situated to the north of the Sud Dag, and that a sketch map depicting the position of the co-sharers was prepared in his presence along with these others. Full stop. The DW1 also identified his signature on Exhibit 10, which was marked as Exhibit 10/1, comma, which was a hand sketch map establishing the fact of existence of a pathway on the northern side of the suit plot. Full stop. Next para. Hence, comma, we do not find any scope of interference with the consistent findings of the learned trial judge based on the materials placed before such judge before the said court, comma, since it is well settled that the appellate court, comma, even if it is possible, comma, shall not substitute its own views for that of the learned trial judge if two views are possible. Full stop. Accordingly, comma, FAT 413 of 2025
is dismissed on contest without any order as to costs. Full stop. Consequentially, what cans are pending?
No, only this, not can one.
Can one.
Other
What?
two
But
can
2 and 3 are disposed of.
disposed of yesterday.
Accordingly, can 1 of 2025 also stands disposed of. Full stop. Next para, no order as to cost. আচ্ছা না যেখানে বললাম is dismissed, comma thereby affirming টা করে দিতে হবে, এটাতে ডিগ্রি হবে, thereby affirming the judgment and preliminary degree dated March 28, 2024 passed by the learned civil judge senior division bracket at Ghatal district Paschim Medinipur in title suit number 72 of 2015 তারপর যেটা কন্টিনিউ করলাম লাস্টে ওই 8 দিন সার্টিফাইড কপি না formal decree be drawn up এখন.
Grateful, man.
Thank you for cooperating, Mr. Banerjee. Yes. Otherwise, this would be pending for years and we will grant stay and.
Item number 7.
Change of side. Yes.
My case also not.
Why? You are on in the other side?
No. From that side to this side. This is original side.
Oh, what? Yes.
But my affidavit in reply.
You are for the appellant.
I'm for the
There's a
appellate, yeah.
section 5 application
Section
you have filed.
Opposition. What is the opposition? Filed it previously?
What? Opposition?
Yeah.
Because, yes, it is already on. Which one is the
Can 1 is section 5 application.
Right.
The parties have exchanged their affidavits.
What is the delay and what is your explanation
The
first?
delay is 1 to 49 days.
In years, what does it come to? More than 3?
More than 3.5. More than 3.5.
My lord, I will tell you a lot.
1 to 4?
1 to 49, my lord.
Yes.
The suit was initiated, my lord, on 31st of May 2021 by the husband.
Divorce?
For divorce.
You must have remarried in the meantime.
No. That's your lordship.
Good husband.
On the,
Yes.
I must say that also. That otherwise,
what are your respective ages?
Age.
Petitioner, the wife is blood 43.
Yes.
The husband is around 52.
And what? Approximate. The divorce suit was filed on 31st May.
31st of
21.
May.
Then
2021. My lord, it's that COVID time, my lord. It is revealed that the suit was proceeded ex parte. My case is that I never received summons. My case is that I never received summons, and thereafter, my lord, on the day when the husband deposed, on the same day, my lord, the argument was commenced and the judgment delivered.
The date of the deposition. That date itself, the judgment was delivered.
On that day, ex parte, yes. On that day.
Same date.
Same. And my lord, how, my lord, I came to know, because the entire delay, my lord, my case is that if your lordship takes up,
What is
my
the
lord,
date of the judgment?
Date of the judgment is, my lord, 5th of March 2022.
Decree is 5th. 4th March is the judgment. 5th is the decree.
4th March.
4th March.
4th March is the date. Which
Lord, if your lordship takes up, Lord, my explanation, Lord, I just for your lordship, Lord, the marriage was solemnized and thereafter out of the marriage, Lord, in 2017, one male child, Lord, born. Lord, he is right now, Lord, of 9 years of age, 9 plus. Lord, the parties at the time, Lord, was living together. Lord, there was, Lord, quarrel, differences of opinion due to in-laws interference. That is the
We
case.
won't go into those.
Lord, I am not on that. Lord, the case proceeded with that. The explanation rather of my section 5 application is that after the male child, Lord, begotten, Lord, out of that marriage, Lord, since there was a lots of quarrel goes on, Lord, police complaint was filed. It was a mutual arrangement. Lord, I most of the time resides at my parental house. Quite often, my lord, I visit, my lord, my matrimonial home for taking any, my lord, necessary belongings or something like that.
Then it
To
is
avoid
broken down irretrievably.
to avoid, my lord, the quarrel. That was mutual arrangement, and the husband also sometimes came in my in-laws house, my lord, my parental house. Now, my lord, if your lordship takes up paragraph 12.
Your problem was with his parents or your in-laws?
Lord,
No, with the husband himself also.
Lord, initially, Lord, the explanation that has been canvassed, my lord, that main trouble is in-laws.
But also the husband.
regarding the
party-
husband, my lord, the proper maintenance was not provided. He was not taken care when, my lord, I was
Opposite
pregnant.
party started physical and mental torture.
That is, my lord, the police complaints were lodged, but thereafter, my lord, by the intervention, I said, my lord, that paragraph 11 also I said, by the intervention of the police authorities, dispute between the petitioner and opposite party was resolved for the
What
time being.
remains in the marriage, Mr. Mukherjee?
My lord, today, my lord, I loses. My lord, apart from stigmatic and all that thing, my lord, your lordship kindly consider there's a future of my child. I could not able to contest the suit. My lord, I have other avenue to venture. Had it been a case that the summon was served, my lord, it's something which was done behind my back. I loses, apart from whatever stigmatic remark, my lord, I have, my lord, the husband pleaded that I renounced from her, my lord, from his my lord, life. My lord, it's not that. The really the, my lord, matrimonial tie was not broken. He used to come to my parental house to avoid the quarrel, my lord. That was a mutual arrangement behind my back in the year
There is so
2020.
much quarrel, you cannot live together, Mr.
In
But
the
what happens to
in-laws,
the
in
conjugal
in-laws
life?
house. Well, I really say, my lord, today, if he is not really, my lord, he has not remarried. I do not know what is, my lord, the, my lord, reconciliation chances. I cannot say that before your lordship, but I can, my lord, what I little, my lord, inquired from my advocate on record. I have other avenue regarding the security of the future of my child, a male
That
child of
remains.
yes. So
That
that's
still
why
remains. You can file section 26 any point.
section 20.
So 25 any point of time.
My lord, that's where, my lord, today an ex parte decree is passed wherein, my lord, it has been, my lord, said that I have, my lord, your lordship knows 125. If ultimately a suit, my lord, is being decreed on the ground of
Section
desertion,
25,
my lord,
permanent
that is,
alimony.
my lord, permanent. Now my child is 9 years of age. A male
Permanent
child of
alimony?
9 years, my lord, your lordship consider I have to, my lord, nurture my child.
No, that's your choice.
Yes,
Actually.
my lord, I am.
You have a right to have that choice.
Now, my lord,
Yes.
paragraph 12, my lord, I narrated that after that reconciliation, my lord, paragraph 12, that it is unfortunate since from the opposite party never spent any money, my lord, towards the maintenance of the wife and child. Most of the time, the petitioner stays in the parental home along with the child on the advice of the opposite party. So, there would be no further dispute cropped up between the petitioner and her in-laws. Subsequently, the petitioner used to stay in her matrimonial home for some limited period of time and again come to the to her parental home. On the other hand, the opposite party also visit the parental home of the petitioner as per his availability. That suddenly on 21st of March 2025, when the petitioner went to his matrimonial home, the opposite party refused her, along with her son, to enter into the premises as their marriage was dissolved by the court's order. Upon hearing such unwilling event, the petitioner became perplexed and immediately informed her father. Upon searching, it was revealed that by virtue of the judgment dated such and such, that is, my lord, in 2022, and the decree dated such and such, the passed by the learned such and such, in matrimonial suit number 218 of 2021, the marriage between the petitioner and the opposite party was dissolved by virtue of the ex parte decree in favor of the opposite. The petitioner assured to such information for the first time by virtue of the certified copy delivered on 21st of April 2025. Thereafter, my lord, sometime mental depression. Ultimately, my lord, on May 2025, the petitioner met the learned advocate of the court premises, where the learned advocate requested him to come to chamber on 25th of May. 25th of May, my lord, I tried to contact, but the clerk informed that 3 days the learned advocate is not available. On 27th June, ultimately the petitioner contacted, and the first week of July 2025, the petitioner met to the learned advocate. 5th of July, and the learned advocate advised them to bring the marriage certificate and other relevant
Why did
documents.
you file an ordinary rule 13 application?
Today, your lordship knows now the scope and ambit.
Ordinary rule 13 is
Scope and ambit of the appeal. Now the Honorable Supreme Court is saying these also can be taken as a ground. Yes, that no, my lord, your lordship is absolutely right. Order 9, Rule 13, if I can go and succeed, my lord, everything can.
Easier.
Yes, that I can also.
Anyway, let us see.
Now, my lord, ultimately, after filing of such application, the learned advocate advised the petitioner to file appropriate appeal. Before the 125 was initiated in the meantime.
Informed her about such costs that she took some time to collect the money. That is not credible from any of you. I am speaking of all
Yes,
three of
yes,
you.
I understand.
You would not charge so much that she would take some time to collect. Anyway.
Now, my lord,
That is the usual thing. This much we
Puja-
understand.
yes.
So when was it filed ultimately?
Ultimately, my lord, it was filed
October.
uh,
No, not
in
even
3rd of November 2025. Puja vacation intervenes in the meantime, July.
Puja vacation will not get benefit
No.
because it expired before that.
That also I
March you knew and November you filed.
no, my lord, I contacted ultimately the 125, initially 125 application filed.
Came to know on
The-
March 21, 2025.
Yes.
And you filed this appeal in November 25. After
Because, my lord, in
8 months.
Why, my lord, this I have stated. Initially 2 or 3 months from mental trauma. Thereafter, ultimately, I contacted the learned advocate in July.
So easy to say
And-
mental trauma, Mr. Mental trauma of such nature, I mean, you could not contact your advocate. Is there any treatment of mental trauma?
No, my lord, it's not.
Any anti-anxiety drug, over-the-table drug during that period?
That is not there. That is not there. But this 8 months, my lord, I have explained that it's a lady, my lord, who is coming to an advocate. He is asking that you bring the certified copy 125 filed. Ultimately, advise the appeal has to be filed. I, my lord, under the, my lord, financial stringency, I also took some time to arrange money, and thereafter, ultimately, this has been filed. Altogether, my lord, this 8 months is being explained in such a way. And my knowledge was not there. I say I never received summons. So that is one of the issue. Now, how this has been dealt with, my lord, in their opposition, but kindly takes up their opposition.
Alford, before passing expert degree, must have found that summons was served.
That, my lord, at the COVID time, your lordship knows, my lord, it's
What
2021, the suit was instituted. So, my lord, your lordship knows up to 2022 March, the benefit of COVID was there. The court virtually was not functioning. So, my lord, this was done, my lord, the ex parte decree was passed in May. Sorry, my lord, in March. In March. So, my lord, the disruption of
Session
court
started after March.
Yes,
They
that's
revived
right.
after March. So you could get only from 4th to.
No, I am not asking, my lord, the entire, I say the entire, my lord, the gamut of the action was
That
done
was the
during the
fag end
COVID
of the
period.
fag end of the this
Second wave
lockdown
is
period.
2021, my lord, and ultimately it stopped in March 2022.
In March
By that
21,
time, the
degree was-
decree passed.
Yes, not by that time. In March 2022 itself, the degree was passed.
2022. So, my lord, the entire episode was within the period of COVID. I say that.
That does not help you much.
Yes, my lord, because my case is non-service of summons. My lord, kindly.
In case that due to COVID, no summons was served on you.
I say I never received, my lord. I never received summons. Kindly now takes up, my lord, their opposition.
Yes. Good judgment.
Lord, kindly takes up paragraph 14 straight away, because my explanation really starts from paragraph 12. Now, paragraph 14, they have dealt with my paragraph 11 to 13. Lord, kindly takes up, my lord, the last 4 line from the bottom of that paragraph. It is stated that since, has your lordship got it? Since September 2018, the petitioner is staying at her parental house, and despite repeated attempts of the respondent husband, the petitioner did not return to her matrimonial house. Now,
Mr. Amadi, take your seat. Yeah, okay. You can also take your seat if you want. Yes, you have a seat. Yes. Yes.
Lord, kindly takes up, my lord, now paragraph 15. Paragraph 15, it is submitted that since 2018, the petitioner has never come to the house of the deponents. It is submitted that the petitioner has not visited the matrimonial place. It is a concocted and manufactured story where is the petitioner wife in the June 2018 left the matrimonial house and started residing at the parental house of the petitioner wife, and since June 2018 the opposite party, being the husband, continuously used to visit till COVID pandemic, and on every occasion has tried to bring back the petitioner wife and their son, and on every occasion they refuse to come back. Now, Lord, the petitioner has have not stated or given any explanation with regard to why she did not visit the matrimonial house or tried to contact the respondent husband from 2020 to 2025. Moreover, the petitioner's wife is a psychiatric patient, psychiatric patient, and as such never bothered to contact the husband. Now, my lord, kindly takes up the paragraph C also. it could be evident from the records of the matrimonial suit that the respondent husband, as many as 4 occasions, has tried to serve the copies of the suit of the petition to the petitioner wife through registered post such and such, which was returned as refused. Now, the affidavit of service was filed. Subsequently, on 7th of January 2022, the learned district judge at Chandannagar kept the matter for expertise. The learned district judge at Chandannagar recorded the evidence of the respondent and on the very same day was pleased to pass an order dated 4th of March 2022. Now, my lord, so, my lord, with regard to my assertion that I very occasionally went to my in-laws' house and the husband used to come, I say, my lord, now today your lordship in section 5 has to deal with a balance because I made out a case. It's not totally falsified by the husband. According to the husband,
No, they
even
say they tried to serve copies.
no,
refused.
not the service of summons, my lord. It is the case of the husband also. He used to come to my house
No,
for the purpose of reconciliation.
Para C of clause C of para 15.
Yes, my lord. No, my lord, prior to that, kindly takes up, my lord, paragraph
Not that
50.
you are not interested in the previous husband going to you, you coming to husband, you are not interested. Regarding the relevant factors of your non-service of summons.
Yes.
15C.
That is his assertion that this has came back with the remark refused.
And he has annexed track reports and other things also.
So, my lord, I can argue, my lord, if your lordship, my lord, allow me, my lord, your lordship knows that if today at the COVID situation, some postal article, there are, my lord, 2 modes of service. My lord, I can argue before your lordship after amendment. Now, this was never the practice. This was after amendment of order 5. This was introduced that the postal, my lord, cost may be deposited. But in the proviso portion, it has been written, if the process server from the court is not gone there, it is, and the article is not delivered through post, then the court cannot acknowledge that to be a good service.
Let us see that provision.
Yes. CPC
520. The premise of your section 5 is also that non-service of summons.
Yes. But kindly takes up order 5 rule 9A.
Yes. Have either of you produced the order sheet of the suit?
Lord, order sheet, but in my memorandum of
it's a case that no summons was served.
Both of the copies are missing. Lord. We are unable to get the certified copy. Let him conclude. Not
now. Lord, may I place, my lord? The court may, in addition to the service of summons under Rule 9, on the application of the plaintiff for the issue of summons for an appearance of the defendant, permit such plaintiff to effect service of such summons on the defendant and shall, in such a case, deliver the summons to such plaintiff for service. So this is, my lord, what nowadays, after this amendment, we used to send, and postal, my lord, the slips is being deposited before the court with the report. Now, my lord, subsection 2, the service of such summons shall be effected by or on behalf of such plaintiff by delivering or tendering the defendant personally a copy thereof signed by the judge or such officer of the court as the case may appoint on behalf and sealed with the seal of the court by the mode of service as referred.
The amendment had been effected much before the suit.
I'm not on that. Not how, my lord, this can be, my lord, relied upon.
Why are you repeatedly saying now it has been introduced? It is
No,
there.
No, my
when
lord.
the suit was filed 10 years.
Yes, this can be done. My lord, I'm not on that.
Is the service of summons?
Subsection 4 is very important.
Yes.
Because they are relying upon, because they said that I delivered through this article. If such summons when tendered is refused, or if the person served refuses to sign the acknowledgement of service, or for any reasons for such summons cannot be served personally, the court shall, on the application of a party, reissue such summons to be served by the court in the same manner as a summons to the defendant. So, my lord, there is the rider. Yes, like today in our court, rules are not being issued. Your lordship has become liberal. That yes, you can do by your own. Your lordship is relying upon the affidavit of service filed by us. But in the Code of Civil Procedure, after introduction, 9 capital S up Rule 4, prescribe that yes, if you able to serve, very well. But if you do not able to serve, no acknowledgement, no refuse, only refusal, then the court will go back to Rule 9.
You have to see the order sheet. We have required to see the order sheet. Anyway, that would clinch the issue either against you or in your favor. So there's no
As per their opposition, it suggests that this has been sent by them and it has refused. So in my respectful submission, 9 capital A sub rule 4 will come into play.
That has also been done subject to lordship kind sanction.
That what I do not know, I cannot assist your lordship on that because I am only relying upon their. Now, in my reply also I repeated this.
Repeated?
In my affidavit of affidavit in reply, I dealt with their paragraph 15, which your lordship has just now I have placed, including all the sub paragraph at page 5, paragraph 12.
Again, no money and.
On the contrary, your lordship kindly takes up the
same story.
Yes. 10th line from the top of paragraph 12. Yes, I stick on that because I say if today, if
section 5.
No, what if my knowledge is not there?
No, you have said he did not go to.
No, they have tried to falsify the event that there is no occasion for me to visit my in-laws' house sometime in 2025, which may gives rise to a factum by virtue of which I came to know about.
Is it credible that they obtained a decree in 2022 March and they permit you to go there several times and only after 3 years?
I never say after this COVID I was never visited.
Forget COVID. COVID ended. COVID moratorium also ended.
Thereafter
March 2022.
According
from March 2022, they obtained a decree in March 2022. From March 2022, then you did not go to his place till 2025.
No, I have not.
Conveniently for that period only you did not go. Previously you used to go regularly.
No, I never say I used to go regularly. I say very often I used to go.
Very often is not regular.
No, not very often. Sorry.
More than regular.
I stand corrected. Not very often. Kindly takes up.
See what you use. Husband continuously used to visit till COVID
Most
pandemic.
of the time, the petitioner stayed as parental home along with her child on the advice of the opposite party so that there would be no further dispute cropped up between the petitioner and her in-laws. Subsequently, petitioner used to stay in her matrimonial home for some limited period of time and again come to his parental home. On the other hand, the opposite party is to visit the parental house of the petitioner as per his availability. That is my paragraph 12.
If you did not go for so long, it's broken down irretrievably. If you did went for this period and he did not inform you, that's not credible.
Today, I say my right of appeal, if gone, kindly consider.
Your right of appeal has gone. Now the current judgment, trend of the judgments of Supreme Court is your right of appeal goes. Merely for the sake of equity, we cannot help any party.
No, if this can be one of the plausible thing that I am explaining the delay. Today it's not. Today, if the case is totally falsified by them, then your lordship is absolutely right. But today,
because you also had an onus and the initial onus and the burden to show the order sheets that it was not just saying that a valid degree and expiry degree is a valid degree in the eye of law unless you rebut it. You have to show then the court from the order sheet. Going by the time period for which it was pending, not much. Must be very few orders.
Yes, very few orders. Has
to be very few orders.
Yes, it's not even more, not even a year.
Service return, yes. Yes, not even a year. Right.
Not even a year.
Right, not even a year. So 10 months ago. So service return for 2 or 3 days, maybe then his evidence and that date it was passed. So you should have brought before the court that would make it evident what was the finding of the trial court. And there is a presumption of correctness. And we can draw adverse inference if you don't produce the certified copy. Your case is based on non-service of summons. This is one aspect. The other
evidence part is being obtained, examination in chief and all that, but the order sheet. May I try and come back?
Certainly, and Mr. Mukherjee, it's rather surprising that you went there regularly. You are separated when? You are never separated. That's your case. So regularly you went or he
No,
came?
I never regularly went. Most of the time, I used to stay my parental house. Very, few time, it
No, you have stated that categorically that
it is the advice of the petitioner, no further dispute cropped up to in-laws. Subsequently, the petitioner used to stay in her matrimonial home for some limited period of time. That is after 2018, because the police incident happened in 2018, 30th of April 2018. Thereafter, upon the intervention of police, I say that the dispute resolved for some time. But we decided that I will be residing with my son to my parental house.
By the intervention of the police authority, a dispute between the
petitioner and the opposite party was resolved for the time being,
and the parties again started living together
in the matrimonial home. Then it is unfortunate, since from then the opposite party never spent any money towards the maintenance of his wife and the child. Most of the time, petitioner stays in the parental home along with his child on the advice of the opposite party, so that there would be no further dispute cropped up between the parties.
Subsequently, the petitioner used to stay in her matrimonial home for some limited period of time and again came to her paternal home.
On the other hand, the opposite party is also visit the paternal home house of the petitioner.
So you visited during this
at
time.
Least not from his opposite.
He had a decree in 22. Then between 22 and 25, he continued this visit, and you permitted you to go without intimating you that no, you are not my wife anymore. He did it suddenly after 3 years.
Because my assertion that I went to my in-laws' house to bring back something, some interests or clothes, and they said no, you will not be permitted to enter because I am obtained a decree of divorce. That is my case.
Let us hear Mr. Amit. Yes. Then if necessary,
And
we'll
if necessary,
we'll ask for that.
Since the only point which my learned friend has raised, that the service was never, the summons were never served. That it is a case that on twice she has refused the service. Then my learned friend has placed rule 4, subsection 4 the court we have made an application before the court we deposited the amount, and court served a notice upon them. Despite the difficulties, we intended to get the certified copy of those particular order and the other things.
Application, order, we have nothing before us.
I was beseeching your lordship to call for the records, because that order sheets are also not available. Because
we call for the records, then we allow the section 5.
The difficulties, the records are not available in the trial court. I have applied for certified copy twice, but I am not getting it. Only to satisfy your lordship, that is the reason on the last occasion I took adjournment also, because I know this is coming, that they will say that they have not received the summons, but ultimately it is the court satisfaction, court records the satisfaction, it was served through the court.
So, Mukherjee will call for the records even for the purpose of section 5.
Yes,
and we say that section 5, if we
I'm injuncted
for the
already.
Yes, if we allow the section 5, immediately after the ground is same.
Yes, I am now lordship is hearing my appeal. So I am not agreed by anyway.
So we may say that Mr. Mukherjee that and Mr. Amit that this will give our reasons, since the points involved are the same in the appeal and the application, will take up both together, and we call for the records.
That will clear the picture.
Yes.
Otherwise, I'm injuncted. I'm not. I've been already injuncted by lordships.
The present appeal arises out of a divorce decree passed in favor of the respondent husband against the appellant wife on March 4, 2022. Full stop. Can 1 of 2025 is an application for condonation of the delay of about 1249 days within bracket roughly 3.5 years bracket closed in preferring the appeal. Full stop. Upon hearing learned counsel for the parties, the court finds that the plinth of the cause sought to be made out in the condonation application is that no summons of the suit was ever served on the appellant stroke petitioner. Full stop. Next para. During hearing, it is evident that the records of the suit are essential even to adjudicate the adjudicate on the grounds taken in the condonation application, in the light of the allegation that no summons were served at all, to ascertain which the trial court records as well as the orders of the trial court would be necessary. Full stop. Next para, in any event, comma, we find that the short ambit of the appeal also revolves around the non-service of summons, alleged non-service of summons, and as such, comma, the grounds involved in the appeal as well as the condonation application are the same. Full stop. Accordingly, we direct can 1 of 2025 as well as can 2 of 2025 to be listed along with FAT 488 of 2025. Full stop. Now, comma, subject to being mentioned by the parties. Full stop. Next para. In the meantime, comma, the trial court records shall be called for by special messenger at the cost of the, you pay the cost, you're the husband, at the cost of the respondent.
Only request, Lord. Your Lordship would kindly fix a date, Lord. It's not far.
To be deposited within within a week from date. Full stop. Next para. The respondent shall prepare and file the requisite number of informal paper books without comparing with the records. We cannot prepare that.
Yes, Lord. That's the reason.
Within 6 weeks from the
Lord,
date
may I
of
beseech one thing? May I beseech?
within 6 weeks from the within 4 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the parties for the respondent.
Lord,
Yes.
Lord, I was beseeching your Lordship, Lord. Your Lordship would kindly make this returnable after 4 weeks. But then your Lordship will decide.
Which court? This is which court?
Chandannagar, Lord, not far.
Very far.
Just Lord, an hour. Lord, I'll
We
pay
can
this.
appoint you as a special messenger. You can bring the
Lord,
record.
I will pay this
Otherwise,
special passenger cost.
Payment won't do. Nowadays, payment won't.
Kindly do not.
Everybody pays special messenger.
I'm
In
already
every matter we are directing.
already suffering an injunction, Lord, by your Lordship, Lord. So
And
kindly,
in any event, he
it's not
cannot
Lord-
also prepare the paper book until the records come.
That's the reason, Lord. I was
That
beseeching.
order sheet has
Kindly make it returnable after 4 weeks. I'll pay the deposit.
Meaningless.
It will reach, Lord. It's not far, Lord. I
No, that's why we have.
That is the
kept
only
app-
request, Lord. I'm
you
making.
mention it as an application,
That-
and when it comes up under the heading application, you give us a surprise by reminding that the appeal is to be taken up along.
The difficulty is, Lord.
Suppress that when you mention.
I cannot
too often. Many of you do. So when we direct appeal to be heard along with the application, you never say that while mentioning the application. You always say
Let
application.
the matter returnable be after 4 weeks, Lord.
No,
Kindly do
after
that.
4 weeks, nothing will happen. We have given you liberty.
Because he is not going to exercise the liberty, Lord. He is not going to exercise the liberty.
Obviously, you. Obviously, you.
Lord, I'll come back, Lord. Then I'll remind the Lord.
Come back. You put in the special messenger cost, if possible, by tomorrow, so that
Lord, I'll do.
So that it comes quickly.
Obliged, Lord. Deeply.
Grateful. যদি অলরেডি করে সমস্ত সার্ভ হয়নি বা হয়েছে তাহলে অ্যাপিলে কি করবে নেক্সট
Lord, I beg to appear for the appellants, my lord.
Yeah, and thank you very much for the courtesy. You left the seat, we saw that, for those counsel. We appreciate it very much. Yes. Yes.
My lord,
You're Mr. Chakraborty?
My lord.
Yes. What is the matter?
My lord, there is a delay of 91 days in filing the appeal.
Have you served copy?
I have not, my lord.
First time? Appearing for-
Yes, my lord. First time.
So you serve copies?
Much obliged. Along with the injunction application, my lord.
Yes, yes. What is the number of the injunction appeal?
Can 1, my lord.
Injunction is can 1. Can 2 is section 5?
Section 5 is can 2, my lord. Filed today only, my lord.
Today?
Today only, my lord. That,
Learned counsel for the appellant submits that a condonation application bearing can 2 of 2026 has been filed only today. Full stop. We deem the same to be in the days list and direct the appellants to serve copies of can 1 of 2026 as well as can 2 of 2026, as well as a copy of the memorandum of appeal on the respondents, indicating that the applications shall next be listed for hearing in the monthly list of April 2026. Full stop. The appellant shall file an affidavit of service to that effect on the returnable date.
much obliged.
Item number 9.
I'm appearing for the.
First, there was a wrong recording of the order. We'll correct that and then. In the order dated March 5, 2026, comma, the date of the order was erroneously recorded as March 5, 2025. Full stop. Let such error be deemed to stand corrected by reading
March 5, 2025, March 5, 2026 instead of March 5, 2025 in the said order. Yes. What is the matter?
Yes, Malad, in this matter, this is a suit for partition. Lordship was pleased to direct us to serve, Malad. Malad, we have tried to serve, Malad. This is my affidavit of service, Malad.
That means what is?
No, we have. Lordship will kindly see, Malad.
How many parties?
Malad, 48. But Malad, this is a suit.
You have to wait for some time. If 2 more can be added, then you will have a half century. So you will spend more in
Malad, yes, yes.
copy service than
For that
advocate
reason, I
fees,
took an adjournment
court fees,
from
take
the
it together.
Lordship.
You're for the other side.
Yes, no, he is assisting me Malad, in this matter. Malad, Lordship will, Malad, on last occasion, Lordship was pleased to Malad, grant an order of injunction only in nature and character.
Have you been able to serve on all?
Service, Malad, somebody, has returned, Malad. You have 4 returned, Malad.
Prepare a chart which have returned and not.
That is, I'll try.
Prepare it. Come back on Monday. Affidavit of service filed. Have you got a copy of the affidavit of service?
Yes,
Affidavit of service filed to be kept on record. Full stop. Next para. In order, we request learned counsel for the appellants to prepare a short chart to ascertain as to which of the respondents have not been served, as well as to which of the respondents you are the plaintiffs in the trial.
No, I am the defendant, Malad.
All the respondents are plaintiffs.
Yes, yes. No. But some of the plaintiffs and some of the performers.
And which of the respondents did not
contest? 1 to 17 is
listen to our order. Listen to our order.
Yes, yes.
And which of the respondents did not contest the suit in the trial court?
Yes, yes.
So you prepare a chart, 2 columns. One is these have been served, not served, and the other not contested. We want a list of the not contested, so that we can dispense with service on not contested. All this a partition suit, keeping in with the number.
Yes, sir.
We will dispense with service on them, and regarding the others, you
see the chart and not
see the chart and like a Venn diagram. I mean, the common overlapping thing. We have not been served but contested. We'll direct you to serve. Let the matter be listed under the same heading on March 23, 2026. Monday.
23, I have some problem.
24?
24, no, 23. Well, 23 is the Monday. Lordship is fixing on Monday, my lord. Yes, on the Monday I don't have problem. But I was thinking about Tuesday, my lord, 23.
23rd is Monday.
Yes. Then
your learned friend can come with the chart. You can come with the chart. Injunction, nobody will miss a fee. Yes.
Item number 10.
Yes, 10.
Item number 10, Malad, I am for that.
Yes.
When it is that up, yes, Malad, served. This is my
good service.
Good service. This is my affidavit of service.
What is the matter?
This is a matter, my lord, in which, my lord, the already an order was passed. The day when the impugned order was passed, that day, my lord, appellant died. So the order has become, my lord already passed an order, but since there is a condonation of delay application on 13 January 2026.
You recall that order?
My lord,
yes,
because there is a direction for paper book.
Section 5, where is the section 5?
Can 2, my lord. It was filed on 4th of February 2026.
What is the delay and what is the reason for that?
The delay is 62 days, my lord. I annexed the medical document also, page 7, my lord. The appellant was a senior citizen and he was, my lord.
Appellant was senior citizen?
Before the, my lord, no, my lord.
Before filing of the appeal, he was senior citizen, now he is 55?
No, the appellant, my lord, he was suffering from some medical, my lord, problem, my lord. But I have paragraph 5, paragraph 6.
You're confusing with some other section 5 which you are moving.
Paragraph 5 and paragraph 6. 62 days delay, my lord.
Affidavit of service filed to be kept on record. Despite service, none appears on behalf of the respondent. So as such, we take up the applications for hearing expertise. Footstep can 2 of 2026. You have served copies of both the applications.
Both the applications. No, can 1 already served, can 1 already disposed of.
Oh, can 1 disposed
of?
Disposed of, but that was recalled.
That was recalled, man.
Yes. Can 2 is an application. Can 2 of 2026 is an application for condonation of the delay of about
62 days.
62 days in preferring the appeal. Footstep next para. We find from the materials annexed to the application and the pleadings therein that sufficient explanation for the delay has been furnished inasmuch as the appellant was suffering from ailments during the relevant period. Footstep accordingly can 2 of 2026 6 is allowed, comma, thereby condoning the delay in preferring FMAT 513 of 2025. Full stop. Next para. Learned counsel for the appellant points out that we had admitted the appeal upon giving elaborate reasons, and had also disposed of Can 1 of 2025 by our earlier order dated March. This is 18 or 13?
13, man.
It's merged.
Jan-
13.
January 13, 2026.
Sorry, dated January 13, 2026. So, sub next para. However, when did you recall?
It was recalled on 2nd of February 2026.
However, comma, subsequently, the said order was recalled on February 2, 2026, when it was detected that the appeal was time barred and no order could be passed unless there was a valid application for condonation of delay, and the same was allowed. Full stop. Next para. In view of the above order, whereby the condonation application, comma, filed subsequently, comma, has been allowed, comma, we reiterate the ratio laid down in the order dated January 13, 2026, and admit the appeal to be heard on the questions raised herein. Full stop. For the sake of propriety, comma, we record such reasons as follows, colon diye. Now, we quote such reasons from the order dated January 13, 2026. প্যারাগ্রাফ 3 থেকে এই অর্ডারটা প্যারাগ্রাফ 3 থেকে ইলেভেন পর্যন্ত পুরোটা কোট করে দেবেন। হ্যাঁ, আর তারপরে
Only one thing, my lord, I have already put in the special messenger cost. That is,
since we are apprised that learned counsel, since we are apprised that the appellant has already put in the special messenger costs, comma, the aforesaid order is deemed to be a part of this order, sans NS, the direction to put in special messenger costs by the appellant. So this is made a part of this order. The same order will copy paste the relevant paragraphs, and you carry on with whatever. The rest of the order remains because we are copy pasting and making that a part of this order. Instead of repeating the whole thing.
Deeply.
এটা উপরে দিয়ে দিলাম, মেঘনাদকে এটা দিয়ে দিলাম। পুরোটা দিয়ে দিলাম না?
I'm extremely sorry that it was erroneous on my part that.
No, we also committed the same error. We also admitted on the presumption that it was not time.
Deeply.
Yes.
Number 11.
Same order our time waste.
So I am appealing with the appellant lawsuit.
Yes, Mr. Das, what is the matter?
Lawsuit, last original lawsuit was directed to serve the copy of Can 1 and Can 2.
Not served?
Yes, all the service was completed, but appellant respondent numbers 5 return back with postal endorsement deceased. 5 call. Deceased. Son already on record.
Son on record. Son is only here.
3. Then 3 respondent number 3 is the son already on record.
There is no other heir. Otherwise, you have to impute the other heirs.
To that extent, require some.
So unless that is done, how can you proceed with this
lawsuit?
Affidavit of service filed today be kept on record. Full stop. However, comma, learned counsel for the appellant submits that from the postal track reports, comma, it was found that respondent number 5 has died in the meantime. Full stop. However, comma, learned counsel contends that the son of the deceased respondent number 5 is already arrayed as a party to the present appeal.
Respondent 3.
Being respondent number 3. Full stop. In order to enable the appellants to ascertain as to whether
the deceased respondent number 5 has left any other heirs than the respondent number 3 and to take appropriate steps in that regard, comma, we adjourn the matter till April 13, 2026, April 13, 2026, when it will next be listed under the same heading. We are giving you time till April 13. You ascertain.
And file an appropriate application.
If you find that others are there, you file an appropriate application.
If you do not know, yes, there are expunge application
You
or
know what to do, yes. This arises for partition suit, no?
partition suit.
Partition suit then will be much liberal in that substitution also, even if it's beyond. It's in the nature of an addition of partition.
Yes.
Because already one of the heirs is also on record.
Already on record and preliminary
So we just require a formal application, but all have to be implemented.
Challenging a preliminary degree alive against
Yes, you just implement those people.
Loss.
Item number 12.
So I'm for the petitioner respondent.
Yeah.
This is my present
Only one respondent, so served. He's appearing also. Yes.
present petitioner before lordship filed a suit for divorce, suit for dissolution of marriage, and that has been decreed, my lord. That they preferred an appeal. Your lordship, I file this application for early.
You are for the respondent.
I am the respondent.
Early hearing.
The early hearing, my lord. But since the present petitioner before lordship is 27 years old guard, my lord.
27.
27 years. During at the time of studying in college, they met each other, and marriage was. Marriage certificate was issued.
We send it for mediation. Let
it send the mediation. Well, this
will
has
be very
been,
happy.
this has been happened.
Very happy to 2 months lost, and then we don't.
My lord, I tell you, lordship, this incident has happened on the due to the pressure of the father of the my lord, the married guard. My lord, this has been CRPF employee.
Whose application is this?
He has filed an application.
Let him move the application. Yes.
My lord, the present petitioner before lordship is a 27 years old girl, my lord. During the college.
We won't go into the entire story. What is it?
No, my lord, filed on the ground of fraud.
Directly to prepare paperwork.
Yes, my lord.
You don't want
my lord, informal paperwork, my lord. It is very short.
You have all the papers. Evidence?
Yes. Evidence, entire evidence, decree, judgment, entire. Informal paperwork, my lord. Kindly fix it any day.
Were there exhibits also?
No, my lord. They
produce those also.
They produce 2 exhibits on CD.
So those are also required.
Well, I play the messenger first. Exhibit, my lord, material exhibit, my lord.
The present appeal has been preferred against divorce decree obtained by the respondent wife, comma, by the appellant husband. Full stop, next para. This application is for expeditious hearing of the appeal at the behest of the respondent wife, full stop, keeping in view the young age of the couple, comma. What is your age?
My age, my 27.
You know, my lord, he is a 37 years old. I am 27 years.
Young age of the within bracket compared to us. What do they mean? Young age of the couple, comma, and keeping in view the nature of the litigation, which is a matrimonial matter, comma. This court is of the opinion that expeditious hearing is required. So accordingly, can 1 of 2026 is allowed, thereby directing the trial court records to be brought by you are directing the records to be brought. Trial court records to be brought by special messenger at the cost of the respondent, comma, to be deposited within a week from date. Full stop. Upon arrival of the trial court records and the same being examined and found to be complete, comma, due notice of arrival of the same shall be served on both the appellant and the respondent. Full stop. The respondent shall prepare and file the requisite number of informal paper books without comparing with the records within 4 weeks thereafter.
Yes, madam.
Full stop. Next para.
I'll kindly fix it date, madam.
We have granted injunction.
No. I have not filed any stay application.
You want her to remarry? You remarry in the meeting. Granting you leave to remarry in the meeting. You have got a divorce degree. He has not filed an injunction. So why don't? আচ্ছা যা বললাম সেটা
everything I have narrated.
Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. But in the meantime, why don't you send you for mediation? I mean, if possible, then have it.
No, your lordship, kindly hearing the matter, my lord. My lord, kindly fix a date.
My lord, kindly go through the evidences. Kindly go through the evidences what they have been laid.
We cannot
put the
fix a
CAL
date now. We are too hard pressed for that. No, but we have already directed you put in the special messenger cost, whatever the law will take its course. But in the meantime, why not mediation? We're directing it for mediation. In the meantime, comma, since the matter arises out of a matrimonial proceeding, comma, the matter may be the same is sent for mediation to the Calcutta High Court Mediation Committee. Full of the records of the matter be immediately sent to the said committee for such purpose. Full stop. Liberty is given to the parties to mention the matter in the event mediation fails. Let this happen in the meantime. You put in the special, let the records come, you prepare the paper, do everything. Mediation will take at best 1-2 months maximum. So within that, I mean, they may also agree to this.
But the can is pending.
Can dispose of করে দিলেন তো
Can dispose of?
Can dispose of করে দিলেন
Can is for appropriate this expeditious hearing. You have disposed it. Otherwise, how could you pass the directions?
Liberty to mention.
Yes, next.
Item number 13.
I'm for the appellate part. আশরাফ কি করেছি সেদিন সবরে বেশি এক প্রথমে যে ওই এরারটা 2025 বলে রেকর্ড করে ইয়েস ওটা দিয়ে তারপরে ইয়েস ইয়েস
it arises out of an order passed by civil judge on a reference made under section 3 capital H subsection 4 of National Highways Act.
I've never heard of it. This was
apportionment.
Actually, section 30 of the Land Acquisition Act.
Yes.
Compensation.
Apportionment of compensation.
Now we did.
As per section 30 of the Land Acquisition Act.
Now there are three divergent views at present. Or I have kind of.
No, we also have.
Landed appeal issues.
The West Bengal Highways Act?
No, it's a National Highways Act. 1956.
The West Bengal also has a Highways Act.
Yes. Bengal Highways Act. 1964.
Yes. This is under National.
1956.
Which section?
Section 3 capital H subsection 4.
This matter was moved previously?
No.
Because we have that provision underlined. Yes.
Before my learned friend starts, well, there is a defect.
Yes.
That is
What
because defect is regarding the amount value what will be the valuation of the appeal. Because in the section 830 we used to that amount paid for and awarded. Difference is the valuation of the appeal. But here is no such. There is degree the order from the order itself. It does not appear what is the amount granted or the amount refused. So that is the problem because
in reference is silent about that. Even the judgment.
You are what? The land loser.
He is land loser.
He is claiming a portion of the fight between.
It's about structure. It's about payment of structure.
You are also one of the land losers.
Yes. Now who has constructed the structure?
Apportionment. Neither the reference petition nor the judgment only speaks about any amount.
Directed to assess. Petitioner is directed to assess means?
Petitioner means one of the project National Highways Act project director. Because it is his petition. There was his petition. Kindly come to page 23 of my stay application. That was filed by the ADM, a competent authority filed that petition. So he was the petitioner.
Oh, competent authority shall refer the
Yes.
Refer the matter as per the land acquisition collected.
The assist the announcement.
And before that, my lord has to decide whether the appeal maintainable or revision.
What are the provisions? Let us see.
Malra, we got divergent view on this, Malra.
Now it is better.
Yes.
Which is the provision of appeal?
There is no.
No.
Then how
no provision for appeal in the statute.
If you lost
appeal is a feature of statute, then how can you file an appeal?
Kindly. This aspect was taken into consideration by Division Bench of Andhra Pradesh High Court.
Andhra Pradesh, our High Court, any judgment?
I couldn't find out.
Then don't forget. Hand side.
Due to the
I also could not find out any judgment.
You are more interested for the timing in the judgments which hold that appeal is maintainable.
No, well, both well, I got in one Supreme. এটা হচ্ছে তোমার সুপ্রিম দিয়ে বলে সুবিধা 2025 সুপ্রিম এপি
এপি
498 2025 in that.
So, decree under CPC. Any of the provisions of the statute say that the
No.
Statute is silent regarding
that the code of civil procedure applies or anything like that?
No.
Unlikely in the Land Acquisition Act, my lord will find the civil procedure code will
Some
apply.
provisions have been applied.
But here, my lord, only thing, my lord, if your lordship can takes up the statute once.
Land Acquisition Act din to ekটু Land Acquisition Act din
না না just Land Acquisition Act না না আমি দেখাচ্ছিলাম
appeal to picture of statute. It is well studied. এটা তো লিমিটেড পারপাস এটা অ্যাপিলের পারপাস না বিক্রি কি করে হবে
I, my lord, will lordship find that is a competent authority's jurisdiction only.
That my lord father also pointed out, but that does not confer appellate power.
Yes, my lord, only for the limited purpose, summoning and enforcing the.
And here, under the Land Acquisition Act, the reference judgment is
Appellable under 54.
54, not only that, reference is before a civil court.
Yes.
It acts as a civil court. And
But here it says, my lord, CHY dispute arises as to apportionment of the amount or any part thereof, or to any person to whom the same or any part thereof is payable. The competent authority shall refer the dispute to the decision of principal civil court of original jurisdiction.
And Section 54 of Land Acquisition Act is subject to provisions of CPC.
Yes, that is
applicable to appeals from original decrees, and notwithstanding contrary, an appeal shall.
As if that is the original court.
CPC is applied directly.
Yes. And
applicable to appeals. An appeal shall only lie in the proceedings under this act to which to the High Court from the award of the court and from any degree of the High Court. So 54 is very specific. There is no such provision.
No such provision in the.
Let us see Andhra Pradesh High Court.
And Joseph, Andhra Pradesh, I mean, Kerala High Court, there is the same judgment, division bench judgment holding 227 is.
So first, let him finish his judgment.
Yes.
Kerala versus Andhra Pradesh now.
Kerala versus Andhra Pradesh.
And one Supreme Court judgment, it discusses many things.
But
this
ultimately,
says there, apart from this,
apart from there is no.
It says there must be an uniformity. We are recommending it for Law Commission in case of Petroleum
that
Act.
means there is no provision.
There is no provision. That is why.
Well, we are leaving it upon your lordship.
Side the Supreme Court will.
I am handing it over Mal, because it's
Ignore all the
reportable.
others.
It's a reportable. It's not.
Okay.
What is the logic of the Andhra Pradesh?
They say, but since
The rights are being decided.
the
Apportionment is a right to the property in respect of which the determination will be made. So title record to be considered that way. On that score, it was held that 96 will apply. Subject to question.
Yes, it's a deemed decree. So
But the Kerala High Court is of the opinion what is from lordship, it is not a degree.
Position that appeal is a creature of statute.
Yes, that is the
This appeal is specifically provided for in some statute. There cannot be any right of appeal.
And that is the Kerala High Court. What is followed from lordship? That is the Kerala High Court judgment. The degree, it is not a degree.
You cite your Kerala?
Yes. The then Chief Justice of our High Court was one of the author of this judge.
Aditya was an authority on this. See the size of the judgments?
Precisely, well, that was the point taken that it is not a degree in terms of section 2 subsection of the Code of Civil Procedure, and there is no provision for appeal in the statute. Therefore, the appeal is not maintainable. Kerala. একটা কোয়েশ্চেন দুটোই তো যশোর কিন্তু একটা আছে গেল কোথায় গেলটা কোথায় এলডি 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 সবই তো এলডি দিয়ে দিলাম গেলটা কোথায় গেল তো দিয়ে দিলাম যশোর ঠিক আছে দুটোই সবই এলডি লেকচার 2013 4 KLT page 612 2013 4 KLT 612 দেখো আমি দিয়ে দিচ্ছি আমাদের ওকে আমি এগুলো দিতে পারি না কটা
No, Supreme Court is in respect to a different statute.
Different statute, but it says well, when all these references are there.
Which reference? These judgments.
No, it's about the reference made by the competent authority in certain cases. Now, somewhere arbitration proceeding is there, somewhere something is there. So
That does not apply here, the Supreme Court. Not the specific statute we are speaking about.
page 30, paragraph 33, Mallory, to some extent says needless
Just
to
to add here, yes.
that in the process of determination of compensation, evidence will have to be laid by the parties unless statutory remedy of appeal is provided, where all issues of law and facts can be re-examined. Any other remedy may be illusionary as is noticed. Well, kindly have a look 226. But it says nothing. Now kindly come to page paragraph 36. It needs for uniformity in nomenclature of the cases. I must.
Yes, continue.
I must be candid, Your Lordship. I'm really confused. I'm really confused. When I filed this petition, my lord, once I
Obviously
asked my learned senior friend what would be the remedy, is it appeal or revision? He said, I am also not clear, but probably revision.
You have handed over the Kerala judge.
yes well
So if your lordship passes an order, that would be helpful for us in future.
Just yes. Just a question arises at the outset as to the maintainability of the present appeal. Which of next para, the appeal has been preferred against an order passed under section 3 capital H within bracket 4 of the National Highways Act 1956 bracket hereinafter referred to as the 1956 Act bracket closed. Which of next para, learned counsel appearing for the appellant hands over cites a division bench judgment of the Andhra Pradesh High Court in the matter of নামটা দেখে করে দেবেন Bollineri Srihari Rao versus Combe reported at 2025 Supreme within bracket AP 498 in support of the proposition that the adjudication of disputes under the said provision is a deemed decree and accordingly appeals would be maintainable under section 96 of the Code of Civil Procedure despite the act not explicitly providing for such appeals. Whose of learned counsel, in his usual fairness, also hands over an unreported judgment of the Honorable Supreme Court in civil appeal numbers 10882-10888 of 2025, bracketed Kolpoturu Power Transmission Limited versus Vinod and others. Full stop. Next para. In the said judgment, the Honorable Supreme Court, although in the context of the petroleum and minerals pipelines, bracket acquisition of right of user in land, bracket closed act, 1962, took into consideration several similar statutes, including the 1956 Act, where a dispute as to adequacy of compensation arises. First up, the Honorable Supreme Court, upon considering the said provisions, came to the finding that there were several anomalies in the provisions of law in different statutes in that regard, and observed that that these issues need to be examined by the Law Commission of India and the Ministry of Law and Justice, Government of India, so as to determine whether a statutory remedy of appeal should be provided against judgments stroke orders passed under the Petroleum Act. Full stop. Next para. It is submitted that, thus, the law is fluid on such count. Full stop. Next para. On the other hand, learned counsel for the respondent cites a division bench judgment of the Kerala High Court in the matter of Nafisa and another versus reported at 2013 Supreme Kerala KER close 569, where the Honorable Division Bench had observed that there is no provision in the 1956 Act which provides a right of appeal against the decision by the court on the reference under section 3H within 4, and such a decision is also not given the status of a decree, at least using a deeming provision. First of therefore, it was held, an appeal under section 96 of the Code of Civil Procedure will not lie. First up, next para. It was also observed that an appeal under section 104 of the Code also does not lie, since such a decision does not fall among those orders enumerated as appealable under the provisions of or under Order 43 of the Code. Full stop. Next para. The Division Bench also took note of section 105 within 1 of the Code of Civil Procedure, as per which no appeal shall lie from any order made by a court, that is to say, a civil court, in the exercise of its original or appellate jurisdiction, save as otherwise expressly provided. Full stop. Next para. Upon a careful consideration of the aforesaid judgments and the provisions of law, we come to the following conclusions. Full stop. In the 1956 Act, there is no specific provision of appeal against an adjudication under section 3 H within 4 of the said Act, although such adjudication is done by a principal civil court of original jurisdiction. Full stop. Next para. It may be noted that all orders passed by civil courts are not appealable. Full stop. It is a trite principle of law that appeal is a creature of statute, and unless specifically provided for in a statute, no appeal lies against any adjudication, be it in the nature of an order or a decree. Full stop. Next para. Section 2 within 2 of the Code of Civil Procedure clearly defines a decree to mean the formal expression of an adjudication which, so far as regards the court expressing it, conclusively determines the rights of the parties with regard to all or any of the matters in controversy in the suit, and may be either preliminary or final. Full stop. The decrees which shall be deemed to be included within the said definition have been specifically mentioned as rejection of a plaint and a determination of any question within section 144 of the Code of Civil Procedure itself. Full stop. Similarly, on the other hand, any adjudication from which an appeal lies as an appeal from an order, and any order of dismissal for default have been specifically excluded from the definition of the decree. Full stop. Next para. However, section 2 within 2 of the code operates within the parameters of the Code of Civil Procedure itself. Full stop. The use of the expression double inverted suit in section 2 within 2 clearly demarcates the zone of operation of the said definition, being restricted to a civil suit, adjudicated by a civil court. Full stop. Next para. In an adjudication under section 3H, capital H within 4 of the 1956 Act, although the same is by a civil court, it is not in connection with a suit as such. Full stop. If the intention of the legislature was to include an order under the said provision within the definition of decree as provided in the Code of Civil Procedure, comma, nothing prevented the legislature from specifically incorporating such an adjudication within the purview of the deemed decrees as provided in some cases, for example, rejection of plaint. Full stop. Next para, having not done so, comma, by specific exclusion, comma, such an adjudication has not been included within the periphery of a decree passed by a civil court. Full stop. In our opinion, comma, the ratio of the judgment delivered by the division bench of the Kerala High Court in Nafisa apostrophe S case is more apt and acceptable and tenable in the context of discussion. Full stop. On the contrary, comma, the division bench judgment of the Andhra Pradesh High Court did not take into consideration the cardinal principle of jurisprudence that unless specifically provided by a statute, comma, an appeal does not lie from any adjudication at all. Full stop. Next para, moreover, comma, we do not find anything within the four corners of either section 2 within bracket 2 or section 104 or order 43 of the code to bring an adjudication under section 3 capital H within bracket 4 of the 1956 Act within the purview of either a decree or a deemed decree or even an appealable order under the Code of Civil Procedure. Full stop. Next para. Thus, comma, the ratio of Kalpataru power supra, comma, with utmost respect, comma, is not tenable in the eye of law. Full stop. Next para. Although the anomaly recognized by the Honorable Supreme Court in Ravinath Tilha, কল্পতরু পাওয়ার যেটা বললাম ওটা অন্য হবে, ওটা হবে কল্পতরু পাওয়ারটা কেটে দিয়ে রবীনাথ তিলহারি না সরি বলিনেরি শ্রীহরি রাও, সরি কল্পতরুটা হবে, হি ওয়াজ এ জাজ, কল্পতরুটা হবে বলিনেরি BOLLINENI অন্ধটা
শ্রীহরি রাও।
আচ্ছা, আর এখন যেটা বলছি ইন, হ্যাঁ কি বললাম, Supreme Court in Kalpataru power supra cannot be brushed aside inasmuch as pari materia provisions in other statutes, comma, for adjudication regarding compensation is supplemented by a provision of appeal, comma, for example, section 54 of the Land Acquisition of 1894 and the like, comma, a similar provision is not found in the 1956 Act. Full stop. Next para, be that as it may, comma, by necessary implication, comma, even in Kalpataru power supra, comma, the Honorable Supreme Court accepted the view that there is no present provision of appeal in the 1956 Act, comma, which prompted the Honorable Supreme Court to recommend the introduction of such a provision in the said Act by the Law Commission of India / Ministry of Law and Justice, comma, Government of India. Full stop. Next para. In such view of the matter, comma, in the absence of any specific provision, comma, the impugned adjudication under section 3 capital H within bracket 4 of the 1956 Act is held to be not appealable. Full stop. Next para. Accordingly, FAT 533 of 2025 is dismissed as not maintainable. Full stop. Consequentially, can 1 of 2025 is also disposed of. Full stop. It is made clear, no orders to cost. Next para, it is made clear, comma, however, comma, that nothing in the above order shall preclude the appellants from exploring appropriate remedy available to the appellants in law against the impugned order. Full stop. Next para. For such purpose, comma, leave is granted to the learned advocate record for the appellants to take back the certified copy of the impugned order upon furnishing a photocopy thereof.
Extremely grateful.
Grateful to your lordship.
Affidavit service we kept on.
হ্যাঁ, প্রথমেই affidavit সার্ভিস করে। পিলহারিয়ার ওটা একটু সরি যেটা বললাম না বলিনি ফুলিনি ওগুলো একটু দেখে করে দেবেন হ্যাঁ আমি বড় করে লিখে দিচ্ছি কোনটা সুপ্রিম কোর্ট অন্ধ্রপ্রদেশ চট করে চোখে পড়বে এটা এপি কেরালা এই সুপ্রিম কোর্ট আমি লিখে দেবেন
When both of us were discussing outside this courtroom, there would be end of this confusion.
has to be
Otherwise, we are facing difficulties.
no yes
Great.
thank you yes next
Item number 14.
yes
For the respondent.
There is a direction to sub notice of the applications.
আশরাফকে বলে দাও ওই অর্ডারটা অন্তত 25টা অর্ডার এটা হয়েছে ওটা বলে দাও প্রথমটা ও লিখবে না এটাতেও আছে হ্যাঁ
Resolution of marriage. Marriage was solemnized under the Hindu Marriage Act. The decree was passed on 8th May 2025.
You are remarried?
Section, today is fixed for section 5.
Section 5.
Section 5?
Section.
What is the delay?
Delay to the extent of 105 days, my lord. In preparing appeal. Reason, my lord, after passing of the decree, my lord, she became disgruntled and was under mental stress and tension. What to be done? A false allegation has been made against her. Schizophrenia. That has been
contested degree.
Contested degree.
Right. I want to file opposition. Because of
oh, we are rejecting the application, but if you want to file opposition, then we'll enter it.
No, I have not heard it.
My lord, a maintenance proceedings is going on. My lord's wife initiated proceeding under section 125.
Why 125? If you dismiss this section 5, you can also take out section 25 in the decree, in the trial. This is not a. If you accept this ground, Mr. Ghosh, anybody and everybody will come after a deal.
My lord, degree was that ought to have been filed within 90 days, that is 7th August. Appeal filed on 11th December. My lord, reasons assigned in section 5 application, that is paragraph 18. No, always sincere and dutiful for proceeding with this suit. My lord, there was no laches or negligence in proceeding with this matrimonial suit. After all, decree was passed. My lord, she disgruntled actually, my lord. The false allegation has been made against her. Schizophrenia. Husband failed to prove this. Doctor was brought to the witness box.
Yes.
Doctor was.
He said that you have schizophrenia.
Yes. That allegation actually, my lord, she was suffering, my lord, serious mental stress and tension. What to do? What will be do? My lord, he contracted with the learned advocate.
In the suit, you did not suffer from that. You laid evidence.
I laid evidence.
So, when you got the copy of the plaint, at that point also you must have got the shock that these allegations.
I expected that husband will prove this case, but doctors was brought to the witness box.
You are so shocked that you could not for over 100 days you could not prefer an appeal after getting the decree being passed.
Actually,
during pendency of the suit.
I have stated in my application. She is ignorant about the legal affairs. That is the statement made in the applications. That appeals to be filed within 90 days.
Of law is not a good ground. You know that, Mr. Ghosh. That is said.
Well, what I have stated
we used to joke about that ignorance of law of the litigant is not a good ground, but ignorance of law of an advocate.
Well, I have stated that it was ignorant about the legal within 90 days appeal has to be filed. But the fact is, matter I have stated in paragraph 17 onwards, 18 also. That the actual fact is, the application of certificate copy decree on 19th May, and it was obtained on 3rd June. Your petitioner is ignorant about the legal affairs, but if it has to file register within the statutory period, your petitioner became disgruntled after knowing the fate of the matrimonial suit, when she all along sincere and dutiful in performing marital obligation, domestic duties. Your petitioner became mentally upset, which resulted serious nature of mental agony and depression. After recovery from such trouble, your petitioner made a contact with the learned advocate, who in turn handed over certificate of the judgment and decree on 6th December. Immediately, your petitioner contacted the learned advocate practicing with this honorable court, preferring the appeal. So after getting this, immediately after handing over the certificate copy, my lord. Learned trial court, my lord, handed over the certificate copy on 6th December, immediately on 11th. I preferred appeal, my lord, filed appeal before this honorable court. No, that is the candid statement I give.
No, Mr. Ghosh, this cannot be allowed. This is not a good ground. Period of delay is not important, but the quality of the grounds have to be.
Well, what fact has the real fact, but correct facts have been assigned in this application. I cannot make any incorrect facts. I asked her that what prevent you to prefer appeal. She told me that I have serious mental stress and tension
Much
because she
mental
has no
stress and
independent source of income.
Mental stress and tension. Did she have any treatment or any, as we asked the
No, for passing of the decree. My lord, only on the ground,
under such mental stress that she could not contact an advocate.
Advocate contract on 6 December.
But then
He handed over the
does
certificate copy.
Does she have any? Was she treated by a doctor during that
No,
period?
no,
for such
no,
mental
nothing,
stress?
nothing.
Then how do you accept that you were under such
Well,
mental
on the ground
you
that
suddenly went
he is
into
a-
no, you suddenly went into such mental shock after the decree, although you knew all along about the allegations, you contested the suit, you adduced evidence, you never suffered trauma.
Husband,
but only when the decree was passed, then you got shocked.
Husband failed to prove this. Only on the point that the husband sent a letter to the wife to bring her back. On that ground, decree was passed.
Ridiculous.
On that ground.
Sorry, we cannot
Schizophrenia, learned trial to disbelieve the story of schizophrenia.
Very
Only on the point that husband sent a letter to the wife.
You are arguing on the merits of the Ghosh, which you are not hearing.
Only
you are not hearing.
But should appreciate the
We cannot.
judgments delivered by the learned trial court. Only on the basis of that. They sent a letter
That's a
to her
qualitative
to bring
assessment.
her back.
Yes,
You did
we are
not return back. Only on that ground, the decree was passed by the learned
The
trial.
appeal has been filed after a delay of about 105 days. For sub next para, learned counsel appearing for the appellant wife submits that although the ex parte decree was passed,
Not expecting.
although the contested decree was passed, what was the date of the decree, Mr. Ghosh?
8 May 2025.
On May 8, 2025, comma, and an application for certified copies of the judgment and decree was made on May 19, 2025, comma, that is well within time, comma, which was obtained on June 3, 2025, comma, the petitioner was ignorant about legal affairs and did not know about the necessity to file an appeal within a statutory period. First up, more importantly, comma, it has been pleaded that the appellant stroke petitioner became disgruntled after knowing the fate of the matrimonial suit, after having performing her marital obligation and domestic duties all along dutifully, and was under severe mental stress, comma, for which the appeal could not be filed within time. Upon hearing learned counsel for the parties, comma, we find that no explanation worth the name has been furnished for the delay of about 105 days in preferring the appeal. Next para, it is well settled that the ground of mere ignorance of law of the litigant is not a good ground in respect of condonation applications. Next para, insofar as the allegation of the appellant being under severe stress is concerned, comma, we are also unable to accept such explanation. There is no cogent reason whatsoever made out in the application as to why the appellant, comma, all on a sudden after passing of a contested decree and having applied for the certified copies of the judgment of the same duly, comma, came under such severe mental stress that she could not contact a learned advocate for preferring an appeal. Next para, the appellant wife must have known from the very inception of the suit, comma, when a copy of the plaint was served on her about the nature of the allegations made against her. Even thereafter, comma, the defendant stroke appellant wife contested the suit fully by filing a written statement, comma, thereby controverting the allegations made in the plaint, and also underwent the rigmarole of evidence being adduced in the matrimonial suit. We notice that the appellant wife also participated in the evidence and as such, comma, throughout the said period was exposed to the nature of the allegations and the trauma which a person might suffer during the pendency of a matrimonial proceeding. Full stop. Next para. No special reason as to what occurred all on a sudden or what change of circumstances happened after the passing of the decree so as to increase the decibel level of the shock to such an extent that the appellant was crippled from contacting her advocate is not set forth in the application before us. Full stop. Next para. It is also well settled that more than the period of delay within bracket, although inordinate delays are generally not condoned bracket closed, comma, the quality of the reason furnished for the delay is to be noted by courts while considering applications for condonation of delay. Full stop. Since the appellant miserably fails to convince us on the sufficiency of the reasons for the uh, reasons, comma, as discussed above, comma, we are unable to condone the delay in preferring the appeal. Full stop. Accordingly, can 2 of 2025 is dismissed, thereby holding that the that FAT dismissed on contest without any order as to costs. Full stop. Next para. Consequentially, comma, FAT 550 of 2025 is dismissed as time barred, comma, thereby affirming the judgment and decree. There we affirmed dismissed as time barred. Full stop. Consequentially, can 1 of 2025 stands disposed of as well. No order as to cost. Urgency limit. প্রথমে অ্যাফিডেভিট অফ সার্ভিস ফাইল টু বি কেপ্ট অন রেকর্ড করে তারপরে এগুলো করো আর তার আগে ওইটা করে নিও তোমার ইয়েস
Item number 15.
My lord, not today.
Refused.
He is seriously ill.
Oh.
My Somnath Mukherjee, advocate on the court.
Say that. Say that as if you said as if you are dictating to your stenographer.
Lord, they were about to file the, my lord, the decree, my lord. For that reason, my lord, the hearing of the matter.
He is ill. What can be done?
Lord, if
who
he
is
has
the gentleman? The client or clerk? No. Who is the gentleman behind who is instructing? Client or clerk?
Advocate on the court.
No,
he is the advocate on record?
No, he's clerk.
Clerk. So please ask him whether the certified copy of the decree is ready. That was to be filed.
Already filed.
Fair. So let us come back. We'll take it up on Monday.
Lord, but the stamp reporter shows me it was not filed. Lord, for that reason, the matter has been.
We cannot record the clerk's submission. Let us see. We have apprised him sufficiently. An adjournment is sought on the ground of illness of learned counsel appearing for the appellant. Full stop. Next para. Learned counsel for the respondent points out that previously the certified copy of the decree was. Did you direct that?
Lord, your lordship directed them, Lord, to ascertain, Lord, to whether it has been filed or not.
That previously, comma, the appellant was directed to ascertain as to whether the copy of the certified copy of the decree has been filed. Full stop. Be that as it may, comma, in view of the prayer made, the matter is adjourned till March 23, 2026. Full stop. However, comma, it is made clear that in the event the appellant is unrepresented on the said date or any adjournment is prayed, comma, at adverse inference, ex parte orders may be passed in the absence of the appellant. What is the issue? Has been filed.
Number 15.
I am for the petitioner.
Yes.
There is a application for condonation of delay. There is a meager.
All appeared on the last time.
Yes, my lord. We have also served them. My lord. They are the caveat. We have also served.
Don't appear. What can be done? No. They took a point that it is time barred. You have filed a section 5.
I have filed a section 5. The copy has been served to them.
Copy also has been served.
Yes.
What is the delay?
21 days.
What is the ground?
ground I have mentioned, paragraph 3.
কোনো হয়নি থিতা এখনো তো হয়নি থিতা ও 4:24 you have a 3:30 today, so
Not today on.
all of you have to thank my learned brother for many things for saving you from me. No, we'll record an order since you are here. None appears for the respondent at the time of call, full stop. Accordingly, let the matter stand adjourned for the day, full stop. However, it is made clear that in the event the respondent is unrepresented on the next date, ex parte orders may be passed in his absence. But please give a notice to him also that we have passed such an order so that he is positively present on the next.
Item number 17.
17, my lord, I am for the petition appeal and my lord, led by Mr. Tanmoy Mukherjee, my lord.
This is appealing for the first time?
Yes, my lord. Yes,
Is there any
first time.
section 5?
No, my lord.
What is the appeal against?
Appeal against, my lord, first ex parte decree against the
Ex parte, what suit?
partition suit.
You have challenged the preliminary degree?
Preliminary decree as a final decree, my lord.
Final degree you have challenged?
Yes, my lord.
So let Mr. Mukherjee come. Very well. You want to move the matter?
No, my lord. Mr. Mukherjee will move the matter. My
No, we don't. You ask for time.
Yes, my lord. So,
Very well.
there is a defect, my lord, to supply the copy of the final decree and the.
So whatever you have got that?
Yes, my lord. I have got that and I deposit.
Final degree and commissioner's report.
Commissioner report, my lord.
Learned counsel for the appellant files certified copies of the final decree NIN, final decree and the commissioner's report, which are kept on record. Full stop. Next para. Accordingly, it is deemed that the defect in that regard in the appeal is cured. Full stop. However, an adjournment is sought by the appellants. Full stop. Accordingly, let the matter stand adjourned for the day. You have filed second judge's copies also?
Yes, my lord. I have.
Final decree.
Item number 18.
ওটা এখন হ্যাঁ আজ 3:30 তুমি এইগুলো মনে হচ্ছে আমাদের না দিয়ে ডাইরেক্ট আশরাফকে দিও আশরাফ বুঝতে পেরেছো সেদিন কটা ডিসপোজাল হয়েছে 7-8টা না অলরেডি গোটা 15 পেয়ে গেছি আমি না আমি জানি আর হবে না সেটা তোমার দেখো Will শুধু ওইটা রেকর্ড করে দিই none appears for the party at the time আর সঙ্গে yes you're moving sorry yes Mr. Halder yes both sides are there so we'll take up the matter.
So I appeared on behalf of led by Mohan Mukherjee.
Yes.
Oyan Banerjee.
What happened to him?
Led by Oyan Banerjee.
What happened to him?
Not present.
You are competent enough. Let us hear them. Yes. She wants to do the matter. Yes, Mr. Halder.
In a suit for declaration of title and partition, my lord, the abatement made in the plaint demonstrates that the plaintiff has no title over the property in question.
You are challenging the preliminary degree?
No, my lord, injunction, temporary injunction.
Injunction granted?
Injunction granted.
How dare you prefer an appeal against it? Partition suit injunction granted?
No, my lord. From the abatements made in the plaint, it appears that the plaintiff has no title over the declaration of title and partition, not simplicity of suit for partition. From the several
every partition suit is inbuilt.
If you also
Mr. Halder after so many years of practice.
If you also kindly have a look at the grounds of the if you also
they challenge any deed or anything else?
Yes, my lord.
What is?
They are claiming
declaration of title is inbuilt in a prayer for partition. If I pray for partition, that means declaration of title has to be.
Their claim is hit by the Benami Prohibition Transaction Act.
Why do you say that? Where can we find that? From the plaint, it is evident.
From the plaint, it is evident.
First. Which page?
Kindly have a look at page 12. Paragraph application.
Page 12, yes.
Paragraph 5. বাদী দীর্ঘদিন জমি কেনাবেচার ব্যবসায় যুক্ত থাকায় জমি বিভিন্ন ব্যক্তির জমি সন্ধান করে তাদের মধ্যে যোগাযোগ করেন ও জমি ক্রয়ের ব্যবস্থা করেন। খন্দান মৌজার 3555 হাল 3415 দাগে মালিক শৈলনাথ ব্যানার্জি জমি বিক্রয় করিতে ইচ্ছুক আছে জানিয়া বাদী এত তারিখে 1996 সালে ও 2000 সালে দলিল মূল্যে শৈলনাথ ব্যানার্জির নিকট হইতে 16.5 শতক সম্পত্তি খরিদ করেন। তারপর
Mr. Alder will take it up on the next day. Although the matter is called on for hearing, due to paucity of time, the same cannot be concluded. Husab, let the matter be listed next on March 23, 2026. Because tomorrow we take up the hearing matters. এটা তো কিন্তু ওই জিনিসটা থাকবে আগের অর্ডারটা কারেকশন প্রথমে দিয়ে তারপরে
March 23.
23rd March.
I'm led by Mr. Chaudhary.
I'm sorry, but I left actually, but
No, Mr. Banerjee is also not there, the other side. So we are just passing out time there.
no, I had to climb up, so it took some time.
No. We are not, I initially forgot there was a 3:30. My learned brother reminded me.